Welcome to English Podcast. In today's episode, we will understand an important concept from Indian polity in a simple and clear manner.
It's wonderful to be here. And honestly, calling it a concept is well, it's selling it short. We're about to explore the very DNA of the Indian state.
The DNA.
We're looking at the architectural blueprints of the world's largest democracy. It's huge.
That is a massive claim, but looking at the stack of research notes, articles, and historical documents we have on the table, I think it's justified. Our mission for this deep dive is to analyze the historical background of the Indian Constitution. And I have to admit, when most people, and I'll include myself in this here, history of the Constitution, our brains immediately jump to 1946.
Right. The Constituent Assembly.
Exactly. We picture the Constituent Assembly, Dr. Ambedkar in his suit, the debates, the drafting committee.
Which is the climax of the movie, really. But you can't understand the climax if you haven't watched the first 2 hours of the film. The modern Indian political system didn't just materialize out of thin air on Republic Day in 1950.
It wasn't magic.
It wasn't magic at all. It was evolution. The foundation was laid brick by brick, act by act, over nearly 2 centuries of British colonial rule.
So we're rewinding the clock way, way back. We're looking at a timeline that stretches from the year 1600, when the East India Company first arrived as traders, all the way to independence in 1947.
Precisely. And our source material, specifically the notes we had on Indian polity, divides this massive chunk of time into 2 very distinct eras. If you want to understand this history, you really have to understand this division.
Let's set the stage then. What are the 2 eras?
Okay, so the first era is what we call the company rule. This runs from roughly 1773 to 1858.
Right.
This is the period when the East India Company, which, let's remember, was a private trading corporation, was effectively the government of large parts of India.
Which even today is just a mind-boggling concept, a corporation running a country.
It is. And then the second era is the Crown Rule, spanning from 1858 right up to 1947.
And this is after the 1857 revolt.
Exactly. This is after the British government in London basically said enough and took direct control of the administration.
Okay. Before we jump into the year 1600, I want to play devil's advocate for a second. I know our listeners are curious people, but some might be asking, why does this matter? If I want to understand how Parliament works today, or how the civil services function, why do I need to care about a dusty old act from, say, 1773?
That is the most important question to ask. And the answer is that the administrative machinery we see in India today, the very skeleton of the state, was engineered during these centuries.
So it's not just trivia.
Not at all.
Yeah.
Do you wonder why we have a centralized administration? Or, why we have a portfolio system where one minister handles finance, another handles defense? Or why the civil services are structured the way they are?
I assume you're going to tell me it's all in these old documents.
It is. These acts are the source code. If you want to debug the current system or even just understand how it works, you have to read the original code.
Fair enough. Let's start at the beginning then. The year is 1600. Queen Elizabeth I grants a royal charter to a group of merchants, the East India Company. At this point, they aren't conquerors, right? They are just merchants.
Purely merchants. Their charter gave them exclusive rights to trade in the East Indies. They wanted pepper, spices, textiles.
The valuable stuff.
The really valuable stuff. For a long, long time, their only ambition was profit. But the turning point, the moment they shifted from being, let's say, shopkeepers to rulers, was in 1765.
And this is just after the Battle of Buxar in 1764.
Correct. The company won a decisive military victory. As a result, in 1765, they obtained the Diwani rights for Bengal, Bihar, and Odisha.
Diwani rights, that's a key term. Can we break that down a bit? What does that actually mean?
Think of it as the power of the purse. Diwani rights meant the right to collect revenue and administer civil justice.
So taxes.
Taxes and courts. Before this, they were trading goods. After 1765, they were collecting taxes from millions of people. They became the landlords.
That is a dangerous shift. You have a private company motivated by profit, suddenly holding sovereign power over a massive population, collecting taxes with no real rules or government oversight.
And the result was exactly what you'd expect: chaos. Between 1765 and 1773, the company servants, the employees on the ground, became fabulously wealthy.
How?
Through private trade, extortion, taking gifts. They were returning to England as nabobs, a corruption of nabob, and flaunting their immense wealth. Meanwhile, the East India Company itself was nearly bankrupt.
Wait, how does that work? The employees are rich, but the company is broke.
Because of the costs of constant warfare and just, well, sheer mismanagement. The company was bleeding money while its officers were lining their own pockets.
So the British government back in London must have been watching this with some alarm.
Alarm is an understatement. They saw this private company creating a massive, unstable territory, and they realized they couldn't just let this corporation run wild anymore. They needed to step in. And that brings us to our first major constitutional landmark, the Regulating Act of 1773.
The name is very literal, isn't it? Regulating.
It was the first step. The British government basically said, we are going to control and regulate the affairs of the East India Company. It's so significant for constitutional history because it recognized for the first time that the company had political and administrative functions, not just commercial ones.
So how did they try to fix this mess? What were the key features?
Well, the first big move was to centralize power. Before 1773, the British had three main bases, or presidencies, Bengal, Bombay, and Madras. Each had its own governor.
And they were all equal.
Exactly. They were independent of each other.
Yeah.
The governor of Bombay didn't have to listen to the governor of Bengal. It was like three separate franchises operating on their own.
Okay.
The Regulating Act changed that. It promoted the governor of Bengal to the governor general of Bengal. It was a new, superior title. The first man to hold this title was Lord Warren Hastings.
A famous name. And what happened to the governors of Bombay and Madras? Did they get demoted?
You can say that. They were made subordinate to the Governor General of Bengal. This is the seed, the very beginning of central administration in India. The power started flowing toward one point, Calcutta.
Now, a man with that much power needs help. Or perhaps a check on his power.
Right. And the act knew that, so it created an executive council of 4 members to assist him. But here's the catch. The Governor General didn't have a veto. He could be outvoted by his own council.
Ah, so that would cause some problems down the line, I imagine.
Huge problems. But it wasn't just about the executive. The act also established a Supreme Court in Calcutta.
This was set up a year later, in 1774.
Yes, 1 Chief Justice and 3 other judges. It was meant to bring some semblance of British legal order to the chaos.
And what about the corruption? The nabobs?
The act tried to tackle that head-on. It strictly prohibited company servants from engaging in any private trade or accepting presents or bribes from the natives.
I love that they had to make a law saying no bribes. It really highlights how rampant the corruption must have been.
It was institutionalized looting. But here's the thing about the Regulating Act of 1773. It was a first draft. And like most first drafts, it had a lot of holes in it.
Which leads us to the next piece of legislation I see here. The Act of Settlement in 1781. Was this a patch to fix the bugs in the 1773 Act?
That's a perfect way to describe it. It was a bug fix. The 1773 Act created a Governor General and a Supreme Court, but it was really unclear who was more powerful.
A power struggle.
A huge one. You had situations where the court was trying to drag the Governor General's officials to trial for things they did in their official capacity, and the Governor General was refusing to acknowledge the court's authority. It was a turf war.
So how did the Act of Settlement fix this?
It drew a line in the sand. It exempted the Governor General and his council from the jurisdiction of the Supreme Court for acts done in their official capacity.
So immunity for their job-related decisions.
Basically, yes.
Yeah.
The executive got immunity. It also, crucially, removed revenue matters and anything related to revenue collection from the court's jurisdiction.
So if the company is squeezing the peasants for taxes, the Supreme Court can't intervene.
Precisely. It secured the most important thing for the company, the revenue stream. It did, however, lay down a very interesting rule for the court.
What's that?
For personal cases between Indians, the court had to apply the personal laws of the defendant. So, Hindu law for Hindus, and Mohammedan law for Muslims.
That's a precedent that echoes even today in our personal laws. Okay, so they've patched the leaks, but the British government clearly wanted more control, not less. This leads us to the Pitt's India Act of 1784.
Right, named after the British Prime Minister at the time, William Pitt the Younger. This is a crucial act because it created a system of double government.
Double government. That sounds complicated. How do they split the brain of the company?
They looked at the East India Company and said, look, you are a merchant, but you are also a ruler. We need to separate these two jobs.
Okay.
So they allowed the Court of Directors, the company's own elected board, to continue managing commercial affairs. Trade, shipping, the business side of things.
And the political stuff, the ruling part.
For political affairs, that's civil administration, military revenue. They created a completely new body in London called the Board of Control.
And this board wasn't made of company men.
No, it was a British government body. the Chancellor of the Exchequer, a Secretary of State, and 4 privy councillors. This was the government stepping in directly.
So the company makes the money, but the British government pulls the political strings.
Correct. The Board of Control could supervise and direct all operations of the civil and military government. This act is historically significant for 2 big reasons. One, it established the supreme control of the British government over company affairs. The leash was now very tight.
And the second reason?
For the first time, the company's territories in India were officially called the British Possessions in India.
They were claiming ownership.
Explicitly. No more ambiguity.
Before we leave the 18th century, there's a small, almost personality-driven act in 1786. I'm calling it the Cornwallis exception.
Oh, yes. Lord Cornwallis. He was a major British aristocrat, the same general who was surrendered at Yorktown in the American Revolution. He's a big deal.
And they wanted him to be the next governor general?
They did. But he saw the gridlock Warren Hastings had faced with his council, being outvoted all the time. So Cornwallis, being a man of high status, refused to take the job unless his demands were met.
A bit of a diva moment.
You could say that. But he had a point. He made 2 demands. First, he wanted the power to override the decision of his council in special cases. He wanted the final say.
I am the decider.
Exactly. And his second demand was to also be the commander-in-chief. He wanted control of the army as well as the administration.
And they agreed.
They were so desperate to have him that the Act of 1786 was passed just to say yes to both of his demands.
So we move into the 19th century. The sources describe this next phase, from about 1813 to 1853, as peak centralization. Let's start with the Charter Act of 1813. What's the context here?
The world was changing by 1813. The Industrial Revolution was in full swing in England. British manufacturers were producing cheap cotton goods and other products, and they were angry.
Angry about what?
Angry that the East India Company had a complete monopoly on the massive Indian market. They wanted in. They lobbied Parliament heavily.
So the Act of 1813 broke the monopoly.
It did. It ended the trade monopoly of the East India Company in India. The gates were thrown open to all British merchants.
With a few exceptions I see in the notes.
Yes, a couple of big ones. They let the company keep its monopoly on 2 things: trade in tea and trade with China. Those were still the big money makers at the time.
The 1813 Act also marks a bit of a cultural shift, doesn't it? It's not just about trade.
That's a very important point. It asserted the sovereignty of the British Crown over the company's territories, which was a clear political statement. But it also, for the first time, allowed Christian missionaries to come to India for the purpose of enlightening the people.
And education.
And, significantly, it provided for the spread of Western education among the inhabitants of the British territories. It allotted a sum of money for it. This is the root of the English education system in India.
A system with a very long and complicated legacy. Okay, but if 1813 opened the door to free trade, the next big one, the Charter Act of 1833, seems to slam the door on the company's commercial identity entirely. The notes call this the final step of centralization.
1833 is the high watermark of imperial centralization. It is a massive act. Remember the title Governor General of Bengal?
Yes, from 1773.
The 1833 Act changed that designation to Governor General of India.
That is a huge shift in language, not just of Bengal, but of India. It implies authority over the entire subcontinent.
It does, and the powers match the title. The act vested in him all civil and military powers. The first person to hold this grand title was Lord William Bentinck.
So what did this mean for the other provinces? For Bombay and Madras?
They were effectively neutered, legislatively speaking. The act deprived the governors of Bombay and Madras of their legislative powers. They couldn't make laws anymore.
So who made the laws?
The Governor General of India. He and his council were given exclusive legislative power for the entire British India. The laws made under previous acts were called regulations. Laws made under this act were called acts.
One government making laws for everyone.
A total concentration of power in Calcutta. And as for the East India Company itself, the act ended its activities as a commercial body. It became a purely administrative body.
The shopkeepers were officially gone.
Gone. It now held the territories in trust for His Majesty, his heirs and successors. Only the bureaucrats remained.
There is an interesting what-if moment in the 1833 Act, something that was proposed but didn't happen, regarding civil servants.
Yes. The act attempted to introduce a system of open competition for the selection of civil servants. The language was quite progressive for its time. It stated that Indians should not be debarred from holding any place, office, or employment under the company.
But there's always a but.
But the court of directors, the old guard of the company who still had influence, they opposed it tooth and nail. They didn't want to lose their power of patronage, the ability to appoint their own friends and family. So the provision was negated.
The door remained closed to Indians for a little while longer, until the Charter Act of 1853, I believe.
The last of the series of charter acts. And yes, this time, they finally got it through. The 1853 Act introduced an open competition system for the selection and recruitment of civil servants.
So what did that mean in practice?
The Macaulay Committee was appointed in 1854, and the covenanted civil service was thrown open to Indians as well. It was a massive, massive change.
A true watershed moment. But structurally, the 1853 Act also did something fascinating. Your notes mention it created a mini parliament. What does that mean?
This is a subtle but absolutely critical evolution. For the very first time, the Act separated the legislative and executive functions of the Governor General's Council.
So one team for doing things, and a specialized team for making the laws.
Exactly. Before this, the same council did both. Now they added 6 new members called legislative councilors to the council. This created a separate body known as the Indian Central Legislative Council.
And it acted like a parliament.
It functioned like a small version of the British Parliament. It adopted the same procedures. There were questions, discussions, debates. It was a proto-parliament.
And it says here that 1853 also introduced local representation in this council. That sounds progressive.
Yeah, it does, but we have to be careful. Of the 6 new legislative members, 4 were appointed by the provincial governments of Madras, Bombay, Bengal, and Agra.
Okay.
But these were still British officials representing those areas, not Indians elected by the people. Still, it was the first time the center officially acknowledged that local, provincial voices needed to be heard in the central lawmaking process.
So by 1853, we had this highly centralized government, a nascent parliament, and a professional civil service open to Indians. It all looks kind of stable. But then 1857 happens.
The Great Revolt, the Sepoy Mutiny, the First War of Independence, whatever you choose to call it. It shook the foundations of the British Empire in India to its very core.
And that brings the curtain down on the company. The nearly 100-year experiment of a corporation running a country was officially over.
Absolutely. We are now entering the second major era of our timeline, the Crown Rule, from 1858 to 1947.
So what was the immediate reaction from London?
The British government looked at the sheer devastation of 1857 and decided the East India Company was too much of a liability. It had to go. The first major act passed was the Government of India Act of 1858.
And it had a very high-minded title, I see, an act for the good government of India.
Yes, good government. I'm sure the Indian subjects who had just been brutally suppressed found that very reassuring. But legally, what did it do?
It was a complete transfer of power.
It was liquidation. The East India Company was abolished. All its powers, territories, revenues, everything was transferred directly to the British Crown.
And the title of the man at the top, the Governor General,
that changed again. He was now to be known as the Viceroy of India.
We often hear these terms used interchangeably, Governor General and Viceroy. But what is the technical difference?
Viceroy literally means in place of the king. He was the direct personal representative of the British Crown in India. Lord Canning, who was the Governor General during the revolt, stayed on to become the first Viceroy.
And what happened to that complex double government system, the Board of Control versus the Court of Directors?
Scrapped. Both were abolished, completely gone. Instead, they created a new, extremely powerful office, the Secretary of State for India.
Now, this is a crucial position to understand. The Secretary of State wasn't sitting in Calcutta or Delhi, right? He was back in London.
Yes. He was a member of the British cabinet, and he was responsible ultimately to the British Parliament. But he was vested with complete authority and control over the Indian administration. He was the puppet master in London. The Viceroy in India was the manager on the ground.
And did the Secretary of State have a team?
Yes, a 15-member Council of India was established to assist him, but they were almost entirely an advisory body. The Secretary of State was the chairman and held the real power.
So 1858 marks the point of total, direct control from London. But I imagine trying to rule a subcontinent from an office in Whitehall is difficult. They must have realized they couldn't govern without some local cooperation.
Exactly. The lesson of 1857 was that you cannot govern hundreds of millions of people without listening to them at all. That realization leads directly to the Indian Councils Act of 1861.
This act is pivotal because it brings Indians into the room, so to speak, doesn't it?
For the first time, yes. It initiated the process of associating Indians with the lawmaking process. The Viceroy was given the power to nominate some Indians as non-official members of his expanded legislative council.
So who were the first ones to get this invitation?
In 1862, Lord Canning nominated 3 individuals: the Rajah of Benares, the Maharaja of Patiala, and Sir Dinka Rao.
So royalty and landed gentry, not exactly the common man.
Not at all. These were very safe, conservative, loyal choices. And we should be clear, they had very little actual power. They couldn't really question the budget or the administration in any meaningful way. But symbolically, it was a start. The door had cracked open. Just a little.
The 1861 Act also seems to have reversed that trend of centralization we talked so much about earlier.
Yes, this is a key policy shift. Remember the Charter Act of 1833, when Bombay and Madras were stripped of their legislative powers?
Right.
The 1861 Act gave those powers back. It initiated a process of legislative decentralization that would eventually, decades later, lead to the provincial autonomy we see in the 20th century.
It also gave formal recognition to something called the portfolio system.
Yes, which had actually been introduced informally by Lord Canning in 1859. This is literally how our cabinet government runs today.
So what was it?
Before this, the Viceroy's Council functioned like a committee. Everyone looked at every file. It was incredibly inefficient. Canning said, "This is silly." He made each member of the council in charge of a specific department: home, finance, defense, and authorized them to issue final orders on behalf of the council.
Much more efficient. The act also gave the viceroy a specific emergency power.
Yes, the power to issue ordinances. He could do this without the concurrence of the Legislative Council during an emergency. And these ordinances had a life of 6 months.
A power that still exists in the Indian Constitution today for the president and governors.
Absolutely, the lineage is direct.
Okay, let's fast forward 30 years to the Indian Councils Act of 1892. It seems like the British were slowly, very slowly, loosening the grip.
Very slowly is the key phrase.
Yeah.
The Indian National Congress had been formed in 1885, and there was growing pressure for more representation and more power. The 1892 Act was a concession. It increased the number of non-official members in both the central and provincial legislative councils.
But more importantly, it expanded their functions, right?
Yes. For the first time, the councils were given the power to discuss the budget, and they could address questions to the executive. Before this, the money was a secret garden, off limits to them.
The notes mention a tricky bit about elections here.
Yeah, this is interesting. The British were allergic to the word election at this stage. The Act of 1892 never uses the word but.
But
It made a provision for filling some of the non-official seats through nomination on the recommendation of certain bodies,
like who?
like provincial councils recommending members for the central council, or universities, municipalities, zamindars, and chambers of commerce recommending members for the provincial councils.
So if the University of Calcutta recommended Mr. X, the viceroy would likely nominate him.
That was the idea. It was election by the back door, a very limited, indirect form of election.
Now we arrive at a very significant and deeply controversial milestone. The Indian Councils Act of 1909, also known as the Morley-Minto Reforms.
Named after the Secretary of State, Lord Morley, and the Viceroy, Lord Minto. Structurally, on the surface, it looked like more progress. They increased the size of the legislative councils considerably. The Central Legislative Council went from 16 members to 60.
And they allowed a non-official majority in the provincial councils for the first time.
Yes, though they were careful to retain the official majority at the center. They also widened the deliberative functions. Members could now ask supplementary questions and move resolutions on the budget.
And this is where we see the first Indian being appointed to the Viceroy's Executive Council, the Inner Circle.
Yes, Satyendra Prasad Singha. He was appointed as the law member. This was huge. He wasn't just in the talking shop of the legislative body. He was in the executive inner circle where decisions were made.
But the 1909 Act is almost always remembered for something else, something much darker.
You're referring, of course, to the introduction of the communal electorate.
Can you explain what that means?
The Act introduced a system of separate electorates, specifically for Muslims. This meant that Muslim members were to be elected only by Muslim voters.
So a specific community gets its own separate pool of voters and candidates.
Yes. It institutionalized the idea that the political interests of Hindus and Muslims were separate and distinct, and that a Muslim leader could only represent Muslims and a Hindu could only represent Hindus. It basically legalized communalism in the political sphere.
And Lord Minto is known for this.
He came to be known as the father of communal electorate. It's a very dark legacy. It planted the seeds of separatism that would eventually, tear the country apart in 1947.
It broke the idea of a common national electorate before it could even fully form.
Precisely.
Okay, let's move to part 4 of our timeline. Toward responsible government from 1919 to 1947, the language itself starts changing here. The British stop acting like permanent rulers and start talking about responsibility.
Right. The political climate in India was heating up. The Home Rule movement was very active. World War I had changed the global perspective on self-determination. So in August 1917, the British government made a famous declaration.
The Montague Declaration.
Yes. They declared that their objective was the gradual introduction of responsible government in India.
Which led directly to the Government of India Act of 1919, or the Montagu-Chelmsford reforms. And the big innovation here is a word I always struggle with: diarchy.
Diarchy. It comes from the Greek word diarch, which means double rule. It was a very complicated constitutional experiment that was introduced in the provinces, not at the center.
Okay, so how does a double rule actually work?
Imagine you are the governor of a province. You have a list of subjects you need to administer: health, education, police, etc.
Yeah.
They split that list into two. One list was called reserved subjects.
And what was on that list?
The important stuff. The power subjects: law and order, finance, land revenue, justice. The governor administered these with his executive council, and they were not responsible to the legislative council. They answered only to him.
And the second list?
That was the transferred subjects, things like education, health, agriculture, local government. The governor administered these with the aid of ministers, Indian ministers, who were responsible to the legislative council.
So in essence, the British said, you guys can run the schools and the hospitals, but we will keep control of the police and the money.
That's a perfect summary. And as the notes say, the experiment was largely unsuccessful. It created constant friction. A minister for health wants to build a new hospital, a transferred subject. But the finance member, a reserved subject, refuses to release the funds. It was designed for gridlock.
Well, the 1919 Act did give us bicameralism at the center for the first time.
Yes. It replaced the single Indian Legislative Council with a bicameral legislature, an upper house, the Council of State, and a lower house, the Legislative Assembly. And for the first time, direct elections were introduced for the majority of members in both houses.
It also extended that principle of communal representation.
It did. It provided separate electors not just for Muslims, but also for Sikhs, Indian Christians, Anglo-Indians, and Europeans.
The act also set a timer on itself. It said, we'll send a statutory commission in 10 years to see how all this is working.
Which brings us to the Simon Commission, appointed in 1927. So they actually jumped the gun and appointed it 2 years ahead of schedule, 7 members, led by Sir John Simon.
And the problem wasn't the timing, it was the membership.
It was an all-white commission. They were sending a group of 7 British men to come and judge the fitness of India for further self-government, but they didn't include a single Indian in the jury.
Naturally, the reaction in India was furious. Simon, go back.
All parties boycotted it. But interestingly, the commission did its work and submitted a report in 1930. And it actually made some far-reaching recommendations.
Such as?
It recommended abolishing that messy diarchy system. It proposed extending responsible government in the provinces and establishing a federation of British India and the princely states.
So these recommendations eventually fed into the next big act. But before that, we have to touch on the Communal Award of 1932. This feels like a sequel to the 1909 separate electorates.
It was an expansion pack. The British Prime Minister, Ramsay MacDonald, announced that separate electorates wouldn't just be for the religious minorities anymore. They would now be extended to the depressed classes, what we today call the scheduled castes.
And this is where Mahatma Gandhi drew the line.
Absolutely. Gandhi saw this as a cynical British ploy to divide Hindu society itself, to create a permanent fracture. He was in Yeravada jail at the time, and he undertook a fast unto death to protest it.
Incredibly high stakes.
Extremely. It created immense pressure and led to negotiations between the leaders of the Congress and the depressed classes, led by Dr. Ambedkar. The result was the Pune Pact.
And what was the compromise?
The compromise was this. The idea of a separate electorate for the depressed classes was dropped, so everyone would vote together in a joint electorate. But in return, a significant number of seats in the provincial legislatures would be reserved for the depressed classes.
Which is the basis of the reservation system in politics we have to this day.
It is. The Pune Pact is the direct origin of reserved constituencies.
Now, we finally arrive at the behemoth, the Government of India Act of 1935. The notes call this a milestone and a heavy lifter.
Milestone is an understatement. This act was a monster, an incredibly long and detailed document, 321 sections and 10 schedules. It was the longest act the British Parliament had ever passed at that time.
Why was it so big? What was it trying to build?
It was trying to build a completely new constitutional structure for India, an all-India federation. It proposed uniting the British Indian provinces and the princely states into a single political unit.
A united India, on paper. And how did it propose to divide the power between the center and the provinces?
This should sound very familiar to anyone who knows the Indian Constitution. It divided the legislative powers between the center and the units into three distinct lists: the federal list for the center, the provincial list for the provinces, and the concurrent list for subjects where both could legislate.
That is exactly what is in Schedule Cyan of our Constitution today.
Exactly. It also gave the residuary powers, that is, the power to legislate on anything not on the lists, to the viceroy. Today, those powers go to the parliament, but the three-list structure is identical.
But the notes say this Grand Federation never actually happened.
The blueprint was there, but the tenants never moved in. The princely states refused to join. They were afraid of losing their sovereignty and autonomy to a powerful federal center, so the federal part of the act remained on paper.
But the provincial part did happen.
Yes, and this was a huge step forward. The act introduced provincial autonomy. It completely abolished diarchy in the provinces, no more reserved versus transferred subjects. The provinces were now treated as autonomous units of administration.
So real responsible government in the provinces.
It was. The governor was now required to act with the advice of ministers who were responsible to the provincial legislature. This was implemented in 1937, and Congress formed ministries in several provinces. It only lasted until 1939 when World War II broke out and the ministries resigned. But it was a crucial experience in self-governance.
The 1935 Act also gave us some institutions that are household names today.
Absolutely. It provided for the establishment of the Reserve Bank of India, RBI, to control the country's currency and credit. It established not just a Federal Public Service Commission, but also provincial and joint public service commissions.
And the federal court.
Yes, the federal court, which was set up in 1937 and is the direct precursor to the Supreme Court of India.
It's just incredible how much of the 1935 Act is basically modern India's administrative structure.
That's the provocative thought we really need to sit with. A massive, massive chunk of the 1950 Constitution, some scholars say as much as 75% of the structural details, is directly derived or adapted from that British Act of 1935.
That is a sobering statistic. Okay, let's move to the final chapter. Independence, 1947.
The pace accelerates dramatically here. World War II is over. The British are exhausted, economically and politically. On February 20, 1947, the British Prime Minister, Clement Attlee, makes a historic declaration.
Which was?
That British rule in India would end by June 30, 1948 at the latest.
But history moved faster than that.
Much faster. The Muslim League, led by Jinnah, was demanding partition. Communal violence was spreading like wildfire. The last viceroy, Lord Mountbatten, arrived and quickly concluded that a united India was impossible. He put forward the Mountbatten Plan on June 3, 1947.
And the plan was partition.
The plan was partition. It was accepted reluctantly by both the Congress and the Muslim League.
So the Indian Independence Act of 1947 was quickly enacted by the British Parliament to make this happen.
Yes. This act did the legal heavy lifting. It declared India an independent and sovereign state from August 15, 1947. But, and this is a key legal point, it created two independent dominions, India and Pakistan.
Why dominions and not just republics?
Because we didn't have our own head of state yet. We didn't have a new constitution. Dominion was a transitional status. It meant we were independent nations, but technically still part of the British Commonwealth, acknowledging the king as the symbolic head until we wrote our own rules and became republics.
So the office of the viceroy was abolished.
Yes. And a governor-general was established for each dominion to be appointed by the British king on the advice of the dominion's cabinet. India, famously, asked Lord Mountbatten to stay on as the first governor-general of the new Dominion of India.
And the constituent assemblies of the two new countries.
They became fully sovereign bodies. The act empowered them to frame any constitution they wished and to repeal any act of the British Parliament, including the Independence Act itself.
There was one very dangerous provision in this act, though, the lapse of paramountcy.
This was the ticking time bomb. The act proclaimed that British paramountcy over the hundreds of princely states was over. All treaties with them ended. The states were now legal or free to join India, join Pakistan, or, and this was the great danger, remain independent.
Imagine a map of India with 565 independent holes in it.
That was the risk, a complete balkanization of the subcontinent, which is why the integration work done later by Sardar Patel was so absolutely critical.
The act also said that until the new constitutions were framed, governance would continue under which law?
The Government of India Act of 1935. They didn't have a new constitution ready on August 15th, so they just kept using the 1935 rulebook, modified as needed, for the transition period.
Before we wrap up, I want to touch on the transition teams mentioned in our sources. The interim government of 1946. This was before official independence.
Right. After the elections to the Constituent Assembly, an interim government was formed. The members were essentially the Viceroy's Executive Council. Jawaharlal Nehru was the vice president of the council, with the Viceroy as president.
Some of the portfolios are fascinating. We know Sardar Patel had Home and Information and Broadcasting. Dr. Rajendra Prasad had Food and Agriculture.
And here is a historical nuance that's often forgotten. The Muslim League initially stayed out, but then joined. Liaquat Ali Khan, who would become Pakistan's first PM, held the powerful finance portfolio in this interim government.
That must have been a very tense cabinet meeting.
You can only imagine. Then, after independence, we get the first cabinet of Free India in 1947.
Let's run through a few of those key names. It's a who's who of Indian history.
Jawaharlal Nehru, naturally, was prime minister and also handled external affairs and scientific research. Sardar Patel took home and states, which was crucial for integrating the princely states.
Dr. B.R. Ambedkar, the architect of the Constitution, was the law minister.
A brilliant choice. Sardar Baldev Singh was the defense minister. R.K. Shyamakum Chetty was the first finance minister of Free India.
And Rajkumari Amrit Kaur, the only woman in the cabinet, held the health portfolio.
Yes, and it was a broad-based cabinet. It included people who weren't from the Congress Party, like Dr. Sharama Prasad Mukherjee, who was from the Hindu Mahasabha, and held the Industries and Supplies portfolio.
A real cabinet of national unity for a moment of crisis and creation.
Exactly.
So here we are. We have traveled from Queen Elizabeth's charter in 1600 all the way to Nehru's cabinet in 1947.
It's quite a journey. We went from a trading company seeking profit to a centralized autocracy, then through a slow process of decentralization, and finally to the doorstep of a representative democracy.
It really highlights that history isn't just a list of dates. It's an evolution of ideas and structures.
Absolutely. When we look at the Indian Constitution today, we aren't just looking at a document written between 1946 and 1949. We are looking at the culmination of the Regulating Act, the Charter Acts, the struggles against diarchy, and of course, the massive federal structure of 1935.
The Public Service Commission, the judiciary, the parliamentary system, these are all legacies of this long history.
They are the bedrock. The British rule ended on August 15, 1947, but the administrative structure they built remained. In many ways, we just changed the driver. We didn't swap out the car.
So here's a thought to leave our listeners with. We talked about how much of our Constitution is directly derived from the Government of India Act of 1935.
Indeed. An enormous amount.
Does knowing this change how you view the indigenous nature of the Constitution? Is it a British document that was adapted for India, or is it a truly Indian document that was just built using some British bricks?
That is a question worth pondering. There's no easy answer.
Thanks for joining us on this deep dive into history.
Thank you. It was a pleasure. Keep learning. Moving ahead, let us understand the next important point. From an examination perspective, this point is significant. Okay, let's just pause right there. That sounded incredibly dry and honestly a little intimidating.
It did. It sounds like the start of a very long, very grueling lecture.
Exactly.
Yeah.
And while that intro might sound like something you'd want to skip, what we are actually about to do is, well, decode the DNA of the world's largest democracy.
It's a pretty stark pivot from examination point to decoding DNA, but you're absolutely right. We're not here to, memorize article numbers or dates for a quiz.
No.
We're looking at the operating system of a nation. We're trying to figure out how a single document manages to hold together over 1 billion people, arguably the most diverse population on the planet, without the whole thing just collapsing into chaos.
Yes, that's the mission. We're diving deep into the making and the salient features of the Indian Constitution. And look, I get the perception. The Constitution, isn't that just some massive, dusty rule book? But the sources we have today, these really detailed texts on Indian polity, they paint a picture of something much more dramatic. It's a story of, political conflict, of ransacking the world for ideas, and of creating something that critics at the time cynically called a paradise for lawyers.
It really is a fascinating origin story. Our mission here is to understand how a document drafted over 70 years ago manages to stay relevant in the age of the internet and AI. We've got sources detailing the timeline, the architectural blueprint, and even the fierce, sometimes really colorful criticisms leveled against the founders.
So where do we even begin with something this massive?
Well, you have to go back to the inception, to the very first spark of the idea.
And I was genuinely surprised by the timeline here. I usually associate the Constitution with 1947 and independence, or, maybe 1950 when it was enacted. But our sources point out that the seed was planted way, way back in 1934,
It was.
and not by the people I expected.
That's a very common misconception. I think most people assume it was Gandhi or maybe Nehru who first articulated the specific demand for a constituent assembly,
Right.
but it was actually M.N. Roy.
The pioneer of the communist movement in India.
Precisely. It's just fascinating that the initial push for this supreme democratic document came from the radical left. It wasn't until a year later, in 1935, that the Indian National Congress officially adopted the demand.
But the real line in the sand moment, the moment the demand sort of grew up into a geopolitical challenge, that was 1938, wasn't it?
That's the one. That's when Jawaharlal Nehru stepped up. And looking at the text, he wasn't just asking for a constitution. He was setting terms. He demanded it be framed by an assembly elected on adult franchise, and this is the kicker, without outside interference.
Without outside interference. That's a powerful phrase.
Oh, it's crucial. He was effectively telling the British Empire, we don't want a gift. We don't want a charter handed down from London.
We're not your project anymore.
Exactly. We want to write our own destiny. He was asserting sovereignty before they even had independence. It was a complete rejection of that dominion status mindset where the British Parliament would still have the final say.
And of course, the British initially just ignored this. But then history intervened.
World War II.
Suddenly, the empire needed friends.
Necessity is indeed the mother of concession. So in 1940, you get the August Offer, where the British accepted the demand in principle, mostly to secure Indian cooperation for the war effort.
Right.
Then in 1942, Sir Stafford Cripps came over with a draft proposal. But that fell apart completely.
It just crashed and burned. And that was because of the Muslim League, right?
Correct. The Muslim League flat out rejected the Cripps proposal because they had a totally different vision. They didn't want one constitution for a united India.
They wanted to.
They wanted India divided into two autonomous states with two separate constituent assemblies. They were already looking towards the creation of Pakistan. So you just had this massive political deadlock. Nothing could move forward.
So how did they finally get everyone into the same room to write this thing? Or at least try to?
It took until 1946 and the Cabinet Mission Plan. Now, this plan was clever. It rejected the idea of two separate assemblies, which kept the British and the Congress happy. But it offered enough autonomy to the provinces to temporarily sort of satisfy the Muslim League.
A temporary truce.
A very fragile one, but it worked. So in November 1946, the Constituent Assembly was finally constituted.
And let's look at the composition of this room, because the numbers themselves tell a story. The plan was for 389 seats total.
Right.
You had 296 for what was then British India and 93 for the princely states. Elections happened in the summer of 46. The Congress, as expected, swept it with 208 seats. The Muslim League got 73.
And here's where the drama really kicks in again. The princely states, they initially decided to just stay away.
They didn't even fill their seats.
Nope. Those 93 seats were empty. They were still hoping to, remain independent monarchies after the British left. And even worse, despite that earlier agreement, the Muslim League boycotted the first meeting on December 9th, 1946. They insisted on their demand for Pakistan.
Wow. That image is just striking. You fought for this assembly for over a decade. You finally walk into the Constitution Hall in Delhi, and it's half empty.
It must have been incredibly tense. Only 211 members attended that first meeting. The uncertainty was palpable. Would the country even hold together? Would this whole project just collapse before it began?
But they decided to press on anyway.
They made a strategic decision to move forward. Following French practice, they elected the oldest member, Dr. Sachidananda Sinha, as the temporary president to just get the proceedings started. A few days later, Dr. Rajendra Prasad was elected as the permanent president.
And here's a little nugget from the notes that I've never seen in a general history book. There were actually two vice presidents.
It's a unique detail, isn't it? H.C. Mukherjee and V.T. Krishnamachari.
Why two?
It shows the attempt to balance representation right from the top. H.C. Mukherjee represented the Christian community and other minorities, while V.T. Krishnamachari was chosen to represent the princely states, once they eventually decided to join, of course.
So it was a signal.
A clear signal that this wasn't just a Congress Party meeting. This was intended to be an all-India gathering. It was an exercise in consensus building from the very top.
But the real ideological foundation, the soul of the document, was laid just a few days later, on December 13th, 1946. That's when Nehru moved the Objectives Resolution.
A landmark moment.
Now, is this the famous Tryst with Destiny speech?
That's a common confusion, but no. Tryst with Destiny was on the eve of independence, August 1947. The Objectives Resolution was 8 months earlier, in December 1946.
Okay.
Think of the Objectives Resolution as the architect's vision statement before a single blueprint was drawn. It declared India as an independent sovereign republic and promised fundamental things like justice, equality, and freedom to all its citizens.
So this was the mission statement for the whole endeavor.
Exactly. And this resolution, which was adopted unanimously in January 1947, eventually morphed into what we now know as the preamble of the Constitution. It was the philosophical soul. It basically told the drafters, this is the destination. Now you write the map to get us there.
So they have the philosophy, now they need the text. And this brings us to one of the most visible and most criticized features of the Indian Constitution.
Yeah.
Its sheer size. I mean, critics at the time joked about it being elephantine.
It's a fair description, honestly. One member of the Assembly, H.V. Kamath, even commented that the emblem chosen for the Assembly, an elephant, was accidentally very appropriate.
Because it's just huge. The source compares it to the U.S. Constitution.
Yep.
The U.S. Constitution has 7 articles.
7.
That's it. The original Indian Constitution in 1949 had 395 articles and 8 schedules, and now it's ballooned to roughly 470 articles and 12 schedules. Why? Why did they need so many words to run a country?
It's not just, verbosity for the sake of it. There are real structural reasons. First, you have to consider the geography and the demography.
For sheer diversity.
Immense diversity. You're dealing with a subcontinent-sized country with every major religion, hundreds of languages, countless cultures. You can't just have broad, sweeping principles. You need specific protections for minorities, for backward classes, for different regions. If you leave it vague, it just creates conflict down the road.
Plus, there's the fact that unlike the U.S., we don't have separate constitutions for the states, right?
Exactly. Yeah. That's a major, major factor. In the U.S., you have the short federal constitution, and then each state has its own detailed constitution to handle local matters. In India, this one single document has to cover the political structure of the center and the diverse structures of all the states.
So everything is in there.
Everything. It defines the high courts, the powers of the governors, the public service commissions for the states. All of it is in one book. Except, of course, for the historical exception of Jammu and Kashmir, which our sources note was fully integrated in 2019.
But there's another reason, one often cited by critics.
Yeah.
The dominance of legal experts in the assembly.
The lawyer's paradise.
That sounds like a terrible vacation spot.
Indeed. Sir Ivor Jennings, a British constitutional expert, coined that phrase. The argument was that the document is so complex, so filled with legalese, that it would lead to endless litigation.
And was he right?
To be fair, she wasn't entirely wrong. But you have to understand the mindset of the drafters. They were transitioning from a colonial regime where rules were arbitrary. They were deeply suspicious of power.
They didn't want to leave any loopholes.
Exactly. They didn't want to leave things to convention or good faith. They wanted it all written down in black and white to prevent future abuse. They preferred a long, detailed, slightly complicated rule book over a short, ambiguous one that could be misinterpreted.
That makes sense. If you don't write it down, someone in power will eventually interpret the silence in their favor. So, speaking of writing it down, let's talk about where these 395 articles actually came from. There's this persistent criticism that the Indian Constitution is just a bag of borrowings, that we just sort of copy-pasted from everyone else and didn't create anything original.
It's a very common critique. They called it a hodgepodge or a patchwork quilt. But Dr. B.R. Ambedkar, who chaired the drafting committee, was very unapologetic about this.
I leaned into it.
He did. He famously said he was proud of ransacking all the known constitutions of the world.
Ransacking. Such an aggressive word. It sounds like it was a constitutional pirate.
It does sound aggressive, but his logic was actually very sound. He argued that in 1947, the fundamental principles of democracy had already been discovered and tested. The Americans had worked out fundamental rights. The British had perfected the parliamentary system. Why reinvent the wheel?
So if it works, take it.
If a democratic principle has been tested and proven in America or Ireland or Canada, take it. But, and this is the absolute key, they didn't just copy, they filtered. They adapted every single borrowed provision to suit the unique Indian reality.
So let's break down the loot, so to speak. Where do we get what?
Well, the biggest single chunk, the structural blueprint, came from our own recent history, the Government of India Act of 1935.
The British law that governed India before independence.
Yes, and this drew a lot of flack. Critics like N. Srinivasan claim the Constitution is really just the 1935 Act with adult franchise added on top.
Is that a fair criticism?
Structurally, he had a point. The federal scheme, the office of the governor, the power of the judiciary, the public service commissions, the emergency provisions, more than half of the Constitution's provisions are remarkably similar, if not identical, to the 1935 Act.
So why keep the British structure if we were kicking the British out?
Pragmatism. Familiarity. The Indian administration had been running on these lines for years. Changing the entire administrative skeleton overnight would have led to absolute chaos. They decided to keep the engine, but change the driver and, more importantly, the destination.
Okay, so the skeleton is British administrative law. What about the soul, the philosophy?
The philosophical heart, the fundamental rights that comes directly from the USA. The idea that citizens have certain inalienable rights that the state cannot encroach upon, and the independence of the judiciary to protect those rights, that is distinctly American.
And judicial review, too.
Yes, the concept of judicial review, that the courts can strike down a law if it violates the Constitution, is also from the American model.
And what about the directive principles? Those guidelines for what a good government should do?
Those were inspired by the Irish Constitution and the parliamentary system itself, the idea of a prime minister, a cabinet that is responsible to the legislature. That's obviously from the British Westminster model.
But we didn't just stop in the English-speaking world. We went shopping in Canada, Australia, Germany.
Oh, absolutely. We took the idea of a strong center where the federal government has more power than the states from Canada. We took the concurrent list where both the center and the states can make laws on certain subjects from Australia.
And Germany. The source mentions the Weimar Constitution.
Yes, we looked at the Weimar Constitution of Germany for provisions regarding the suspension of fundamental rights during an emergency.
That one sounds a bit scary, the government being able to suspend your rights.
It is, and it's always been controversial. But the drafters, having just lived through partition, felt that during a war or a major crisis, the survival of the nation had to come before individual liberty.
Where else? The source mentions South Africa, Japan.
We looked at South Africa for the procedure of constitutional amendment and Japan for the concept of procedure established by law.
What about the USSR, the Soviet Union?
The idea of fundamental duties, those were actually added much later, but the concept of duties and the ideals of social, economic, and political justice in the preamble draw some inspiration from the Soviet model.
And France.
The term republic and the ideals of liberty, equality, and fraternity in the preamble are taken directly from the French Revolution.
It really is a greatest hits album of global democracy.
It is. But it's a remix, not a cover song. For example, while we took the U.S. idea of judicial review, our Supreme Court isn't as powerful as the American one in some respects. We tried to balance it with the British idea of parliamentary sovereignty. It's a true synthesis.
Let's unpack that synthesis a bit more, specifically regarding the structure. Is India a federal country like the U.S., where the states are super powerful and almost like mini countries?
This is where it gets really, really interesting and tricky. The Constitution, believe it or not, never actually uses the word federation.
Never.
Not once. Article 1 of the Constitution calls India a union of states.
Okay, what is the practical difference between a federation and a union? That sounds like semantics.
It's not. Dr. Ambedkar explained this very clearly in the Assembly. A federation, like the U.S., is formed by an agreement between independent states. They come together and create a central government.
Right.
A union, like India, is different. The union wasn't created by the states. The union created the states. This means no state has the right to secede. You can redraw the entire map of India, change state boundaries, rename them, split them in two, but the nation itself is indestructible.
So it looks federal on the surface. There are states, there's a central government, but the soul of it is unitary.
Precisely. That's why scholars have come up with all these terms for it. Quasi-federal was what Casey Ware called it. Granville Austin called it cooperative federalism.
So what are the federal features?
You have the classic ones. A written constitution, division of powers between center and state, and independent judiciary.
But the unitary or non-federal features are really strong.
Overwhelmingly so. You have a single constitution for everyone, single citizenship, and the fact that the center appoints the governors who head the states, and of course, the big one. During an emergency, the whole system can become purely unitary. The center just takes over everything.
Why this unitary bias? Why make the center so incredibly strong?
You have to remember the context. 1947, partition. The country was literally being torn apart by religious violence. There were hundreds of princely states, many of them contemplating declaring independence.
The fear was chaos.
The drafters were terrified of balkanization, the country breaking up into dozens of tiny warring pieces. A strong center was seen as the only glue that could hold all the diverse pieces together.
That context makes a lot of sense. Fear was a huge motivator. Now, that flexibility you mentioned brings us to another blend that the sources highlight: the mix of rigidity and flexibility.
Right. A rigid constitution like the US one is very hard to change. It's almost set in stone. A flexible one, like the UK's, which isn't even fully written down, can be changed as easily as any ordinary law. India tries to find a middle path.
And this is all governed by Article 368.
Yes. Article 368 lays out the amendment process, and it's clever because it classifies changes into different tiers of difficulty.
So some things are easy to change.
Some parts of the Constitution are very flexible. They can be changed by a simple majority in Parliament, just like passing a normal bill. Things like changing the name of a state or creating or abolishing a state's legislative council. It's as easy as passing a traffic law.
But other, more important parts are rigid.
Very. Most constitutional provisions need a special majority. That means it has to be passed by 2/3 of the members present and voting, and that 2/3 must also be more than 50% of the total strength of the House. That's a high bar to clear.
And then some parts are extra rigid.
Exactly. Anything that affects the federal structure, like changing the powers of the Supreme Court, the way the president is elected, or the distribution of legislative powers between the center and states, that requires the special parliamentary majority plus ratification by the legislatures of at least half of the states.
So it safeguards that core federal balance while still allowing the country to adapt over time.
It's designed to bend without breaking. If it were too rigid, it might just crack under the pressure of social change. But if it were too flexible, any ruling party with a big majority could rewrite it to suit their whims.
Okay, I want to move now to what our sources call the conscience of the Constitution. This is the section that groups together fundamental rights, directive principles, and fundamental duties.
Yes, Granville Austin, one of the most famous scholars of the Indian Constitution, described the fundamental rights and the directive principles together as the conscience of the Constitution.
Let's start with fundamental rights. Part 3 of the document. These are the big ones we all know: equality, freedom, religion.
There are 6 categories today: right to equality, right to freedom, right against exploitation, right to freedom of religion, cultural and educational rights, and the right to constitutional remedies. But originally there were 7.
Ah, the infamous right to property.
Correct. The right to property used to be a fundamental right, but it caused endless legal headaches for the government's land reform and socialist agenda in the early decades.
How so?
Well, the government wanted to redistribute land from large landlords to the landless, and the landlords kept going to court claiming their fundamental right to property was being violated. So eventually, the 44th Amendment in 1978 demoted it. It's still a legal right under Article 300A, but it's no longer a fundamental right.
And these rights are justiciable. That's a key term here, right?
It's the most important term. It just means they're enforceable in a court of law. If the state violates your right to free speech, you don't have to wait for the next election to complain. You can go directly to the Supreme Court under Article 32.
And Article 32 itself is a fundamental right.
Yes. Dr. Ambedkar called Article 32 the very heart and soul of the Constitution. Without it, the other rights are just words on paper.
But then you have Part 4, the Directive Principles of State Policy, or DPSP. These are all the nice-sounding things: equal pay for equal work, building a welfare state, village panchayats, a uniform civil code. But they are not justiciable.
That's the crucial distinction. You can't sue the government for not giving you a job or for not implementing a uniform civil code.
So what's the point of them?
They are declared to be fundamental in the governance of the country. This means the government should keep them in mind when making laws, but they aren't legally enforceable instructions. They're classified into socialist principles, Gandhian principles like promoting cottage industries, and liberal intellectual principles.
So if I were to simplify it, rights are the don'ts for the government, Don't arrest me without cause. Don't discriminate. And principles are the do's. Do try to solve poverty. Do protect the environment.
That's a brilliant way to put it. And for a long time, there was a huge conflict between the two. Which one is superior? Can the government violate a don't, a right, in order to achieve a do, a principle?
That sounds like a philosophical trap with real-world consequences.
It was. It led to many court battles. Finally, in the Minerva Mills case of 1980, the Supreme Court delivered a landmark judgment. It said the Constitution rests on the bedrock of the balance between the two. You can't sacrifice rights entirely for social goals, but you also can't use rights to block all social progress. It's a delicate equilibrium.
And then we have the duties, Part 4 VA. These weren't in the original 1950 Constitution, were they?
No, they were not. Fundamental duties were added during the emergency in 1976 by the 42nd Amendment, based on the Swaran Singh Committee's recommendations.
This feels a bit like a parent saying, okay, I've given you all these rights and freedoms, now here are your chores.
In a way, yes. The argument was that you can't have rights without corresponding responsibilities. They are moral obligations on citizens. Things like respecting the flag and the anthem, cherishing the ideals of the freedom struggle, developing a scientific temper, protecting the environment.
Are they enforceable?
Like the directive principles, they aren't directly enforceable by court writs, but Parliament can pass laws to implement them. They basically set a tone for what it means to be a good citizen.
Let's talk about one of the biggest topics in India today.
Yeah.
Secularism.
Yeah.
The sources point out something I didn't realize. The word secular wasn't even in the original preamble.
That surprises many people. The word secular, along with socialist, was added by that same controversial 42nd Amendment in 1976. However, the concept of secularism was always embedded in the Constitution. Articles 14, 15, 16, and the religious freedom articles from 25 to 30, they made it a secular state in practice from day one.
But our expert notes distinguish between Western secularism and Indian secularism. Western secularism is described as negative, a complete separation of church and state.
Correct. In France or the US, the state basically says, we have nothing to do with religion. It's a purely private matter. It builds a wall of separation.
But India's is different.
India's concept is what's called positive secularism. It doesn't mean the state is hostile to religion or indifferent to it. It means the state gives equal respect and protection to all religions. Sarva Dharma Samabhava.
Why the difference in approach?
Because in a country like India, religion is so deeply woven into the social fabric, into personal law, into culture, a total separation is just impossible. So the Indian state can support religious educational institutions or manage temple affairs, provided it doesn't favor one religion over another. It's a much more pragmatic, hands-on approach.
Let's move on to some of the unique features that made this whole democratic experiment function. I want to highlight universal adult franchise first.
This was a truly revolutionary act. You have to remember the context. In 1947, India was overwhelmingly illiterate and incredibly poor. Most Western democracies took centuries to give everyone the vote. They often started with white, male property owners, then all men, then finally women.
And India just did it in one go.
In one shot. Gave the vote to every single adult citizen from day one. It was a massive gamble on the wisdom of the common person.
Critics must have thought it would fail.
They did. They said illiterate people couldn't possibly choose a responsible government, but it became the absolute bedrock of Indian democracy. It empowered the poor and the marginalized like nothing else. And in 1989, the voting age was even lowered from 21 to 18 by the 61st Amendment.
Another unique thing, single citizenship. You mentioned this before. In the U.S., you are a citizen of the USA and also a citizen of, say, New York.
Yes, you hold a dual allegiance. In India, to promote unity and a single national identity, there is only Indian citizenship. You don't get a separate passport or a separate set of rights for being a Bengali or a Gujarati or a Tamil.
Or does it work?
Well, the sources do note a grim irony here. Despite this constitutional ideal of single citizenship, we still see communal and linguistic riots. The legal framework promotes unity, but social reality sometimes lags far behind. The gap between intent and reality is a constant struggle.
That connects to the idea of the independent bodies. We usually think of government as three branches: legislature, executive, and judiciary. But the Constitution created these other institutions, these bulwarks of democracy that stand outside that triangle.
Absolutely. The Constitution's framers realized that politicians shouldn't control everything, especially the things that keep them in check. So you have the Election Commission. It doesn't report to the Prime Minister. It's an independent constitutional authority whose sole job is to ensure free and fair elections.
And the tag.
The Comptroller and Auditor General, the guardian of the public purse. They audit all of the government spending to ensure money is being used legally and properly.
And the UPSC.
The Union Public Service Commission and the state PSCs, they're there to ensure that the people running the country, the civil servants, the bureaucrats, are selected based on merit through open competition, not by political patronage. These bodies are designed to act as powerful checks on the government's power.
I also noticed a relatively recent addition in the unique features list, the three-tier government.
This is a genuine global uniqueness. Most federations have two tiers, the center and the states. But with the 73rd and 74th Amendments in 1992, India gave constitutional status and recognition to a third tier, panchayats in the villages and municipalities in the cities.
So before 1992, villages had no power.
They did, but their existence and powers were up to the whims of the state governments. Elections often weren't held for decades. The 1992 amendments made local self-government a constitutional mandate. It wasn't just let's have local government. It was written into the Constitution with its own schedules and powers.
And even more recently, cooperative societies got a constitutional boost.
Yes, the 97th Amendment in 2011. It gave constitutional protection to cooperative societies and made forming them a fundamental right. It shows the Constitution is still evolving, still trying to find ways to organize society at the grassroots level.
Okay, we've praised this document enough. Let's get to the juicy part, the criticism. The sources list some very specific and very colorful complaints from members within the assembly itself.
The criticisms are vital because they show the real tension and debates that were happening in the room. We've already discussed the borrowed Constitution claim and the carbon copy of the 1935 Act claim, but the cultural criticism is fascinating.
The un-Indian criticism.
Yes. Many members felt the Constitution just didn't reflect the political traditions or the spirit of ancient India. K. Hanumanthaya had this famous and very sharp quote, "We wanted the music of Veena or sitar, but here we have the music of an English band."
Wow, that is a sick burn, honestly. The music of an English band. He was basically saying it's a completely Western document dressed up in Indian clothing.
Precisely. They felt it was disconnected from Indian traditions and values. Another member, Lokanath Misra, went even further and called it a slavish imitation of the West. They felt the Constitution should have been built up from the village level, the panchayat system, which was Mahatma Gandhi's vision.
Right, which brings us to the un-Gandhian critique. Gandhi wanted a decentralized state built on self-sufficient village republics. But Ambedkar, who was the chief architect, was very skeptical of villages.
Skeptical is putting it mildly. Ambedkar famously called Indian villages a sink of localism, a den of ignorance, narrow-mindedness, and communalism.
Ouch.
He believed the traditional village structure was deeply oppressive, especially to Dalits and minorities, and couldn't be the foundation of a modern, equal nation. That was a major ideological clash.
So who won?
The final document is largely Ambedkar's structure, centralized, modern, and rights-based, with Gandhi's village ideas included only in the directive principles in Article 40 as a goal for the state to strive for, not as the primary structure of the state itself.
And finally, that paradise for lawyers critique comes back with a vengeance.
It does. Sir Ivor Jennings and Indian members like H.K. Maheshwari argued that the complex legalistic language would lead to endless litigation, profiting the legal profession while confusing the common person.
And looking at the sheer volume of constitutional cases that have clogged Indian courts for 70 years.
You'd have to say they had a point. It is a highly, highly litigated document.
But despite the English band music and the elephantine size and the lawyer's language, it worked. It has held together.
It worked. That is the ultimate, undeniable rebuttal to all critics. It has held together a nation that many foreign observers in 1947 predicted would balkanize and collapse within a decade.
It's adapted.
It has adapted. It absorbed hundreds of princely states. It reorganized its own internal boundaries based on language. It fully integrated Jammu and Kashmir in 2019. It empowered local governments in 1992. It is a living document.
It's a living document. I like that.
It is, but, and here is where it gets really profound, and this is the thought I want to leave you with. It has a soul that cannot be touched.
What do you mean by that?
I mean, the Parliament has the power to amend almost anything in the text. But in the famous Kesavananda Bharati case of 1973, which is mentioned in our source context, the Supreme Court laid down the basic structure doctrine.
Meaning there are some parts of the DNA that you just can't mutate.
Exactly. The court said Parliament can change the details, amend the articles, but it cannot alter or destroy the basic structure of the Constitution. Things like secularism, the federal character, judicial review, the rule of law, and the parliamentary system.
So even the Parliament isn't all-powerful.
No. It implies that while the text is massive and detailed and amendable, there is an untouchable spirit, an unwritten core to the document that even the elected Parliament cannot destroy.
That is a powerful thought to end on. The idea that there's a core identity that survives every political change, every amendment.
Indeed. And it forces us to constantly ask, what else constitutes that basic structure? As society changes, does the soul of the Constitution expand? It's a question every single generation of Indians has to answer for itself.
A huge thank you to everyone listening. Next time you see a news headline about a new law or a court ruling, try to spot the constitutional machinery whirring away in the background. It's all there, that elephantine book.
Keep questioning and keep learning.
See you in the next deep dive. Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It absolutely is. And, even if you're not prepping for an exam, this is really the bedrock of how the Indian nation functions.
Exactly. Welcome, everyone, to the deep dive. We are back with another mountain of documents. And today's topic feels weighty. We're not just looking at a business strategy or a new piece of tech.
No, not at all. We are, in a way, looking at the operating system of the world's largest democracy.
That is the perfect way to put it, an operating system. What we have in front of us is a huge collection of notes covering the Constitution of India. And we're not talking about some dusty book in a museum. We're talking about the active code that runs the country.
That's right. The preamble, the union and its territory, citizenship, and the absolute core of it all. What's often called the Magna Carta of India, the fundamental rights.
So for everyone listening, our mission today is to decode this rule book. We're putting on our learner hat. Maybe you have a competitive exam on the horizon. Maybe you just want to understand the headlines better. My job is to ask the questions I think you'd ask. Because looking at these notes, there's a lot of jargon.
Oh, absolutely.
Sovereign, socialist, secular, certiorari, habeas corpus. It's dense stuff.
It is dense, but it's also a story. It's a story about power.
Yeah.
Who has it, who is it for, and what are the limits on that power? That's what we're going to unpack. We'll connect the dots on why the map of India has changed so much, why certain powerful words were added to the Constitution decades later, and why one specific article was called the very heart and soul of the entire document.
Okay, so let's jump in. We're starting right at the very beginning, the preamble. The notes we have refer to it as the identity card of the Constitution. That's a quote from a famous jurist, N.A. Paul Kivala.
It's a brilliant description, isn't it? An ID card. It tells you everything you need to know at a glance. Who are you? What's your nature? What are your objectives? The preamble does exactly that for the Constitution. It lays out the source of its authority, the people, the nature of the Indian state, and the ideals it strives for.
And it has its origins in something called the Objective Resolution, right?
That's right. It was moved by Pandit Nehru in the Constituent Assembly, and it basically set out the philosophy and the goals that the Constitution should enshrine. The preamble is the final, polished version of that vision.
But here's something that really jumped out at me from the timeline in our notes. The preamble that we all, memorized in school, it's actually not the original one from 1949.
No, it's not. And that is a crucial detail, a really significant point from an examination perspective and just for understanding our history. The original text was different.
How so?
3 very specific, very powerful words were added much later. They were inserted in 1976 through the 42nd Amendment.
1976. Okay, my alarm bells are ringing. It's right in the middle of the emergency.
Exactly. The context is everything here. The 42nd Amendment Act added the words socialist, secular, and integrity.
Let's pause on that, because that's huge. Does that mean before 1976, India wasn't technically secular or socialist?
That is the million-dollar question, isn't it? And the answer is, it's complicated. The words weren't there in black and white in the preamble, but the spirit was. The Supreme Court itself had noted, even back in 1974, that the concept of a secular state was always intended by the framers.
So it was already in the DNA of the document.
Precisely. You could see it clearly in Articles 25 to 28, which guarantee freedom of religion. So the 42nd Amendment didn't invent the idea. It just made the implicit explicit. It wrote it on the ID card in permanent marker so there could be no doubt.
Okay, let's break down these key words on the ID card then, because they are so central to political debates today. Let's start with sovereign. It sounds simple, but in today's globalized world, what does it really mean?
It means ultimate authority. It means India is not a dependency or a dominion of any other nation. No foreign power can dictate its policy. It's free to manage its own affairs, both internal and external.
But what about things like the Commonwealth? India is a member and the British monarch is the head of the Commonwealth. Doesn't that create a conflict?
That's a common point of confusion, but the notes are very clear on this. India's membership is an extra constitutional declaration. It's like joining a club. It in no way, shape, or form compromises India's sovereignty. The final say on Indian law and policy rests in India, period.
Okay, that's clear. Next up, the big one. Socialist. When I hear that word, I immediately think of the Cold War, the Soviet Union, state control. Is that the kind of socialism we're talking about?
No, and it's vital to make this distinction. The source material talks about two types: communist socialism, which typically involves nationalization of all property and production, and democratic socialism, which is the Indian model.
So is the Indian brand of socialism.
It's about a mixed economy. It's where the public sector government-owned enterprises and the private sector coexist. The aim isn't to abolish private property. The goal, as stated, is to end poverty, ignorance, disease, and inequality of opportunity. It's a blend of Marxist and Gandhian thought, but our notes say it leans heavily towards Gandhian socialism.
But looking at the Indian economy since the 1990s, the new economic policy of 1991 brought in liberalization, privatization, globalization. Hasn't that socialist tag become a bit diluted?
That's a very sharp observation. The notes do state that the 1991 reforms have, in practice, diluted the socialist credentials of the state. The economy is far more market-oriented now. However, the word remains in the preamble as an ideal, a guiding principle that the state should strive for social welfare and reduce inequality.
And secular, we touched on it, but let's define the Indian version.
Right, so in some Western models, secularism means a strict separation, almost a wall, between church and state. The state is completely indifferent or sometimes even hostile to religion. The Indian concept is different. It's a positive concept.
What do you mean by positive?
It means the state gives equal respect and support to all religions. There is no official state religion, so it's not anti-religion. It's about ensuring that all faiths can flourish without fear or favor.
Okay, and the last two keywords on the ID. Democratic and republic. People often use them as if they mean the same thing.
But they don't. They answer two different questions. Democratic answers, where does the power come from? It comes from the people, popular sovereignty. Now, India is an indirect or representative democracy. We elect representatives to make laws on our behalf.
We don't have things like national referendums on every issue, like in Switzerland.
Exactly. We don't use those tools of direct democracy. And republic answers the question, who is the head of state?
Right. Not a king or queen?
Precisely. In a monarchy, like the UK, the head of state is hereditary. In a republic, the head of state is elected, directly or indirectly. For us, that's the President of India. It signifies two things. There's no hereditary privilege, and all public offices are open to every citizen without discrimination.
I love that. The idea that anyone can rise to the highest office. Now, the preamble also promises these four beautiful ideals: justice, liberty, equality, and fraternity. The notes mention Dr. Ambedkar talking about them as a trinity.
Yes, this is from his final speech to the Constituent Assembly, and it's profound. He argued that you cannot treat liberty, equality, and fraternity as separate items in a list. They form a union, a trinity. To divorce one from the other is to defeat the very purpose of democracy.
Why are they inseparable?
Well, think about it. What happens if you have liberty but no equality?
Then the powerful and the wealthy are free to dominate everyone else. Yeah. Liberty for the wolf is death to the sheep, that sort of thing.
Exactly. And Bedgar said it produces the supremacy of the few over the many. Now, what if you have equality but no liberty?
Then you crush individual initiative. Everyone is the same, but no one is free to be excellent or innovative. It's conformity by force.
Precisely. And without fraternity, a sense of common brotherhood, you can't sustain either liberty or equality. You'd need a constable to enforce every interaction. It's that spirit of being one people that makes the other two possible.
It's fascinating to see where these ideas were borrowed from. The notes say just as social, economic, and political was inspired by the Russian Revolution.
Correct. And the ideals of liberty, equality, and fraternity.
The French Revolution, 1789.
Straight from there. The framers took the best political and social philosophies from around the world and wove them into our foundational document.
But here's the big legal twist. For decades, there was this massive debate. Is the preamble even legally a part of the Constitution? Or is it just a beautiful, poetic introduction?
This was a huge legal fight, and for a while the answer was no. In the Brew-Bar Union case of 1960, the Supreme Court held that the preamble shows the general purposes behind the law, but is not actually a part of the Constitution.
So it was just a preface with no legal teeth.
That was the view. But then came the landmark Kesavananda case in 1973. This case changed Indian constitutional law forever. The Supreme Court overturned its earlier decision. It said definitively, yes, the preamble is an integral part of the Constitution.
And what's the significance of that?
It's immense. It means the preamble can be amended, which is what happened in 1976. But, more importantly, it established that the basic features or fundamental elements of the Constitution, as reflected in the preamble, cannot be altered or destroyed by any amendment.
So you can renovate the house, but you can't knock down the load-bearing walls.
That is the perfect analogy.
Okay, let's move from the ID card to the actual map of the country.
Yeah.
Segment 2. The Union and its territory. Article 1 starts with India, that is Bharat, shall be Union of States.
And pay close attention to that phrasing, Union of States, not Federation of States.
Dr. Ambedkar was very particular about that, wasn't he? Why the distinction?
It's a fundamental difference. A federation, like the United States, was formed by an agreement between independent states that decided to come together. The Indian Union, on the other hand, was not the result of an agreement among the states. The states were created for administrative convenience.
And the crucial part is that no state has the right to secede.
Exactly. The federation is a union because it is indestructible. This leads to the famous description of India as an indestructible union of destructible states.
Wait. Destructible states? That sounds pretty extreme.
It highlights the strong unitary bias of our Constitution. In the USA, you have an indestructible union of indestructible states. The federal government can't just unilaterally change the borders of Texas.
But in India?
In India, under Articles 2 and 3, the parliament has the power to form a new state, increase or decrease the area of any state, alter the boundaries, or even change the name of a state.
And do they need the state's permission to do this?
No, this is the critical part. The bill has to be referred to the state legislature for their views. But Parliament is not bound by those views at all. They can completely ignore them.
And they can do this with just a simple majority vote.
A simple majority. It's not even considered a constitutional amendment under Article 368. It's a remarkably flexible and powerful provision.
Which explains why the map of India is constantly evolving. But what are the limits? Can Parliament just give a piece of Indian territory away to another country?
Now we're back to the Burr-Barra Union case again. That was precisely the question. The government wanted to cede some territory to Pakistan to settle a border dispute. The Supreme Court said, no, you cannot do that using the power under Article 3. Ceding territory to a foreign power diminishes the territory of the Union, and that requires a formal constitutional amendment under Article 368.
Which brings us to a more recent example from the notes, the land boundary agreement with Bangladesh.
The 100th Amendment Act of 2015. A fascinating case. For decades, the India-Bangladesh border was a mess of enclaves.
These are the little pockets of territory, right? A piece of India completely surrounded by Bangladesh and vice versa.
Yes, a historical anomaly. And a humanitarian nightmare for the people living in them, who were effectively stateless. The 100th Amendment enabled an exchange of these enclaves. India transferred 111 enclaves to Bangladesh, and Bangladesh transferred 51 to India. It settled a long-pending issue, but it required a full constitutional amendment to do it.
This whole process of state formation is a story in itself. At independence, we had all these princely states.
552 of them within India's geographical boundaries. Most, 549 of them, joined peacefully, but 3 held out.
The famous trio, Hyderabad, Junagadh, and Kashmir.
Right. Hyderabad was integrated through police action. Junagadh's ruler wanted to join Pakistan, but the people were overwhelmingly Hindu and wanted to join India, so a referendum settled it. And Kashmir's accession is, of course, a long and complex story of its own, starting with the instrument of accession.
So once these states were integrated, the big question was how to organize them. And the main point of conflict was language.
It was a political powder keg. The early leadership was very reluctant to redraw the map along linguistic lines. They feared it would undermine national unity. The Dar Commission in 1948 and then the JVP Committee in 1949 both recommended organizing states based on administrative convenience, not language.
But the people had other ideas.
They did. And this is where the story takes a tragic turn with Padisharamallu. He went on a hunger strike, demanding the creation of a separate state for Telugu-speaking people, carved out of the Madras state. He fasted for 56 days and died.
His death must have caused a massive uproar.
It did. There were widespread riots and protests. The government was forced to act. In 1953, Andhra Pradesh was created, becoming the first linguistic state in India.
And that opened the floodgates.
Completely. The government then appointed the Fazal Ali Commission to look at the whole question again. They ended up accepting language as a broad basis for reorganization, though they rejected the strict theory of one language, one state.
And that led to the big reorganization.
Yeah. The States Reorganization Act of 1956. It wiped the old map clean and created 14 states and 6 union territories. This was the foundation of the modern political map of India.
There's one state with a very unique story mentioned here, Sikkim.
Sikkim's journey is fascinating. Initially, it was a protectorate of India, not a full part of it. Then, through the 35th Amendment in 1974, it was given a unique associate state status.
A status that existed for no one else.
Right. But the people of Sikkim wanted more. They wanted full integration. A referendum was held, the monarchy of the Chogyal was abolished, and through the 36th Amendment in 1975, Sikkim became the 22nd full-fledged state of the Indian Union.
It really shows the Constitution's flexibility. So let's talk about the people within that territory. Citizenship, segment 3.
Right. The notes don't go into every detail of the Citizenship Act of 1955, but they do highlight a category that often causes confusion. The OCI cardholder, or Overseas Citizen of India.
It sounds a lot like dual citizenship, is it?
It might feel like it, but legally, it is absolutely not. The Indian Constitution is very strict. It forbids dual citizenship. If you voluntarily acquire the citizenship of another country, you automatically lose your Indian citizenship.
So what exactly is an OCI card then?
Think of it as a superpowered long-term visa. It's a multiple-entry, multi-purpose, lifelong visa to visit India. OCI cardholders get the same financial and economic rights as non-resident Indians, NRIs. They can buy property apart from agricultural land and practice professions like medicine or law.
But there are some very clear lines they cannot cross.
Yes, the big ones. They cannot vote in Indian elections. They cannot hold public office, so no becoming president, vice president, or a judge. They can't be elected to parliament or state legislatures. And generally, they can't take up government employment.
So you can participate in the economy, but not in the polity.
That's a perfect summary.
Okay, let's move to the heart of the matter. Part 3 of the Constitution. The section our notes call the Magna Carta of India, the fundamental rights.
Yes. Articles 12 through 35. This is the part of the Constitution that protects the citizen from the state. It's your shield.
So the first question is, who exactly are we being protected from? Article 12 defines the state. I always just assumed that meant, the government in New Delhi.
It's much, much broader than that, and it has to be. If it were just the central government, your local municipal corporation could violate your rights with impunity. So Article 12 defines the state as including the government and Parliament of India, the government and legislatures of the states, all local authorities.
Like panchayats and municipalities.
Exactly. And crucially, it also includes other authorities. The Supreme Court has interpreted this to include bodies like LIC, ONGC, SAIL public sector undertakings. Even a private body, if it's acting as an instrument of the state, can be considered the state for the purpose of enforcing fundamental rights.
Wow, so it's a very wide net. And Article 13 is what gives that net its teeth.
That's the power of judicial review. Article 13 says any law that is inconsistent with or takes away a fundamental right shall be void. This is the constitutional basis that empowers the Supreme Court and High Courts to strike down laws made by Parliament or state legislatures if they cross the line.
Okay, let's walk through the rights themselves. The first set is the right to equality, from Article 14 to 18. Article 14 talks about equality before law.
It's a British concept, part of the rule of law. It means no person is above the law. But there's also a second part to Article 14, equal protection of the laws. That's an American concept, which means the law should be applied equally to people in similar circumstances.
But there are some exceptions, right?
There are. The president and governors, for example, have immunity from legal proceedings for their official acts while in office.
Okay. Then we get to Articles 15 and 16, which are about prohibiting discrimination and ensuring equality of opportunity in public employment. And this brings us straight to one of the most debated topics in India, reservations?
The Mandel Commission. You cannot discuss Article 16 without getting into it.
Let's unpack the history here, based on the notes.
So in 1979, the government appointed the Second Backward Classes Commission, headed by B.P. Mandel, to identify the socially or educationally backward classes of India. They submitted their report in 1980.
And what did they find?
They identified over 3,700 castes as other backward classes, or OBCs, making up about 52% of the population. They recommended a 27% reservation for OBCs in government jobs and educational institutions.
But nothing happened for a decade.
The report just sat there. Then, in 1990, the VP Singh government announced it would implement the 27% reservation, and that decision led to massive protests and a huge legal challenge that went all the way to the Supreme Court.
The famous Mandel case of 1992, what was the verdict?
The court upheld the 27% reservation for OBCs. It said it was constitutionally valid, but, and this is crucial, it laid down some very important conditions.
The guardrails.
Exactly. First, it introduced the concept of the creamy layer. It said that the more advanced or wealthier members of the OBCs should not get the benefit of reservation. It should be targeted at those who really need it.
That makes sense.
What else? It also ruled that total reservations for scheduled castes, scheduled tribes, and OBCs combined should not exceed 50%. And at that time, it also struck down a provision for reservations and promotions, though that has a complicated history of its own since then.
Okay, moving through the equality articles. Article 17 is the abolition of untouchability.
And this one is absolute. There are no exceptions. The practice of untouchability in any form is forbidden and is a punishable offense. The Protection of Civil Rights Act of 1955 provides the legal framework for that.
And finally, Article 18, abolition of titles. No more Maharajas or Bahadurs.
Correct. The state cannot confer titles except for military or academic distinctions. So you can be a general or a doctor, but not a lord.
All right, now for segment 5, the core freedoms.
Yeah.
Article 19.
This is a big one. Article 19 guarantees 6 fundamental rights to all citizens. The right to freedom of speech and expression, the right to assemble peacefully, the right to form associations or unions, the right to move freely throughout India, the right to reside in any part of the country, and the right to practice any profession.
I thought there used to be 7 rights here.
There were. The 7th was the right to acquire, hold, and dispose of property. But that was deleted from the list of fundamental rights by the 44th Amendment Act in 1978.
So you can't own property anymore.
No, you can, but it's no longer a fundamental right. It's now a legal or constitutional right under Article 300A. The distinction is that if the state acquires your property now, you can seek legal remedy, but you can't claim your fundamental rights were violated in the way you could before 1978.
And these 6 freedoms in Article 19, they're not absolute, are they?
No right is absolute. The state can impose reasonable restrictions on these freedoms in the interests of things like the sovereignty and integrity of India, public order, decency, or morality.
Like how freedom of assembly can be restricted under Section 144.
Exactly. Your right to assemble doesn't give you the right to cause a riot. There's a balance.
Okay, what about protections for people accused of crimes? That's Article 20.
Article 20 provides 3 crucial safeguards. First, no ex post facto law. The state can't punish you for an act that was not a crime when you committed it.
That's a fundamental principle of justice.
It is. Second, no double jeopardy. You can't be prosecuted and punished for the same offense more than once. And third, no self-incrimination. You cannot be compelled to be a witness against yourself. The right to remain silent.
Which brings us to the big one. Article 21, protection of life and personal liberty. If Article 32 is the heart, this must be the soul.
I think that's fair to say. The article itself sounds simple. No person shall be deprived of his life or personal liberty except according to procedure established by law. But the interpretation of that one sentence has transformed our rights.
Because of that phrase, procedure established by law, that caused a lot of debate.
It did. Initially, in the A.K. Gopalan case in 1950, the Supreme Court took a very narrow, literal view. It said, as long as there is a law passed by the legislature that lays down a procedure, and that procedure is followed, then your liberty can be taken away.
So it only protected you from the executive acting randomly, but not from a law passed by Parliament, no matter how unfair that law was.
That was the interpretation, a deeply problematic one. But that all changed with the Maneka Gandhi case in 1978. It was a watershed moment. The court overturned its earlier view. It said the procedure itself must be fair, just, and reasonable. It couldn't be arbitrary or fanciful.
So it imported the American concept of due process of law.
In effect, yes. It said the law itself must be fair. This interpretation dramatically expanded the scope of Article 21. The right to life was interpreted to mean not just mere animal existence, but the right to live with human dignity.
And so many other rights have flowed from that interpretation.
Countless. The right to a clean environment, the right to health, the right to speedy trial, and very importantly, the right to education.
Article 21A.
Added by the 86th Amendment in 2002, it made free and compulsory education for children between 6 and 14 years a fundamental right. That came directly from the expanded understanding of the right to a dignified life under Article 21.
Now, there's a darker side to this section. Article 22, which deals with arrest and detention, and specifically preventive detention.
Yes, this is a very controversial feature of our Constitution. It allows the state to detain a person without trial simply on the suspicion that they might commit some hostile act in the future. Most liberal democracies do not have such provisions in peacetime.
So you can be locked up not for something you've done, but for something the state thinks you might do.
Correct. There are safeguards, like the right to be informed of the grounds of detention and the requirement of review by an advisory board if detention exceeds 3 months, but it remains a very potent and often criticized power.
Let's move to something less grim. Articles 23 and 24, the right against exploitation.
This prohibits human trafficking and bagarre. It's a term for forced labor without payment, a feudal practice. Article 23 bans it. And Article 24 prohibits the employment of children below the age of 14 in factories, mines, or other hazardous jobs.
And then we have the freedom of religion, Articles 25 to 28.
Article 25 protects an individual's freedom of conscience and the right to freely profess, practice, and propagate religion. Our notes point out an interesting detail here.
Regarding the Sikh faith.
Yes, the Constitution explicitly clarifies that the wearing and carrying of a kirpan is to be included in the profession of the Sikh religion. Also, for legal purposes related to these articles, the term Hindus is construed as including persons professing the Sikh, Jaina, or Buddhist religions.
And for minorities specifically, there are Articles 29 and 30, right?
Right. The cultural and educational rights. These protect the interests of minorities, both religious and linguistic. They have the right to conserve their distinct language and culture, and crucially, the right to establish and administer educational institutions of their choice.
Okay, so we've got this incredible list of rights. But a right is only as good as your ability to enforce it. What happens if the state violates one of these rights?
And that is where Article 32 comes in. This is the one Dr. Ambedkar called the very heart and soul of the Constitution, the right to constitutional remedies.
It's a fundamental right to enforce your fundamental rights.
Exactly. It guarantees the right to move the Supreme Court directly for the enforcement of any of these rights. You don't have to go through the lower courts first. You can knock directly on the door of the highest court in the land. And the Supreme Court is empowered to issue directions or orders or writs.
These are the legal tools, right? Habeas corpus, mandamus, and so on.
They are the powerful instruments of justice. Habeas corpus literally means to have the body of. It's a writ ordering a person who has detained another to bring the body of the latter before the court. It's the great bulwark against illegal detention.
Okay, what about mandamus?
It means we command. It's issued by a court to a public official asking them to perform their official duties, which they have failed or refused to perform.
And the others? Prohibition certiorari.
Prohibition is a higher court, stopping a lower court from exceeding its jurisdiction. Stop what you're doing. Certiorari is a higher court ordering a lower court to transfer a case to it or quashing an order already passed. Send it up to us.
And the last one, quo warranto.
It means by what authority or warrant. It's used to inquire into the legality of a person's claim to a public office. What right do you have to hold this position?
So these are the ultimate checks on state power. But there are situations where even these rights can be suspended, right?
Yes, during a national emergency. Under Articles 358 and 359, the state's powers expand. When an emergency is proclaimed, the 6 freedoms under Article 19 are automatically suspended.
Does everything just vanish?
No. And this is a critical safeguard that was put in place after the experience of the 1975 emergency. The 44th Amendment made it clear that even during an emergency, the president cannot suspend the enforcement of rights under Article 20 and Article 21.
The right to life and personal liberty and protection from conviction.
Those two remain sacrosanct. The state cannot, even in the gravest emergency, arbitrarily take away your life or liberty without a fair procedure or punish you retroactively. That's the absolute bottom line.
What a journey. We've gone from the nation's ID card in the preamble to seeing how the map can be redrawn, to defining who belongs, and finally to this incredible shield of fundamental rights that protects every citizen.
It really is. And that concept we discussed earlier, the basic structure doctrine from the Kesavananda Bharati case, that's the ultimate protector of this entire framework. It ensures that while the Constitution can be amended to change with the times, its fundamental soul cannot be destroyed.
And for you listening, why does all this dense legal history matter? Well, because knowing that Article 32 exists is your superpower. Understanding that Article 21 guarantees you a life of dignity, not just mere survival, is your shield. This isn't just for lawyers, it's the user manual for your rights as a citizen.
Absolutely. And it's a living document. It's not frozen in time. We saw the right to property being removed and the right to education being added. It evolves.
Which leaves me with a final thought for you to take away. We are now deep in the digital age. Our lives, our work, our identities are increasingly online. The source material we've discussed shows how rights can be added and adapted over time. So the question to ponder is this. What is the next fundamental right that needs to be added to the Constitution for the 21st century? Is it a right to internet access? Or maybe a fundamental right to privacy against both state and corporate surveillance?
That's a great question. If the Constitution is truly a living document, maybe it's time for its next update.
Something to think about. Thank you for joining us on this deep dive into the Rulebook of India. Keep learning, and we'll catch you on the next one.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It absolutely is. But, even if you're not prepping for an exam, what we're about to get into is, well, it's essentially the operating system of the Indian state. It's how the whole thing works.
That's a perfect way to put it. Welcome, everyone, to the deep dive. We are cracking open a pretty substantial stack of notes today. The goal is to really decode the structural and, I guess, the philosophical backbone of the Indian Constitution, Indian Polity, as it's called.
Right. And most people hear polity and their eyes just glaze over. They think of, dusty textbooks, article numbers you have to memorize.
Yeah.
A lot of jargon.
Exactly. But our mission today is a bit different. We want to turn those textbook facts into a living, breathing machine.
We want to get to the why behind it all.
Oh.
I mean, why did the framers choose a system that, on its face, seems to prefer instability? And how does the whole thing not just fall apart? How does the Supreme Court stop a parliament with a huge majority from, becoming a dictatorship?
Yes, exactly. We are going to try and strip away some of that legalese and look at this whole thing as a story about power, about balance, and a lot of conflict, actually.
A huge amount of conflict.
We've got a lot of ground to cover. We're starting with the moral instructions, then the duties of citizens, the mechanics of the parliamentary system, the federal structure, which is a whole can of worms, and finally, the big one, the dramatic legal war over how you can even change the Constitution.
That last part, the amendment battle, it honestly reads like a legal thriller. It is the climax of this whole story. But, you can't just jump to the end. You have to set the stage first. To get the drama, you have to understand the rules of the game.
So let's start with the software then, the moral code. We're talking about Part 4 of the Constitution, the Directive Principles of State Policy, the DPSP.
The name itself is, well, it's quite literal. Directive principles. They are constitutional instructions. It's as if the Constitution is handing a manual to the state. And when we say state, we mean everyone. The legislature, the executive, the local panchayats, all of them. And it's saying, look, when you make laws, when you formulate policies, these are the ideals you have to aim for.
Okay, but here's the first major friction point, and this is something that I think trips a lot of people up. These principles are, legally speaking, a bit strange. They're non-justiciable.
That's the key term from Article 37. It basically means they don't have legal teeth.
What does that mean in practical terms?
It means if the government violates one of your fundamental rights, let's say they take away your freedom of speech, you can go straight to the Supreme Court and demand justice. That right is justiciable.
You can sue them.
You can sue them. But if the government ignores a directive principle, say it fails to promote equal pay for equal work, or it doesn't move towards a uniform civil code, you can't take them to court and force them to do it. There's no legal remedy for their inaction.
Which, of course, leads directly to the criticism we saw in the notes. And this isn't a new thing. This debate goes right back to the Constituent Assembly.
Oh, absolutely.
A member named Nasiruddin, he famously called them nothing more than New Year's resolutions.
Ah, yes. A great line.
It is. You make these grand promises on January 1st, you're full of hope, and by January 5th, you've forgotten all about them.
It's a cynical take, but you can see where he's coming from given the lack of enforceability. K.T. Shah, another member, was even more scathing in his criticism.
What did he say?
He called the DPSP a check on a bank, payable only when the resources of the bank permit.
Wow.
It's basically the Constitution telling citizens, yes, we owe you this welfare, we owe you this better life, but we'll pay you when we feel like it, when we have the cash. Don't call us, we'll call you.
So if they're just bad checks or forgotten resolutions, why have them in the Constitution at all? Why not just leave them out and avoid the whole issue?
Because, and this was Dr. Ambedkar's argument, the Supreme Court isn't the only court in a democracy. The ultimate court is the court of public opinion, the electorate. He argued that while you can't enforce these principles in a court of law, they are absolutely enforceable at the ballot box. They serve as an instrument of instructions.
A benchmark for performance.
Precisely. If a government spends 5 years ignoring these ideals like social justice, public health, environmental protection, they will have to answer for it when they go back to the public for votes. It gives the opposition a constitutional basis to say, hey, you failed to live up to Article 39 or Article 40.
It's a political weapon, not a legal one.
Okay.
That makes sense. Now, the Constitution itself doesn't neatly categorize them, but for the sake of understanding, our notes break them down into 3 logical buckets. Let's walk through those.
The first bucket is what we call the socialist principles. This is really the welfare state agenda. It reflects that socialist-leaning consensus among the early Indian leadership.
So what are some examples?
You can look at articles like 38 and 39. They instruct the state to actively work to minimize inequalities in income, to ensure that both men and women get equal pay for equal work, and this is a big one, to prevent the concentration of wealth and means of production in the hands of a few.
That's a huge, almost revolutionary goal right there in the directives.
It's a massive mandate.
Yeah.
Then you have the second bucket, which feels very, very specific to India's history and its freedom struggle. The Gandhian principles.
Right. You can really see his philosophy woven in here.
They're direct reflections of the Reconstruction program that Gandhi championed. It's all about grassroots democracy, rural empowerment. So you have Article 40, which directs the state to organize village panchayats, local self-government.
The idea of power flowing from the bottom up.
Exactly. Then there are directives to promote cottage industries in rural areas. And of course, the one that's still a hot-button issue today, Article 48, which calls for prohibiting the slaughter of cows, calves, and other milch and draft cattle.
It's fascinating to see such a specific cultural and religious value codified as a national aspiration. Okay, and the third bucket represents a more modern, liberal, almost Western vision.
Yes, these are the liberal intellectual principles. They're about modernizing the state and society. The most famous one, and probably the most debated, is Article 44.
The Uniform Civil Code.
Uniform Civil Code. The idea that there should be one single set of personal laws for all citizens, covering marriage, divorce, inheritance, regardless of their religion.
And what else falls under this category?
A very crucial one for the rule of law is Article 50. It directs the state to separate the judiciary from the executive to make sure judges aren't influenced by politicians. And then Article 51, which is quite idealistic, it talks about promoting international peace and security.
So we have this manifesto of aspirations, but what happens when these grand aspirations crash into the cold, hard reality of fundamental rights? This has been a huge constitutional battleground for decades.
It really has. For a long, long time, the central question was this: can the government violate an individual's fundamental right in order to implement a directive principle?
For example, can I take away your private property, which is
You're right.
in order to redistribute wealth, which is a principle?
Exactly that kind of conflict.
Yeah.
And initially, the courts were very clear. No, fundamental rights are sacred. They are supreme. But the thinking evolved, and the definitive stance came in 1980 in a landmark case called Minerva Mills.
And this is where the Supreme Court came up with that very famous metaphor. They called fundamental rights and directive principles the two wheels of a chariot.
That's the one. It's known as the doctrine of harmonious construction. The court ruled that the entire Indian Constitution is founded on the bedrock of balance between these two parts. You cannot destroy one to give effect to the other.
So one wheel can't be more important than the other?
No. They have to move in tandem. If the chariot loses a wheel, it doesn't matter which one it was. The whole thing just crashes. It was a beautiful way of saying that social good and individual liberty have to coexist.
That's a really important takeaway. Balance. Okay, so let's flip the lens now. We've talked about what the state owes the people. Let's talk about what the people owe the state. We're moving on to the price of citizenship, or as they're formally known, fundamental duties.
And you know, what's so interesting here is that the original 1950 Constitution, the one that Ambedkar and the Constituent Assembly drafted, it was completely silent on this. It listed our rights, but it listed zero duties.
That seems like a pretty major oversight. Was it intentional?
It was, for the most part, intentional.
Uh,
You have to remember the context. The framers were idealists coming out of a long freedom struggle. They believed that if you gave people freedom after centuries of colonial rule, they would naturally be good citizens. They'd perform their duties out of a sense of patriotism. They didn't feel the need to spell it out, to treat citizens like children who need a chore chart on the fridge.
but that idealism eventually wore off.
It did. By the mid-1970s, and specifically during the period of the internal emergency, the government felt that this sense of duty needed to be, well, formalized, codified.
And that's where the Swaran Singh Committee comes into the picture.
Correct. The government set up this committee, and based on its recommendations, the 42nd Amendment Act was passed in 1976. This amendment added a whole new part to the Constitution, Part 4VA, with just one article in it, Article 51A.
Now, if we look at the global context, our notes say this was heavily influenced by the Constitution of the former USSR.
Very much so. It was a concept borrowed from socialist states, and you see that in the comparison. Major Western democracies, the USA, Canada, France, Australia, their constitutions don't have a specific list of citizen duties.
So it's not a common feature of democratic constitutions.
Not at all. It's more a feature of socialist countries. Japan is a notable exception among democracies that does have a list. It definitely implies a different kind of relationship between the citizen and the state, a different social contract.
Oh, so?
Well, it suggests that citizenship isn't just a one-way street of entitlements. It's not just a bundle of rights that you get to enjoy. It's a two-way street. You consume rights, but you must also produce duties.
It's the price of admission, so to speak. So let's look at the list in Article 51A. Some of it seems like standard civics 101. Respect the flag, the anthem, protect the sovereignty and integrity of India.
Right, the basics.
But there are a few duties listed that really stand out. They feel quite progressive, almost ahead of their time, even for 1976.
Well, absolutely. For instance, there's a specific duty to promote harmony and the spirit of common brotherhood amongst all the people of India. And it goes on to say we must renounce practices derogatory to the dignity of women. That's explicitly written into the Citizens Code of Conduct.
That is very powerful. And then there's my personal favorite.
Let me guess. The scientific temper.
The scientific temper. The duty to develop scientific temper, humanism, and the spirit of inquiry and reform. It's basically a constitutional duty to be rational, to ask questions, to not just blindly follow dogma or superstition.
It's a remarkable inclusion. But just like the directive principles, the critics have a lot to say about the fundamental duties.
I can imagine. Let me guess. The first criticism is that they're also non-justiciable.
That's part of it, yes. They can't be enforced by the courts. But the criticism is actually a bit more nuanced. It's twofold. First, the list is seen as incomplete.
What's missing?
Well, the Swaran Singh Committee, the one that proposed the duties in the first place, actually made some other recommendations that were rejected. For example, they strongly suggested making paying taxes a fundamental duty.
That seems like a pretty big one to leave out.
It does, doesn't it? But the government of the day decided against it. The one that people often point out as missing is the duty to vote.
And the second major criticism?
That the language is too vague, too abstract. I mean, how do you enforce a duty to cherish and follow the noble ideals that inspired our national struggle for freedom? What does that mean in practice? How does a police officer measure if I'm cherishing enough?
You can't, really.
Yeah.
Which brings us back to the utility question. If I can't be arrested for not having a scientific temper, then what's the point of having it in the Constitution?
The point, according to the Supreme Court, is in legal interpretation. The courts have said that these duties act as a guide for them when they have to decide if a law is constitutional.
Can you give us an example of how that would work?
Sure. Let's say the government passes a law restricting certain industrial activities in a fragile forest area to protect the environment. A company affected by this law goes to court. They claim the law violates their fundamental right to carry on a business.
Okay.
The court will then look at Article 51A. It will see that there is a fundamental duty for every citizen to protect and improve the natural environment. The court can then reason that because this law helps citizens fulfill a fundamental duty, the restriction it places on the company's right is a reasonable one.
I see. So the duties act as a sort of counterweight. They help the court balance an individual's right against the collective's responsibility.
That's a perfect way to put it. They provide context for the rights. Okay, so we've covered the moral code and the citizens code. Let's move from the abstract to the machinery. Let's step into what the outline calls the engine room. We need to talk about the parliamentary system.
This was, you could argue, the single biggest architectural choice the Constituent Assembly had to make. They had two major blueprints in front of them: the British parliamentary model or the American presidential model.
Right, and you have to think, this was 1947, 1948. We had just spent 200 years fighting to get rid of the British. The instinct might have been to reject everything British, to start completely fresh.
But we didn't. We stuck with their system, the Westminster model. Why?
It wasn't just familiarity or inertia. Dr. B.R. Ambedkar laid out a very specific, very logical reason for this choice in the Assembly debates. He framed it as a fundamental trade-off, a trade-off between stability and accountability.
Okay, let's unpack that because it's really the heart of the whole system.
Yeah.
How do stability and accountability conflict with each other?
Think about the American system for a moment. The president is the head of the executive branch. He is elected for a fixed term of 4 years. The legislature, which is Congress, cannot easily remove him. Impeachment is an incredibly high bar and very rare.
So his position is very stable.
Extremely stable. He can make 4-year plans without worrying that his government is going to collapse next week. But the flip side is that he's less accountable on a day-to-day basis. He doesn't sit in Congress. He doesn't have to stand up and answer questions from the opposition every single day. His cabinet is not made of legislators.
Whereas in the British system, the one we adopted,
It's the complete opposite. The executive, that is the prime minister and the cabinet, is drawn from the legislature. They are members of parliament first. They have to sit in the House. They have to face questions every single day during question hour. And, most importantly, they can be thrown out of office at any moment if they lose the confidence of the lower house, the Lok Sabha.
so Ambedkar and the framers chose accountability over stability.
Yes. Ambedkar's argument was that for a young, diverse, and fragile democracy like India, we cannot afford a system where an executive could potentially become an autocrat for 4 years with minimal checks. We needed constant daily vigilance. We needed the executive to be answerable to the people's representatives every single day, not just once every 4 or 5 years at election time.
That choice also explains the principle of collective responsibility, which is in Article 75.
That is the absolute heartbeat of the parliamentary system. The entire Council of Ministers is collectively responsible to the Lok Sabha. The famous phrase used to describe it is, they swim together or they sink together.
What does that mean in practice?
It means if a no-confidence motion is passed against the ministry, the entire ministry has to resign. From the prime minister down to the junior-most minister. You can't have one minister saying, well, the motion was against the PM, not me, so I'm staying. No, it's a package deal. The government is one single accountable unit.
Now, our notes point out a really interesting difference between our system and the original British one, something called the shadow cabinet.
Ah, yes. This is a brilliant institution that they have in the UK. The main opposition party officially forms a shadow cabinet. So if the government has a defense minister, the opposition appoints a shadow defense minister.
Then what's their job?
Their job is to become an expert on that specific portfolio, to scrutinize everything the government minister does, to lead the debate on that subject, and, most importantly, to be ready to take over that ministry at a moment's notice if the government falls and the opposition comes to power. It's a government in waiting.
That sounds incredibly efficient. It actually trains the opposition to govern, not just to oppose. But India doesn't have this.
No, we don't. It's a convention we never adopted. In India, the opposition critiques the government more generally, but we don't have that formal, structured shadow system.
And of course, the other massive difference is the head of state.
Right. Britain is a constitutional monarchy. Their head of state is a hereditary king or queen. India is a republic. Our head of state, the president, is elected, even if indirectly. That makes our system a parliamentary republic, not a parliamentary monarchy.
But let's be honest, the parliamentary system isn't a panacea. We see the demerits play out all the time. The chaos, the gridlock.
Oh, the demerits are very real and significant. The number one issue is, as Ambedkar foresaw, instability. We saw this in the 1990s in India with a string of coalition governments that lasted for 13 days or 13 months. When you have to keep 10 different political parties with different agendas happy just to stay in power, long-term, decisive policymaking becomes almost impossible.
And then there's the criticism that's labeled in our sources as government by amateurs.
Yes. In the American presidential system, the president can appoint anyone to his cabinet. He could bring in a Nobel Prize-winning physicist to be the energy secretary or a four-star general to be the defense secretary. They don't have to be elected politicians.
But in our system,
In our system, the minister must be a member of parliament, either by being elected or nominated within 6 months. So your talent pool is limited to the few hundred people who manage to win an election. This means you often have career politicians who are generalists, managing highly technical and specialized ministries like health, finance, or defense.
it's a closed shop, essentially. Okay, speaking of the distribution of power, let's zoom out a bit. We have this engine room in Delhi, but we also have engines running in every state capital. This brings us to Section 4, the federal system with a unitary bias.
And this is where the language of the Constitution gets very, very deliberate and tricky. If you read the very first article, Article 1, it describes India as a union of states. It consciously, deliberately avoids using the word federation.
Why? Why that specific choice of words? Why union and not federation?
Dr. Ambedkar explained this very clearly in the assembly debates. A federation, he said, is usually the result of an agreement or a compact between independent states that decide to come together to form a country. The classic example is the United States of America. The 13 colonies existed first, then they made a deal to form a union.
And India's case was different.
Completely different. In India, the country, the union, existed first. The union then created the states for administrative convenience. The states did not create the union. And this has a profound implication.
Which is that no state has the right to secede.
Exactly. The union is indestructible, even if the states themselves are not. The Parliament in Delhi can redraw the map of India. It can merge states, break them up, change their names, but no state can decide to leave the map.
So because of this fundamental design, India is said to follow the Canadian model of federalism, not the American one.
Right. The Canadian model features a very strong central government. And because of this, most constitutional experts describe India's system as having a unitary bias. It's federal in form, but unitary in spirit.
Let's list the evidence for this bias, because it's pretty overwhelming when you see it all together. First up, citizenship.
A simple but powerful one. We have single citizenship. In the United States, you are a citizen of the USA and a citizen of California or Florida. You have dual loyalties legally. In India, there is no such thing as state citizenship. You're just an Indian. That legally dilutes any primary allegiance to a state.
Okay, next. The office of the governor. This feels like a direct carryover from the British Raj, doesn't it?
In many ways, it is. The governor is the constitutional head of a state, just like the president is for the country. But look at how they get the job. They are appointed by the president, which in reality means they're appointed by the central government. They hold their office during the pleasure of the president.
So they serve at the whim of the center.
Effectively, yes.
Yeah.
The governor acts as the center's agent, their eyes and ears in the state capital. They have the power to reserve bills passed by the state legislature for the president's consideration, which is a way for the center to veto state laws.
And then there's what was called the steel frame of India, the All India Services.
The IAS, the IPS, the Indian Forest Service. This is a unique feature. These top-level bureaucrats are recruited and trained by the central government, but they are deployed to run the administration in the states. The state government has day-to-day control. They can transfer them, give them postings, but the ultimate disciplinary control, the power to hire and fire, rests with the center. It's a powerful tool for central oversight.
And finally, the ultimate weapon in the center's arsenal, the emergency provisions.
This is what really sets India apart. During a national emergency, under Article 352, the entire federal structure of the country can essentially be suspended. It transforms into a unitary state. The central government becomes all-powerful, and the states are reduced to mere administrative units of the center.
And this transformation happens without having to formally amend the Constitution.
Exactly. The system is designed with a switch that can turn it from federal to unitary overnight in times of crisis to protect the nation's unity and integrity.
So when you add it all up, the single citizenship, the appointed governors, the All India Services, the emergency powers, is it even fair to call India a federal country?
The most famous and probably most accurate description came from the constitutional scholar K.C. Ware. He looked at all these features and called India quasi-federal. It has the structure of a federation, but the substance is heavily tilted towards a unitary system.
But again, Ambedkar would have argued that this flexibility was a feature, not a bug.
He certainly did. He believed a rigid classical federation could easily break under the immense pressure of India's diversity and historical fault lines. The American Civil War was a terrifying example of a rigid federation cracking. India's system was designed to be flexible, to hold a continent-sized country together by tightening the central grip when necessary.
Holding the country together is one thing, but allowing it to grow and evolve is another. A constitution written in the late 1940s can't possibly foresee all the challenges of the 21st century. It needs to be changed. This brings us to our next section, Section 5, the amendment process, under Article 368.
And we come right back to that central theme of balance. Pandit Nehru spoke about this very eloquently. He said, if you make the Constitution too rigid, it becomes a barrier to the nation's growth. It can't adapt. But if you make it too flexible, it just becomes a plaything for the ruling party of the day.
So India tried to find a synthesis, a middle path. We have a system with 3 different levels of difficulty for amendments.
That's right. The first level, the easiest one, is actually conducted outside the scope of Article 368. These amendments can be passed by a simple majority in Parliament, just like any ordinary law.
And what sort of things fall into this category?
This is for the more administrative or less fundamental changes. Things like admitting new states into the Union, altering the boundaries of existing states, changing the rules about citizenship or salaries of MPs. Relatively straightforward stuff.
Then the difficulty level ramps up for Tier 2. This is the standard procedure under Article 368, which requires a special majority.
This is for the more significant changes. Crucially, this is the procedure required for amending fundamental rights and directive principles. To pass this, you need to meet 2 conditions simultaneously. First, you need a majority of the total membership of the House to vote in favor.
So more than 50% of all the seats in the Lok Sabha, whether the members are present or not.
Correct. And second, of the members who are actually present in the House and voting, you need a majority of at least 2/3.
That 2/3 rule is the real safety catch, isn't it? It means a government with a slim majority can't just rewrite the fundamental rights chapter on a whim.
Exactly. It forces a broad consensus. But then there is the third, even more difficult path, the highest level of protection. Special majority plus the ratification by states.
And this is reserved for anything that affects the federal structure itself.
Precisely. If the central government wants to change anything that impacts the powers of the states, like the method of electing the president, the extent of the executive power of the states, the distribution of legislative powers, or introducing something like the GST, which directly affects state revenues, they have to jump through an extra hoop.
What's that extra hoop?
They need to get that special majority in both houses of Parliament, and then the amendment bill has to be sent to all the state legislatures. It only becomes law after at least half of the states have ratified it by passing a resolution in their own assemblies. It protects the states from having their powers taken away unilaterally by Delhi.
There's one more crucial detail here, the role of the president in all of this.
A very important point. When it comes to an ordinary bill, the president can withhold his assent or send it back for reconsideration. But for a constitutional amendment bill, the 24th Amendment made it obligatory. The president must give his assent. He has no veto power here. If Parliament passes it correctly, it becomes part of the Constitution.
Okay, so Parliament clearly has the power to amend the Constitution. But this leads us to the final and, as you said, most dramatic section of our deep dive, the ultimate safeguard. It begs the question, is there any limit to this power? Can Parliament change anything? Could they, in theory, pass an amendment that says India is no longer a democracy or the Supreme Court is hereby abolished?
This is the legal thriller I was talking about. It's a 40-year-long battle of wits between 2 giants. Parliament, asserting its absolute supremacy by saying, we represent the will of the people so we can change any law, including the Constitution, and the Supreme Court, asserting its role as the ultimate guardian by saying, our duty is to protect the Constitution, even from Parliament.
Let's trace the timeline of this conflict, because for anyone studying this, these court cases are the foundational pillars of modern Indian democracy. It all starts in 1951, almost right after the Constitution was adopted, with the Shankari Prasad case.
In Shankari Prasad, the Supreme Court took a very literal, straightforward view. They looked at Article 368 and said, it gives Parliament the power to amend any provision of the Constitution. Any provision means any provision. That includes fundamental rights. So, in round 1, Parliament won a clear victory. The court gave them a green light.
But that green light turned red in 1967, the famous Galaknath case.
This was a seismic shift. An 11-judge bench of the Supreme Court completely reversed the earlier decision. They ruled that fundamental rights are transcendental and immutable. They occupy a sacred place in the Constitution. Parliament, the court said, has no power whatsoever to abridge or take away any fundamental right. They effectively put Part 3 of the Constitution beyond Parliament's
I
reach.
can't imagine Parliament took that decision lying down. You tell a room full of powerful politicians that they have less power than they thought, and they are going to fight back.
They were absolutely furious. They saw it as a direct attack on the sovereignty of the people's elected representatives. So, they did what they do best. They used their power to change the rules of the game. They passed the 24th Amendment Act in 1971.
And what did that amendment do?
It was a direct counterattack on the Supreme Court. The amendment explicitly changed the text of Articles 13 and 368 to say, in no uncertain terms, that Parliament does have the power to amend any part of the Constitution, including fundamental rights, and that no such amendment can be questioned in any court.
So Parliament basically wrote itself a blank check. It reasserted its total dominance. This sets the stage for the final showdown, the most famous, most important case in Indian legal history. Kesavananda Harati versus the state of Kerala in 1973.
This is it, the judgment that defines modern India. A massive historic bench of 13 judges was convened to settle this question once and for all. The stakes could not have been higher, and after months of arguments, they came up with a brilliant, philosophical, and powerful compromise.
What was the final verdict? Did they uphold Parliament's blank check?
In a way, they started by siding with Parliament. They overruled the Galaknath decision. They upheld the validity of the 24th Amendment. They said, okay, Parliament, you are right. You can amend fundamental rights.
So on the surface, it looks like Parliament won the war.
It looked like a total victory. But then came the most important but in Indian history. The court said, you can amend any part of the Constitution, provided you do not alter or damage or destroy the basic structure of the Constitution.
The basic structure doctrine, this is the ultimate shield.
This is everything. It was an act of pure judicial genius. It meant that Parliament's power to amend is wide but not unlimited. They can renovate the Constitutional House, they can repaint it, they can add new rooms. But they cannot blow up the foundation.
So what exactly is this basic structure? Is there a neat list written down somewhere in the judgment?
And that's the other brilliant part. The court deliberately did not provide an exhaustive final list. They left it open-ended, so the doctrine could evolve to meet future unforeseen threats to the Constitution.
But they've given us some idea of what's in it over the years.
Yes. Through various judgments since 1973, the court has identified certain elements as being part of the basic structure. Things like the supremacy of the Constitution, the rule of law, the principle of separation of powers, the secular character of the state, the federal character, free and fair elections, and crucially, the power of judicial review itself.
So if Parliament were to pass an amendment tomorrow saying, from now on, elections are canceled and the current prime minister will be ruler for life.
The Supreme Court would strike that down instantly as a violation of the basic structure. It's the ultimate check on parliamentary power. It ensures that the soul, the essential identity of the Indian Constitution, remains intact, no matter how large a majority the ruling party has.
It's an incredible concept. It's like a constitutional emergency brake that only the judiciary has the authority to pull.
And it was tested and reaffirmed again in the Minerva Mills case in 1980. It is now the undisputed law of the land. It is arguably the single most important reason why, despite all the political turmoil over the decades, the core democratic framework of India has survived.
Wow. We have covered a huge amount of ground today. We started with the software, the directive principles acting as a moral compass for the state. Then we looked at the user agreement, our fundamental duties as citizens.
He then broke down the hardware, the parliamentary system designed for day-to-day accountability, and the quasi-federal structure with that strong unitary bias designed to hold the nation together.
And we wrapped it all up with the ultimate antivirus software, the basic structure doctrine that protects the entire system from being corrupted or destroyed from within.
It really is a remarkable document when you see how all these pieces fit together. It's a constant balancing act between contradictions, flexibility and rigidity, states' rights and central power, individual liberty and social good. It's a living document in the truest sense of the word.
Before we sign off, I want to leave you, our listeners, with one final provocative thought. It builds on what we discussed about federalism.
Ah, yes. The unitary bias, the strong center.
We talked about how the intention back in 1950 was to use a strong central government to keep a diverse and at that time fragile country united. But the question for today is this. In a country that is now more politically mature, more economically powerful, is that strong center still a necessary safety net? Or has it become a system that stifles local autonomy and innovation?
Right. If states are constantly looking over their shoulder at Delhi, can they truly tailor solutions for their unique local problems? Or is the strong center a relic of a more insecure past that now holds back the economic potential of more dynamic states?
It's the central tension that will likely define the next chapter of Indian polity, as the states grow more confident that push and pull with the center is only going to get more intense.
Something to chew on for sure.
It is. Thank you so much for joining us on this very deep dive. I know it was a lot to take in, but hopefully the next time you read a headline about a constitutional amendment or a big Supreme Court judgment, you'll have a better sense of all the machinery clicking away underneath.
Always keep questioning.
We'll see you next time. Welcome back to the deep dive. Today we are taking a massive leap into the very machinery that keeps the world's largest democracy ticking. We aren't just reading the manual, we're looking at the source code of India itself. We're talking about the Indian Constitution, but specifically the tug of war, the relationship between the big boss in New Delhi, the center, and the various state governments.
It is a beast of a topic, but absolutely essential. If you want to understand why your city looks the way it does, or why certain taxes exist, or even why the police report to who they report to, you have to understand Indian federalism. It's a relationship that legal scholars have often described as a marriage where divorce isn't an option, but arguments over the household budget and who controls the remote are a daily occurrence.
I love that image. It's like we're all locked in this massive house together from Kerala to Kashmir, but we're constantly bickering about who takes out the trash and who gets the master bedroom. Because when you look at the sheer scale of India, you realize you simply can't run everything from one office in Delhi. It's impossible. But at the same time, if every state did exactly what it wanted, you'd have total chaos.
Precisely. That is the central tension. The Indian Constitution tries to walk a very fine, very tight line. It creates a federal system, meaning power is clearly divided between two levels of government. But, and this is the key phrase for today, it has a strong unitary bias.
Unitary bias. That sounds like the center has a thumb on the scale.
It's more like a whole hand on the scale. When push comes to shove, the center is designed to be the heavyweight. We have a mountain of sources to get through today. Texts on legislative procedures, administrative frameworks, and the dramatic emergency provisions. Our mission is to understand how this power balance actually works in practice, not just on paper.
Right. We've got a roadmap for this deep dive. We're going to look at three main pillars. First, the rules of the game. How laws and money are split, who gets to tax us and who gets to arrest us. Second, how the neighbors talk to each other. Interstate relations, which, well, usually involves fighting over water. And third, the emergency button. What happens when the system crashes?
It is a fascinating structure. It's not the American model where states are incredibly powerful, and it's not the British unitary model. It's uniquely Indian.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant. We are diving into Section 1, Legislative Relations. This is basically the power to make laws. The Constitution didn't just say, hey guys, figure it out among yourselves. It actually gave us three very specific shopping lists in the 7th schedule, didn't it?
It did. The 7th schedule is the bedrock of our legislative relationship. It divides the work into 3 lists: the union list, the state list, and the concurrent list. And the distribution isn't random. There's very specific logic to it.
Okay, let's unpack these lists one by one. First up, the union list, or list 1. This sounds like the heavyweight category.
It is. The union list contains subjects of national importance where we absolutely need uniformity across the country. Originally, it had 97 subjects. Today, it's sitting at around 98. We are talking about the big-ticket items: defense, banking, foreign affairs, atomic energy, currency, and communication.
Which makes total sense. You can't have Maharashtra deciding to print its own currency or Tamil Nadu deciding to declare war on a foreign country while the rest of India stays neutral.
Exactly. Imagine the chaos. If every state had different regulations for air travel or the stock market, it would be a nightmare for trade and security. So for anything on List 1, only the parliament in New Delhi has the exclusive jurisdiction to make laws.
So it's hands-off for the states.
Completely. If it's on this list, the state legislatures cannot touch it.
Okay, so that's the center's turf. Then we have List 2, the state list. This feels more like the daily life list.
That's a good way to view it. These are matters of local and regional importance where local knowledge is key. Originally, this list had 66 subjects, but it's been trimmed down to 59. This includes public order, police, public health, sanitation, agriculture, prisons, and local government.
So, if I have a grievance about the potholes in my city, or if the local police are inefficient, technically I shouldn't be blaming the prime minister. I should be looking at my chief minister.
In normal circumstances, yes. The state legislature has the exclusive power to make laws here. The framers believed that a representative sitting in the state capitol knows better how to manage local agriculture or irrigation than a bureaucrat sitting in Delhi.
You mentioned normal circumstances. I feel like there's a but coming.
There is always a but in Indian polity. But before we get to the exceptions, we have to look at the third list, the concurrent list, or list 3.
The shared space, like the common room in a dormitory.
Yes, that's a perfect analogy. This is where both Parliament and the state legislatures can make laws. It originally had 47 subjects, now it has 52. This includes things like criminal law, marriage and divorce, bankruptcy, electricity, and labor welfare.
I notice in the notes that some really massive topics like education and forests are in this shared list. Were they always there?
No, and that is a crucial piece of political history. Originally, education of forests were on the state list. They were considered local concerns. But the 42nd Amendment Act of 1976, passed during the emergency era, shifted 5 subjects from the state list to the concurrent list.
Right, let's list those out because that was a significant power shift. That's a huge deal.
It was. They were education, forests, weights and measures, protection of wild animals and birds, and the administration of justice. The argument was that you needed a national standard. You didn't want educational quality or environmental protection to vary wildly from state to state. You needed a unified vision.
But here's the obvious problem with a shared list. What happens if they disagree? Let's say a state passes a law on education that says one thing, and the center passes a law that says the exact opposite. Who wins?
This is where the unitary bias kicks the door down. The Constitution applies the rule of conflict. If there is a repugnancy, a direct conflict between a central law and a state law on a concurrent list subject, the central law prevails.
So Parliament wins every time.
The Parliament wins.
Is there any loophole for the states? Or do they just have to take it?
There is a small, fascinating exception. If the state law has been reserved for the president's consideration and is received his assent, then the state law prevails in that specific state.
Oh, that's interesting. So a state can say, look, Mr. President, we know this conflicts with the central law, but we have a unique situation here in our state.
Exactly. And if the president signs off, that specific state gets to keep its law. However, there's a catch.
Always a catch.
Parliament can subsequently pass a new law to override it again. So ultimately, the center is the senior partner. The power always reverts back to them if they choose to exercise it.
That brings us to the leftovers. In any legal document, you can't list everything because the world changes. The framers didn't know about the internet or cybercrime in 1950. Who gets the powers that aren't on any list?
These are called residuary powers. And this is a major point of difference between India and other federations. In the United States and Australia, the leftovers go to the states. The logic there is that the states are the primary units who came together to form a union.
But in India?
In India, we follow the Canadian model. Residuary powers go to the center. Article 248 gives the exclusive power to make laws with respect to any matter not enumerated in the concurrent or state list to Parliament.
Why did we go that way? Why not trust the states with the leftovers?
You have to look at the context of the late 1940s. The country was being partitioned. There was a genuine, terrifying fear of balkanization, that India would break into little pieces. The framers, particularly Dr. Ambedkar, wanted a strong center to hold the national integrity together. They didn't want a situation where a new power emerged and states could claim it to challenge the center.
That makes sense. It was a survival strategy. Also, I see a note here about extraterritorial legislation. That sounds like science fiction.
It just means laws that apply outside the physical borders of India. Only Parliament can make these laws. A state legislature can only make laws for its own territory. Parliament can make laws that apply to Indian citizens and their property anywhere in the world. So think about taxation laws for NRIs, for instance.
Right. So earlier you mentioned that the states rule the state list in normal circumstances. Let's talk about the abnormal circumstances. When can Parliament just barge in and take over the state list?
Barge in is a strong term, but effectively yes. The Constitution empowers Parliament to legislate on state subjects in 5 specific extraordinary scenarios. This effectively converts the federal structure into a unitary one temporarily.
Let's run through them. I see the first one involves the Rajya Sabha.
Yes. Article 249. Remember, the Rajya Sabha is the Council of States. Its members are elected by the state assemblies. So if the Rajya Sabha passes a resolution by a two-thirds majority, saying it is necessary in the national interest to make a law on a state subject, Parliament gets the power to do so.
That makes structural sense. It's not the center just grabbing power. The state's own representatives in Delhi are giving permission.
Correct, it's a check and balance. This authorization lasts for 1 year, but it can be renewed indefinitely 1 year at a time.
Okay, that's one. The second scenario seems more drastic. During a national emergency.
Article 250. When a national emergency is in operation, say during a war, the federal niceties take a back seat. Parliament acquires the power to legislate on any matter in the state list. The state legislature doesn't stop working, technically, but Parliament becomes the superior authority on everything. The state law isn't void, but it becomes inoperative to the extent it conflicts with the central law.
So the state assembly becomes a bit of a lame duck. What's the third one?
Article 252. When two or more states request it. Sometimes states realize they can't handle a problem alone, maybe regulating a shared river basin or a specific type of trade that crosses borders. They can pass resolutions asking Parliament to make a law for them.
It's like calling in a consultant. Hey, we can't figure this out. Can you write the rules for us?
Exactly. But there is a catch. Once the states hand this power over to Parliament, they can't amend or repeal that law themselves later. Only Parliament can change it. They essentially surrender that specific power.
That is a one-way street. Be careful what you wish for. The fourth scenario is international agreements.
Article 253. This is crucial for modern governance. If the government of India signs an international treaty, say the Paris Agreement on Climate Change or a WTO agreement, Parliament can pass laws to implement it, even if the subject falls under the state list.
So if agriculture is a state subject, but we sign a global treaty on reducing methane emissions from farming, the center can pass a law regulating farms.
Yes, the courts have upheld this. You can't have a situation where the Prime Minister promises something to the United Nations, but a Chief Minister says, sorry, that's my jurisdiction. The nation has to speak with one voice abroad.
And the fifth and final one.
That is President's rule in Article 356. If a state government collapses or is dismissed because the constitutional machinery has failed, Parliament steps in and takes over the legislative duties for that state. The President can authorize Parliament to legislate on the state's behalf.
It really does seem like the deck is stacked in favor of Delhi. But making laws is one thing. Actually running the show, the administration, is another. Let's shift gears to Section 2, Administrative and Financial Relations.
This brings us to a unique feature of Indian federalism. The source material refers to the steel frame of India, the All India Services.
The IAS, IPS, and IFS, these are the officers who run the districts, the ones on the ground.
Yes. In a strict federal system, like the U.S., the federal government has its own employees to enforce federal laws, and states have their own employees for state laws. In India, we mixed it up. We have the All India Services, the Indian Administrative Service, the Indian Police Service, and the Indian Forest Service.
So how does that work in practice? It sounds like a recipe for divided loyalties.
It can be. These officers are recruited and trained by the center, by the UPSC, but they are deployed to work in the states. They serve the state government, they are paid by the state, but their ultimate control lies with the center.
So the district collector in a remote district of Bihar is technically an agent of the center.
In a way, a chief minister can transfer them or suspend them, but they cannot fire them. The ultimate disciplinary authority is the central government. Dr. Ambedkar defended this vigorously. He argued that while federalism is important, you need a minimum standard of administration across the whole country. These services provide that administrative unity.
It definitely keeps the country connected. It stops the state from becoming a completely isolated island. Speaking of connections, I see the center can also give directions to states. That sounds like a parent telling a child what to do.
It is quite authoritative. Under Articles 256 and 257, the center can issue directions to states to ensure that the state's executive power doesn't impede or prejudice the center's executive power.
Can you give me a concrete example? What kind of direction are we talking about?
Sure. The center can direct states to maintain means of communication declared to be of national importance, or the protection of railways. If the center tells a state, you need to deploy police to protect this railway line because it's vital for national supply chains, the state has to do it.
And if the state says no, just ignores the direction.
That is dangerous ground. Article 365 acts as the hammer here. It says that if a state fails to comply with these directions, the president can deem that the government of the state cannot be carried on in accordance with the Constitution.
Which paves the way for a president's rule. Wow, so directions aren't just suggestions. They are orders with a gun to the head.
Essentially, yes. It's a very powerful tool of central control.
Let's talk about money, the lifeblood of governance, financial relations. Because you can have all the power in the world, but if you can't pay the bills, it doesn't matter.
This is arguably the most complex and contentious part. Historically, in India, there has been a mismatch. We call it vertical fiscal imbalance. The center has the most buoyant sources of revenue, income tax, corporation tax, customs. These grow automatically as the economy grows.
And the states.
They were historically left with less elastic sources:
Mhm.
land revenue, sales tax on liquor, agricultural tax. Yet they have the huge responsibilities: police, health, education, infrastructure. They have to do the heavy lifting but have less capacity to raise cash.
But that changed recently with the GST, right? The 101st Amendment.
Yes, the 101st Amendment Act of 2016 was a watershed moment. It introduced the goods and services tax. It allows both Parliament and state legislatures to make laws regarding taxes on goods and services. It was an attempt to create a one nation, one tax system, a unified national market.
But didn't states lose some power there? They can't just set their own sales tax rates anymore.
They did. They surrendered their taxation sovereignty to the GST Council in exchange for a share of this national pot. It was a massive gamble on cooperative federalism.
But even with GST, states often complain they are broke. How does the center help them out?
Through the system of grants and aid. There are two types mentioned in our sources. First, statutory grants under Article 275. Parliament must give these to states that are in need of financial assistance. These are charged on the Consolidated Fund of India.
Charged means they don't even need to be voted on by Parliament every time, right? They just get paid.
Correct. It's a constitutional obligation. Then there are discretionary grants under Article 282. The center or a state can make grants for any public purpose. Historically, the center used this massively to influence state planning. Since it's discretionary, there's more room for politics. If you align with our policies, maybe you get a bigger grant.
So who plays referee? Who decides that state A gets this much and state B gets that much?
The Finance Commission, Article 280. It's a constitutional body appointed by the president every 5 years. Its job is to recommend how the net proceeds of taxes should be distributed between the center and the states and between the states themselves. It's the balancing wheel of fiscal federalism.
So they decide how to slice the pie. Before we move on to the fights, there's a small point about immunity from taxation. The king doesn't tax the king.
Essentially, the property of the center is exempt from state taxation. You can't have the municipal corporation of Mumbai trying to collect property tax on a central government defense establishment. Conversely, the property and income of a state are exempt from union taxation, unless Parliament passes a law that allows it for, say, a state-owned commercial enterprise.
Okay, so we have the laws, the admins, and the money. But clearly, looking at the history of India, everyone isn't holding hands and singing songs. There is serious friction. This leads us to Section 3, friction and reform.
Immense friction. Over the decades, states have often felt bossed around. They argue that over-centralization leads to inefficiency. The Sarkaria Commission famously quoted a concern that this system leads to blood pressure at the center and anemia at the periphery.
That is a vivid image. The head is exploding with pressure while the limbs are weak and bloodless. What have the states done about it historically?
There have been various demands for autonomy. For instance, the West Bengal Memorandum in 1977. The left front government there demanded that the word union in the Constitution be replaced with federal. They wanted the center's powers limited only to defense, foreign affairs, currency, and communications.
That sounds like they wanted to turn the clock back to the cabinet mission plan or something, a very loose federation.
Yes. Similarly, the Anandpur Sahib Resolution in 1973 by the Akali Dal in Punjab demanded that the center's jurisdiction be restricted to just those few core areas, and crucially, the states should hold the residuary powers.
The center obviously didn't say, sure, go ahead.
No. But the friction led the government to appoint the Sarkaria Commission in 1983 to review center-state relations.
This is a name that pops up in every political science textbook. What was their verdict? Did they side with the states?
They rejected the demand for a weak center. They said a strong center is necessary to protect national integrity. However, they strongly emphasized cooperative federalism. They said the center shouldn't treat states like subordinates.
Did they have specific advice on the governor? Because the governor is often seen as the center's agent to destabilize state governments.
They did. Sarkaria recommended that the governor should be a nonpartisan figure, an eminent person from outside the state, and should not be intimately connected with local politics. Crucially, they said Article 356 President's Rule should be used very sparingly, only as a last resort.
And did anyone listen?
To some extent. Later, in 2007, the Punchy Commission was set up. They went further. They recommended that governors should have a fixed 5-year term and shouldn't just be removed at the pleasure of the central government. They wanted clear safeguards to prevent the office from being misused politically.
So the vibe is keep the strong center, but stop bullying the states.
Exactly. Find a better balance through cooperation, not confrontation.
Now let's talk about when the neighbors fight. Section 4, interstate relations. I feel like the biggest fights are always about water.
Water disputes are emotive and political dynamite. Article 262 is the key provision here. It empowers Parliament to provide for the adjudication of any dispute or complaint with respect to the use, distribution, or control of waters of any interstate river.
But here's the twist. I read that the courts are actually barred from interfering initially. That seems odd.
That is the twist. Article 262 allows Parliament to say that neither the Supreme Court nor any other court shall exercise jurisdiction over such disputes. Instead, Parliament enacts the Interstate Water Disputes Act.
So they set up tribunals.
Correct. We have seen many. The Kaveri Water Disputes Tribunal, the Narmada Tribunal, the Krishna and Godavari Tribunals. The idea is that these are technical issues requiring experts, hydrologists, economists, not just judges. The tribunal's decision is final and binding.
But we still see states protesting tribunal verdicts all the time. It never seems to end.
We do. Politics often gets in the way of the expert verdict. But legally, the tribunal is the authority. Aside from water, there is a mechanism for states to just sit down and talk. Article 263 allows for an interstate council.
When did this actually happen? Because the Constitution is from 1950, but I see a date of 1990 here.
That's right. It took 40 years. The Sarkari Commission strongly recommended it, and the VP Singh government finally set it up in 1990.
Who is in the club?
It's a high-powered body. The Prime Minister is the chairman. It includes chief ministers of all states and administrators of union territories. It's meant to investigate and discuss subjects of common interest like internal security or food distribution and make recommendations for better coordination.
It's like a clearinghouse for federal issues. Now, what about legal paperwork? If I get a court order in Delhi, is it valid in Chennai?
Yes. This falls under Public Acts, Records, and Judicial Proceedings, Article 261. The Constitution says full faith and credit shall be given throughout the territory of India to public acts, records, and judicial proceedings of the Union and of every state.
So a marriage certificate from Kerala is valid in Kashmir.
Exactly. And a final judgment of a civil court in any part of India is executable anywhere within India. Note that this applies to civil courts. Criminal rules are slightly different.
We also have these things called zonal councils. Are these in the Constitution too?
No, and that's an important distinction for you to remember. Zonal councils are statutory bodies, not constitutional. They were established by the States Reorganization Act of 1956.
Ah, 1956. That's when we redrew the map based on language.
Yes, to prevent linguistic chauvinism and promote what Nehru called emotional integration, they divide the country into 5 zones: northern, central, eastern, western, and southern.
What do they actually do?
They are advisory bodies. They discuss matters of common interest like border disputes, infrastructure, and interstate transport. The Union Home Minister is the chairman of all these councils.
And there's a separate one for the Northeast, right?
Yes, the Northeastern Council was created by a separate act in 1971. It includes the 7 sisters: Assam, Manipur, Mizoram, Arunachal Pradesh, Nagaland, Meghalaya, Tripura, and Sikkim was added later in 2002. Given the strategic importance and unique geography of the Northeast, they needed a dedicated council.
Okay, we've covered the day-to-day laws and the disputes. Now we have to talk about the break glass in case of fire, part of the Constitution. Section 5, emergency provisions.
Part 8 of the Constitution, Articles 352 to 360. This is where the unitary bias completely takes over. The Constitution transforms from federal to unitary without a formal amendment. Dr. Ambedkar called this a unique feature. No other federation allows this flexibility.
Let's start with the big one, national emergency. Article 352. When can the president push this button?
On 3 grounds: war, external aggression, or armed rebellion.
Armed rebellion. I remember reading that this used to be internal disturbance. Why the change?
That is the shadow of the 1975 emergency declared by Indira Gandhi. The term internal disturbance was too vague. It was used to declare an emergency on political grounds, leading to the suspension of civil liberties and the arrest of opposition leaders.
So after that nightmare ended, the new government wanted to make sure it never happened again.
Exactly. The 44th Amendment Act of 1978 was the corrective measure. It replaced internal disturbance with armed rebellion. You can't declare an emergency just because people are protesting. They have to be taking up arms against the state.
The 44th Amendment seems like it was basically a never-again act. It added a lot of safeguards, didn't it?
It did. For example, the president can now only declare a national emergency upon the written recommendation of the cabinet. Not just the prime minister whispering in his ear. The whole cabinet has to sign off.
And Parliament has to approve it faster, too.
Yes. Previously, they had 2 months. Now, the proclamation must be approved by both houses within 1 month and by a special majority. That's a majority of the total membership, indeed, not less than 2/3 of members present and voting. It's a very high bar.
What happens to our rights during a national emergency? Do we lose everything?
Not everything. This is crucial. Article 19, which guarantees our 6 freedoms like speech, assembly, movement, is automatically suspended only if the emergency is declared on the grounds of war or external aggression.
So if it's an armed rebellion inside the country?
Then Article 19 is not automatically suspended. You can still speak your mind. Furthermore, the 44th Amendment ensured that Article 20, protection and respect of conviction for offenses, and Article 21, right to life and personal liberty, can never be suspended, not even during a war.
That's a massive protection. The government can never take away your life or liberty without due process, no matter what.
Correct. Now let's look at Article 356, President's role.
Hmm.
This is the one used in states.
Dr. Ambedkar called this a dead letter, didn't he? He thought it would never be used.
He was very optimistic. In reality, it has been used over 100 times. It allows the center to take over the government of a state if the constitutional machinery has failed.
But failure of constitutional machinery sounds subjective. If the center doesn't like the state government, can they just say, oh, machinery failed, you're fired?
Historically, that happened a lot. Governments were dismissed for flimsy reasons, usually because the party in the state was different from the party at the center. But the Supreme Court stepped in with the famous S.R. Bomai case in 1994.
What did the Bomai judgment change?
It put the brakes on. The court ruled that the president's satisfaction is not absolute. It is open to judicial review. The center has to have material grounds. They ruled that the floor test in the assembly is the only way to determine if a government has lost support, not the governor's opinion.
They effectively said, show us the proof.
Yes. And they also ruled that secularism is a basic feature of the Constitution. So if a state government is acting against secularism, that could be grounds. But you can't just dismiss a state government for political convenience. This judgment dramatically reduced the misuse of Article 356.
Finally, there's a third type of emergency, Article 360, financial emergency.
This creates a situation where the financial stability or credit of India is threatened. If declared, the center can issue directions to states to observe canons of financial propriety.
And the scary part, they can cut salaries.
Yes, salaries of all persons serving the union and the states, including the judges of the Supreme Court and high courts, can be reduced. It's a drastic measure.
Has this ever happened?
Fortunately, no. Article 360 has never been invoked in India, not even during the balance of payments crisis in 1991. We managed to scrape through without it.
That is a relief. Before we wrap up, we should briefly touch on Section 6, Trade and Commerce. It's part of how the union stays together economically.
Yes, Article 301. It states that trade, commerce, and intercourse throughout the territory of India shall be free. We want a common market. You shouldn't have barriers just because you crossed a state line.
But there are exceptions.
Of course. Parliament can impose restrictions in the public interest, for example, to control essential commodities during a shortage. And states can tax goods from other states, but only if they tax their own local goods the same way. No discrimination allowed.
So what does this all mean? We've looked at the lists, the money, the fights, and the emergencies.
If we synthesize this, we see a system that is designed for cooperative federalism. The Constitution gives the center the upper hand, especially the power to intervene when things go wrong, because the framers were terrified of the country breaking apart.
But they also created valves for pressure release, like the Finance Commission and the Interstate Council.
Exactly. The system works best when those valves are used.
Here is where it gets really interesting for me. The sources mentioned the Sarkaria Commission warning about blood pressure at the center and anemia at the periphery.
Yes.
So here is a provocative thought for our listener to take away. We have these rigid lists and emergency powers written in 1950, but today we live in an era of coalition politics and powerful regional parties. Is the balance of power naturally shifting back to the states, regardless of what the Constitution says?
That is the billion-dollar question. The Constitution provides the skeleton, but politics provides the flesh and blood. A weak center politically might make the unitary bias irrelevant in practice. If the prime minister relies on a regional party to stay in power, he can't exactly invoke Article 356 against that state easily. But on the other hand, fiscal dependency is still huge. The states still look to the center for grants. So you have this constant push and pull. The constitutional framework says one thing, but political reality creates a whole different dynamic.
Something to mull over the next time you see a headline about a water dispute or a governor's decision. It's
Yeah.
not just a political spat, it's the gears of our federalism grinding against each other.
Well said.
That's it for this deep dive into Indian federalism. Thanks for listening.
Thank you. Keep learning. Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It certainly is, and frankly, not just for exams, but for anyone trying to understand how the Indian state actually functions beyond, the headlines and the ceremonies.
Welcome back to the deep dive. Today, we are staring directly into the engine room of Indian democracy. We've got a massive stack of sources here covering the union executive.
President, vice president, prime minister, the whole top tier.
Exactly. And I have to admit, before digging into this, I kind of thought I knew how the system worked. You see the prime minister on TV, the president signs the laws. It seems straightforward. But the mechanics, the actual constitutional gears turning behind the scenes.
It is so much more complex than it appears on the surface. It's a machine built on checks, balances, conventions, and some very, very specific constitutional loopholes.
That's what I found fascinating. It's full of these nuances. We've got terms like pocket vetoes, kitchen cabinets, and my personal favorite, a vice president who has been described by some scholars as His Superfluous Highness.
That is a very specific, and I have to say, a somewhat stinging description.
It is. But as we'll see, there's a constitutional logic behind it.
There is.
But our mission today is really to decode these power dynamics. We want to answer those big questions. Who actually holds the power? What happens if a prime minister dies in office? And can the president just, decide to ghost parliament and ignore a bill?
That's a great way to frame it. We're essentially mapping the relationship between the nominal authority, that's the president, the de jure head, and the real political power, which lies with the prime minister and the council of ministers.
Okay, so let's start at the very top of that pyramid. The president. We all know parliament makes the laws. The Lok Sabha debates, the Rajya Sabha debates, they vote, a bill is passed. But that bill doesn't become an act.
Until the president signs it. That's the final step.
And this is all laid out in Article 111 of the Constitution. It says when a bill is passed, it's presented to the president. And they don't just have a big AP Proof stamp. They have options.
They do. 3 options specifically. First, they can give their assent, which makes it law immediately. Simple enough. Second, they can withhold their assent.
Which basically kills the bill right there and then.
Yes, that's what we call an absolute veto. It's a full stop. Or they can choose the third option, return the bill to Parliament for reconsideration.
Okay, let's unpack this veto power. Because our sources list 3 very distinct types: absolute, suspensive, and pocket. Let's start with that absolute veto. It sounds so, absolute, like the president saying a hard no.
It is a hard no.
And that feels very aggressive for what's mostly a ceremonial head of state. When does this actually get used?
It is aggressive, and that's precisely why it's so rare. You don't see the president just waking up and deciding to block a major government policy bill on a whim. That would cause a constitutional crisis.
Right.
So the absolute veto withholding assent entirely is usually exercised in 2 very specific scenarios. The first one is with private members' bills.
And just to clarify for everyone, a private member's bill is a bill introduced by an MP who isn't a government minister, correct?
Exactly. Most legislation is driven by the government, but any MP can propose a law. Now, these bills rarely pass because the government of the day controls the majority in the House. But let's say one does slip through.
Okay.
The government might not actually want that law, so the cabinet will advise the president to veto it. It's a way for the government to maintain control over the legislative agenda.
So it's less the president's personal decision and more the government using the president to clean up a legislative anomaly.
That's a good way to put it. The second scenario is much more political, though. It involves a change of government.
Okay, I'm listening. This sounds interesting.
So imagine this. A cabinet gets a bill passed by Parliament, but then, for whatever reason, they lose their majority, a scandal breaks. The cabinet resigns before the president has had time to sign that bill into law.
So the bill is just sitting on the president's desk in limbo, but its authors are now out of power.
Precisely. And a new cabinet comes in. The new government looks at that bill from the old guys and says, we don't want this. This is not our policy. They can then advise the president to withhold assent.
So the president uses the absolute veto on the advice of the new government to kill the old government's leftover business.
Exactly. It's a political tool used during a transition of power.
Do we have any real-world examples of this? It sounds like the kind of thing that would cause a lot of political drama.
We do have precedents. The sources point to two big ones. The first one was way back in 1954 with President Dr. Rajendra Prasad and something called the PCS Appropriation Bill.
PPSU. That's the Patiala and East Punjab States Union, right?
That's the one. It was a state under president's rule at the time. Parliament passed the bill to authorize funds, but by the time the bill got to the president's desk for his signature, the president's rule had been revoked. The state had a functioning government again.
So the whole context had changed.
Right. The reason for the bill no longer existed. So Dr. Prasad, seeing this, withheld his assent. It was a procedural veto, not a political one.
Okay, that one sounds pretty technical. What about the second example? You said it was more political.
Much more. This was in 1991 with President R. Venkataraman. The bill in question was about the salaries and pensions of members of parliament.
Ah, classic. The bill to give themselves a raise.
Essentially, yes. The controversy was that it was passed on the very last day before the Lok Sabha was dissolved. It was rushed through without the proper prior recommendation from the president, which is a constitutional requirement for money bills.
So it was procedurally flawed.
Deeply. When the bill reached President Venkataraman, he saw the flaw and the political context, a dissolved House, an outgoing government, and he withheld his assent. The bill died. He effectively said, no, this wasn't done right.
Okay, so that's the absolute veto. A full stop, but used very carefully. Now what about the second type? The suspensive veto. This sounds less like a no and more like a, are you sure about this?
That's a perfect way to describe it. With a suspensive veto, the president doesn't kill the bill. They return it to Parliament for reconsideration. They might say, I have some concerns about Clause 4, or I think you should reconsider the financial implications. They can even suggest specific amendments.
But here's the catch, and the sources make a really big deal out of this. It's a very weak veto in the end, isn't it?
It's very limited. If Parliament takes that bill back, looks at the president's notes, and decides, you know what, we like it the way it is, and they pass it again.
With or without the president's suggested changes.
Then the president must give their assent. They have no other choice.
They can't say no twice.
They cannot. The president's suspensive veto can be overridden by a simple majority in Parliament. This is a crucial design feature of our Constitution.
Why is that so important?
It ensures that the unelected head of state cannot permanently block the will of the elected legislature. The president can act as a check, a sort of constitutional pause button to force Parliament to have a second thought, but they cannot be a stop button.
So they can delay it, but they can't ultimately defeat it. Okay, that makes sense. But then we get to the third one, which I have to say is the most fascinating. The pocket veto. This sounds like something a teenager does when they don't want to show their parents a bad report card. They just keep it in their pocket.
That's essentially it. And this entire power stems from a silence, a loophole in the Constitution. Article 111 says that if the president wants to return a bill, they should do so as soon as possible.
But what in the world does as soon as possible mean? A day, a week, a decade.
Exactly. That is the loophole. The Indian Constitution, unlike the American one, does not specify a time limit. It doesn't say within 10 days or within a month. It just says as soon as possible.
So a president could interpret as soon as possible as, well, never.
Theoretically, yes. They don't ratify the bill, they don't reject it, and they don't return it. They just do nothing. The bill sits on their desk, gathering dust.
And by doing nothing, they kill the bill.
Effectively, yes. A bill doesn't become law without the presidential signature. The most famous example of this, and this is a story every student of Indian polity knows, involves President Zail Singh in 1986.
This was the Indian Post Office Amendment Bill, right? I've read about this.
That's the one. The Rajiv Gandhi government, which had a massive, massive majority at the time, passed this bill that imposed some pretty severe restrictions on the freedom of the press. It allowed the government to intercept mail on very broad, very vague grounds.
And it was hugely controversial.
Hugely. Civil liberties groups were up in arms, and President Zail Singh was not happy about it. His relationship with Prime Minister Rajiv Gandhi was already quite strained by that point.
So what were his options? He couldn't just use an absolute veto, could he?
Not really. Vetoing a bill from a government with such a huge majority would have been seen as a direct confrontation. And if he used a suspensive veto, sending it back.
The government would just use its majority to pass it again, and then he'd be forced to sign it anyway.
Precisely. He was boxed in. So he chose the third path, the path of inaction. He chose the pocket veto.
He just sat on it.
He just sat on it. He didn't say yes, he didn't say no, he just let it sit on his desk pending.
And what happened to the bill?
It stayed in his pocket, so to speak. It was still sitting there when his term ended. 3 years later, in 1989, the next president, R. Venkataraman, found this bill. He sent it back to the new National Front government for reconsideration. By then, the political winds had completely changed, and that new government just decided to drop the bill entirely.
Wow, that is a masterclass in bureaucratic passive aggressiveness,
Yeah.
using doing nothing as a form of powerful political action.
It is. But I have to add one crucial caveat here. The sources are very clear that there is one big exception to all these veto powers.
Let me guess. Constitutional Amendment Bill.
Exactly. The 24th Amendment Act of 1971 completely changed the game here. It made it absolutely mandatory for the president to give assent to a constitutional amendment bill.
So no vetoes whatsoever.
Yeah. No absolute, no suspensive, no pocket, nothing. If Parliament passes a bill to change the Constitution itself, the president's role is purely as a rubber stamp. They must sign.
Got it. So vetoes are for ordinary laws.
Yeah.
Now let's pivot to another presidential superpower, one that creates a lot of debate among legal scholars. Article 123, the ordinance-making power.
This is a very interesting and somewhat controversial feature of the Indian Constitution. In a strict separation of powers system like the U.S., the executive executes the law and the legislature legislates. They don't cross over.
But in India, they do.
Yes. Article 123 allows the executive, that is, the president, acting on the advice of the government to make laws when Parliament is not in session.
And this is designed for emergencies, right? Like Parliament is on its summer break and a war breaks out or a pandemic hits, and the country needs a new law right now. You can't wait for all the MPs to travel back to Delhi.
That's the exact justification. An ordinance has the same force and effect as an act of Parliament. It is a temporary law, but it is a law. But because it bypasses the entire legislative process, the debate, the voting, the committee scrutiny, it comes with some heavy safeguards. Or at least it's supposed to.
The outline mentions a satisfaction nuance here. The text says the president has to be satisfied, that circumstances exist which require immediate action. That word satisfied seems incredibly subjective.
It is. And for decades, the big question was, can the courts question that satisfaction? Can a judge say, Mr. President, we don't think you were really satisfied. We think this was a political move.
And for a while, the government tried to make that impossible, right?
He did. The 38th Amendment during the 1970s tried to make the president's satisfaction final, conclusive, and unchallengeable in any court. They wanted to lock the judiciary out completely.
But that was rolled back.
Yes. The 44th Amendment deleted that provision, restoring judicial review. So today, the answer is yes, the president's satisfaction is subject to scrutiny.
Which brings us to a really important case from our sources, the Cooper case of 1970.
Right. In the Cooper case, the Supreme Court ruled that the president's decision isn't totally immune from judicial review. You can challenge it in court if there's evidence of mollified intent.
Mollified meaning bad faith.
Exactly. Essentially, if the government is just using the ordinance route to bypass Parliament because they don't want to face a difficult debate, or maybe because they lack the numbers in the Rajya Sabha, that is unconstitutional. That is a fraud on the Constitution. You cannot use an emergency power for political convenience.
And speaking of fraud on the Constitution, we have to talk about the D.C. Wadhwa case. The example from Bihar in the sources is absolutely wild. I had to read it twice to believe it.
It is a shocking statistic, and it's a landmark case. D.C. Wadhwa versus State of Bihar from 1987 exposed a massive systemic abuse of this power. The governor of Bihar, who has similar ordinance powers at the state level, promulgated 256 ordinances between 1967 and 1981.
256. That's not an emergency response. That's just how they were governing.
It was their primary method of governance. But here's the real kicker. They kept repromulgating them.
Okay, explain what repromulgation means. An ordinance has a limited lifespan, doesn't it?
Yeah.
It expires when the legislature meets again.
It does. It must be laid before the legislature when it reassembles, and it ceases to operate 6 weeks after reassembly if it's not approved. But what was happening in Bihar was, instead of placing the ordinance before the assembly to be voted into a proper law, they would let the assembly session end.
And then?
And then they would immediately issue the exact same ordinance again, over and over.
So they were keeping these so-called temporary laws alive indefinitely.
For up to 14 years in some cases. They were effectively running the state by executive decree, completely bypassing the elected legislature. It was a subversion of the entire democratic process.
That sounds remarkably undemocratic.
The Supreme Court thought so too. In the D.C. Wadhwa ruling, they came down on it like a ton of bricks. They called the repromulgation of ordinances a fraud on the Constitution and a colorable exercise of power. You simply cannot turn an emergency provision into a substitute for lawmaking.
It's amazing how these loopholes get exploited until the courts step in to weld them shut. It really highlights that constant tension between the executive's need to act and the legislature's right to debate.
And that tension exists right through the executive structure, which I think brings us neatly to the next rung on the ladder.
Moving down the official order of precedence, let's talk about the number 2, the Vice President.
Article 63 of the Constitution, there shall be a Vice President of India.
The office is modeled after the U.S. Vice President, but the sources are quick to highlight some key differences, particularly in how they get the job. This seems to be a favorite point for exams, so if you're listening and studying, this is a key takeaway.
It is a vital distinction. Let's think back to how the president is elected. The Electoral College includes members of parliament, yes, but also members of the state legislative assemblies. Every MLA from every state gets a say in who the president is.
Because the president is the head of the entire Indian Union, including the states.
Precisely. But for the vice president, the states are completely excluded. The VP is elected only by an electoral college consisting of members of parliament, and that includes both the elected and the nominated members.
So why the difference? Why don't the states get to vote for the VP?
Dr. B.R. Ambedkar actually gave the logic for this in the Constituent Assembly debates. His argument was about the nature of their duties. He said the president is the head of the state, the entire federal union. He administers both the center and the states, so the states must have a voice.
Okay, that makes sense.
But the vice president, what is his primary day-to-day job?
He's the chairman of the Rajya Sabha.
Exactly. His main function is parliamentary. He presides over the Council of States, he only rarely acts as president, and even when he does, it's only for a temporary period. So Ambedkar argued it wasn't necessary to set up this huge, expensive electoral machinery involving all the state assemblies for a role that is primarily about managing the upper house of parliament.
That brings us back to that quote I mentioned at the start. His Superfluous Highness. Why would scholars be so mean to the VP?
It's not really about meanness. It's a commentary on the constitutional design. The Constitution assigns the vice president almost no specific executive functions. He doesn't have a portfolio. He doesn't run a ministry. He's not in the line of command. His office is essentially a spare tire.
Just waiting for a puncture in the main tire.
In a manner of speaking, yes. He only steps into the executive spotlight if there's a vacancy in the president's office due to death, resignation, or removal. And even then, there's another big difference from the American system.
Oh, right. In the U.S., if the president dies, VP becomes the president for the rest of the term. Lyndon B. Johnson after JFK, for instance.
Correct. But in India, the VP only acts as president for a maximum of 6 months. His job is just to hold the fort long enough for a new election to be held to fill the vacancy. The VP is a placeholder, not a successor.
So the spare tire is only used to get you to the nearest mechanic to get a new tire.
That is a perfect analogy.
Let's play out that spare tire scenario, though. The president's office is vacant. The VP steps up. But what happens if the VP's office is also vacant? Or if the acting president resigns?
Then the line of succession goes to the Chief Justice of India. The CJI would then act as president.
Has that ever actually happened? That sounds like the plot of a political thriller. The top 2 offices empty at the same time.
It happened once in a very dramatic and fascinating sequence of events in 1969.
Tell me about it.
So in 1969, the sitting president, Dr. Zakir Hussain, died in office.
Okay, so a vacancy is created at the top.
Naturally, the vice president at the time, V.V. Giri, took over as the acting president. But V.V. Giri had his own political ambitions. He wanted to become the president for a full term. He wanted to run in the presidential election that was now due.
And he couldn't run for president while also being the acting president?
He felt he should resign to contest the election freely. So in a very unusual move, he resigned from the vice presidency.
Hold on, so the president is dead. And the acting president, who was the VP, has just resigned. Both the top two spots are empty simultaneously. Who's running the country?
The constitutional backup plan kicked in. The Chief Justice of India at the time, Justice M. Hidayatullah, had to step in and serve as the acting president of India.
Musical chairs in Rashtrapati Bhavan.
It really was. And it shows why having a clear, deep line of succession is so critical. You can never have a power vacuum in a sovereign state. Someone must always be the constitutional head.
It's incredible that this system was tested like that and it held up. Okay, let's shift gears now from the superfluous highness to the person who, in reality, runs the show, the Prime Minister.
Now we are moving from the nominal executive, the president, the de jure or legal head, to the real executive, the Prime Minister, the de facto or actual head.
The sources cite Article 75, which simply says the president appoints the PM. But we all know it's not like the president just scrolls through LinkedIn and picks their favorite candidate.
Not at all. By convention, it's almost always the leader of the party that holds a majority in the Lok Sabha. If a party gets 273 or more seats, their leader becomes PM. It's straightforward.
But the sources highlight the president's discretionary power. What happens when no single party gets a clear majority?
The dreaded hung parliament.
Exactly.
In that situation, the president's role suddenly changes from ceremonial to absolutely critical. They have to use their personal judgment, their discretion, to figure out who is most likely to be able to form a stable government and command a majority.
And this power was first used in 1979 by President Sanjeeva Reddy.
Yes, that was the first time. The Janata Party government had collapsed. There was no clear majority for anyone. President Reddy used his discretion to appoint Charan Singh as prime minister, essentially taking a political bet that Singh could cobble together a coalition and prove his majority.
And there was a court ruling about when exactly the PM has to prove that majority wasn't there.
Yeah.
Because you can't just appoint someone and let them rule without having the numbers.
That's right. The Delhi High Court weighed in on this in 1980. They ruled that a person doesn't have to prove their majority before being appointed. The president can appoint them as PM first and then give them a reasonable time, usually a few weeks, to prove their majority on the floor of the House.
That makes sense. You get the keys to the car, but you have to prove you can drive it within a month. Now, here's a trivia nugget from the sources I found really interesting. You don't actually have to be a member of parliament to become prime minister.
That's true, but with a very, very strict condition attached. The Supreme Court ruled on this in 1997. It said, a person who is not a member of either the Lok Sabha or the Rajya Sabha can be appointed prime minister.
So, hypothetically, a distinguished economist or a general could be brought in to lead the country.
Yes, but they must get elected to either House of Parliament within 6 months of their appointment.
And if they fail to get elected?
They immediately cease to be the prime minister. The 6-month rule is non-negotiable. It's a provision that allows for bringing in outside talent, but it upholds the democratic principle by requiring them to get a popular or legislative mandate very quickly.
We've actually had some major political figures who were prime minister while being members of the Rajya Sabha, not the Lok Sabha.
We have, and this is a significant deviation from the British tradition, where the PM is almost always from the House of Commons. In India, membership in either house is perfectly valid. Indira Gandhi, when she first became PM in 1966, was a Rajya Sabha member. H.D. Deve Gowda in 1996 as well.
And most recently, Dr. Manmohan Singh.
Yes, for his entire 10-year tenure, from 2004 to 2014, Dr. Singh was a member of the Rajya Sabha. He led the country for a decade from the upper house.
The sources have some very poetic and telling descriptions of the PM's role. Lord Merley calls the PM primus inter pares,
which means first among equals.
But then another scholar, Jennings, calls the PM the sun around which planets revolve. Those sound like two very different things.
They are worlds apart, and that distinction matters immensely. First among equals implies the PM is just the chairman of the cabinet meeting. He's the most senior, but at the end of the day, he has one vote, just like the other ministers. It's a very collegiate, equal footing view.
But the sun, that sounds a lot more powerful.
The sun implies the PM is the source of all gravity and light in the system. The ministers, the planets, derive their authority from him and revolve around him. Without the PM, the planets would just drift away into space.
And which model better describes India?
The trend in Indian politics, especially under strong, charismatic leaders, has definitely been more towards the sun model. The PM is often seen as the captain of the ship of the state.
And the PM is also the main bridge to the president, according to Article 78.
Yes, Article 78 lays out the PM's duty. It is to communicate all decisions of the Council of Ministers to the President, and also to furnish any information about the administration or proposed legislation that the President might call for. It's not optional.
So the president might be a nominal head, but they have the constitutional right to be kept informed. They have the right to know what the government is doing in their name.
Exactly. The right to be consulted, the right to encourage, and the right to warn.
Now let's talk about the team. The PM doesn't work alone. We have the Central Council of Ministers.
This is the body that's defined in Article 74. It says, "There shall be a council of ministers with the Prime Minister at the head to aid and advise the President."
I keep hearing that phrase, aid and advise, and it sounds so polite, like they're just running a suggestion box for the president.
It sounds polite, but in constitutional terms, it is a command.
Right.
Originally, there was some ambiguity about whether the President had to accept the advice, but the 42nd and 44th Amendments to the Constitution cleared that up completely. They made it explicit. The advice tendered by the Council of Ministers is binding on the President.
So if the council says, sign this bill, the president has to sign it.
Well, the 44th Amendment gave the President one small out. They can ask the Council to reconsider their advice, but only once. If the Council sends the same advice back to the President a second time, the President must accept it. They have no choice in the matter.
This raises a question about transparency. Can the courts ever look at what advice was given? Like, can the Supreme Court subpoena the Prime Minister and say, show us the cabinet notes you sent to the president on this controversial issue?
No, absolutely not. The Constitution is very, very clear on this point of judicial exclusion. It states that the nature of advice given by the ministers to the President cannot be inquired into by any court.
And why is that shield in place?
It's to ensure frank and confidential discussions at the highest level of government. If ministers knew their advice could be picked apart in a courtroom, they might hesitate to speak their minds freely or give honest, but perhaps unpopular counsel. It protects the sanctity of executive decision-making.
Now, let's talk about the size of this team. It used to be that a prime minister, especially in a coalition, could create a massive ministry to keep all their partners happy. You know, you get a ministry, everyone gets to be a minister.
That was a huge problem. It was known as the era of jumbo cabinets. If you needed the support of a small party with just 2 MPs, you'd just make both of them ministers to keep them on your side. It was a massive drain on the public exchequer and terribly inefficient.
So they put a cap on it.
Yes, the 91st Amendment in 2003 put a hard mathematical limit on it. It says that the total number of ministers, including the Prime Minister, in the Council of Ministers cannot exceed 15% of the total strength of the Lok Sabha.
That's a good practical way to stop the bloat. Now, probably the most important concept in this whole section is collective responsibility under Article 75.
This is the bedrock. It is the single most important principle of the parliamentary system of government. The Council of Ministers is collectively responsible to the Lok Sabha.
I've heard the phrase, they swim or sink together.
That is precisely it. It means the government acts as a single, unified entity. If a motion of no confidence is passed in the Lok Sabha against the government, the entire council must resign.
Wait, even if the no confidence motion was about a mistake made by just one single minister?
Yes. If the finance minister presents a terrible budget and the House loses faith in the government because of it, the defense minister and the health minister have to resign too. The whole government falls as one.
And it also means you have to present a united front to the public, right? You can't be a cabinet minister and go out and trash your own government's policy at a press conference.
Absolutely not. That's called cabinet solidarity. A minister must support cabinet decisions both within Parliament and outside it. Even if they argued passionately against a policy inside the cabinet meeting, once the decision is made, they must own it publicly.
And if their conscience won't let them? If they fundamentally disagree?
Then their only honorable option is to resign from the cabinet.
And our sources give us some very powerful historical examples of this principle in action.
They do. The most famous is probably Dr. B.R. Ambedkar himself. He resigned from Nehru's cabinet in 1953.
And why did he resign?
He was deeply disappointed with the government's hesitation and the dilution of the Hindu Code Bill, which he had championed. He felt the government wasn't moving fast enough or boldly enough on social reform. He couldn't publicly defend the government's position, so he resigned.
And there was Arif Muhammad Khan in 1986.
Yes, a very famous case. He resigned from Rajiv Gandhi's government over the Muslim Women Protection of Rights on Divorce Act. He had taken a progressive stance in Parliament, but the government later reversed its position to appease certain conservative groups. He resigned in protest, That is collective responsibility in action. You either toe the line or you leave.
So that's collective responsibility.
Yeah.
But the sources also mention individual responsibility. What's that?
This flows from the constitutional wording that ministers hold office during the pleasure of the president.
Which in reality means the pleasure of the prime minister.
Exactly. The prime minister can, at any time, ask a minister to resign. If that minister refuses, the PM can simply advise the president to dismiss them.
It sounds harsh, but I guess it's a necessary tool for the PM.
It's the primary mechanism the PM uses to enforce that collective responsibility. If one minister is being incompetent or rebellious or is caught in a scandal, the PM can cut them loose before they drag the entire government down with them.
Here's a fascinating comparison from the sources that I think really highlights a key difference between our system and the British one it's based on. In the UK, there's something called legal responsibility.
Yes. In Britain, the traditional maxim is, the king can do no wrong. This means the monarch can't be sued or prosecuted. So, to ensure accountability, every official act or order of the king must be countersigned by a minister.
So if the order turns out to be illegal,
The minister who countersigned it is held legally responsible. They can be taken to court. They take the legal fall for the crown's actions.
but in India, we don't have that.
No. In India, there is no provision for the legal responsibility of a minister. Ministers do not need to countersign the official acts of the president. And since we already established that courts cannot inquire into the advice given to the president, a minister cannot be held personally liable in a court of law for the official advice they give.
That is a very significant legal shield.
It is. It places the accountability for a minister's actions squarely in the political arena in Parliament, rather than in the legal arena. If a minister gives bad advice, the political remedy is for Parliament to remove the government, or for the PM to fire the minister. But you can't usually sue the minister personally for giving that advice.
Because so we have the president, the PM, and this council of ministers. But the council is big. Even with the 15% cap, that can be around 80 people. How do they actually get any detailed work done? You can't make complex policy decisions with 80 people in a room.
You can't. And that is where the cabinet committees come in. These are interesting because they are extra-constitutional.
Meaning they aren't mentioned anywhere in the Constitution itself.
That's right. If you read the Constitution cover to cover, you won't find any mention of the Cabinet Committee on Security. They are established under the Government of India's rules of business. They exist to reduce the massive workload of the full cabinet and to allow for a proper deep dive, pun intended, into complex policy issues.
The sources list what they call the Big Four committees. Let's just run through them, because this really tells you where the real power centers of government are.
These four are the most powerful. First, you have the Political Affairs Committee.
Which is often called the super cabinet.
Exactly. It deals with all major policy matters, both domestic and foreign, relations with other countries, major internal security issues, federal-state relations. It all goes through here. And it's headed by the Prime Minister.
Okay, number 2.
The Economic Affairs Committee, also headed by the PM. This committee directs the national economy, coordinates government activities in the economic sphere, and handles all major economic policy decisions.
Third,
The Appointments Committee of the Cabinet. This one decides all the top-level appointments in the government, the secretaries to the government, the heads of public sector enterprises, the top brass in banks and financial institutions, also headed by the PM.
I am sensing a very clear pattern here. The Prime Minister is at the head of almost everything important.
Almost everything. The fourth of the Big Four is the Parliamentary Affairs Committee. Its job is to look after the progress of government business in Parliament scheduling debates, planning legislative strategy, ensuring bills pass. This is the only one of the Big Four that is usually not headed by the Prime Minister.
So who heads this one?
It's typically headed by the Union Home Minister.
Ah, so the Home Minister gets the job of herding the cats in Parliament.
It seems so. But notice that the PM directly controls the political policy, the economic policy, and the top personnel. That structure consolidates an immense amount of power in the Prime Minister's office.
And then there's one more group that's mentioned in the outline, the Kitchen Cabinet. It sounds like where the snacks are kept, but I have a feeling it's a bit more important than that.
Much more important. And unlike the other committees, this isn't official at all. It's a highly informal body. But almost every Prime Minister has one. It usually consists of the PM and maybe 2 to 4 very close, trusted colleagues, friends, or sometimes even family members.
The inner circle.
The real inner circle. It's often where the actual crucial decisions are made before they are even brought to the formal cabinet committee or the full cabinet for a rubber stamp. It allows for speed, secrecy, and frank discussion.
The critics must hate it, right?
They do. The main criticism is that it undermines the authority of the formal cabinet as the constitutionally mandated decision-making body. It can sidestep the established constitutional process. If the prime minister is listening more to a friend from outside government than to his own finance minister, that can be a real problem for governance.
But practically speaking.
Practically speaking, every leader in the world relies on a small group of trusted advisors. It's the room where it happens, to quote the musical Hamilton. You can't have a truly frank, no-holds-barred brainstorming session with 80 people. You do it with 3 or 4 people you trust implicitly.
So let's zoom out and look at this entire machine we've just assembled. We started with the president, who has veto powers, but largely acts on advice, a sort of constitutional emergency brake. We have a vice president who is essentially waiting in the wings as a spare tire. We have a prime minister who's very much the sun of the solar system, appointing ministers and heading all the super powerful committees. And we have a council of ministers that is bound together by this principle that they swing or sink as one.
It is a system designed for stability and clear lines of authority, but it is one that is very heavily centered on the office of the prime minister. The constitutional hierarchy is clear. The president reigns, but the prime minister rules.
And understanding this framework really helps you decode the daily news. When you hear that the Cabinet Committee on Security met today, you now know that's the super cabinet in action.
Exactly.
Or if you hear that the government has passed an ordinance, you now understand that they are bypassing a recessed parliament, and you also know the legal risks and history involved because of the Cooper and Wadhwa cases.
It transforms the news from just a series of random political events into a structural narrative. You can see the machinery working. You understand the levers that are being pulled behind the scenes.
Before we sign off, I want to leave our listeners with one final provocative thought that came from the sources. It really stuck with me.
Go on.
The sources mention that some scholars have described the British cabinet system as a cabinet dictatorship. But given everything we've just discussed about the Indian Prime Minister being the sun, heading almost all the key committees, holding the power to dismiss any minister, and often relying on an informal kitchen cabinet, does our system run the risk of becoming not a cabinet government, but a prime ministerial government?
That is the eternal question of parliamentary democracy, isn't it? Where does the balance of power lie? Does the system empower the team, or does it end up concentrating all power in the captain? Is the cabinet a genuine decision-making body, or is it, in practice, just a cheering squad for the prime minister's agenda?
It really makes you wonder about how much power should be concentrated in one single office.
Indeed. And that is precisely why understanding these constitutional gears, the vetoes, the checks, the principle of collective responsibility, is so incredibly vital. They are the only things designed to stop that sun from burning too bright.
Something to mull over. Thank you for listening to this deep dive into the Indian executive. We hope you feel a little more equipped to read tomorrow's headlines.
Thank you, and keep questioning.
See you next time.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It certainly is. And frankly, for anyone trying to understand how the world's largest democracy actually, functions day to day, this is the engine room.
Exactly. We're going to try and put aside the headlines for a bit, the shouting matches you see on TV, all that drama.
Yeah, the noise.
We're putting on our hard hats, walking onto the factory floor of Indian democracy, and we are unpacking the parliament. And I have to say, looking at the research, it's not just a building where people gather to argue. It's a labyrinth of very specific, sometimes, almost archaic rules. It's a massive, complex machine.
That is the perfect analogy. It is a machine. It's so easy to look at the Sansa Bhavan and just see, stone and pillars or a grand symbol of power.
Right.
But inside, it is this intricate web of checks, balances, and some very specific architectural choices in a constitutional sense that dictate how laws get made. And if you don't understand the machinery, the actual gears and levers, you can't really understand the product.
Which are the laws that govern all of us.
Precisely.
So let's start with the absolute basics, the blueprint, if you will. Our source material, Chapter 22, lays this out pretty clearly. When we say Parliament in India, under Articles 79 to 122 of the Constitution, what are we actually talking about? Because I think most people, myself included before this deep dive, just visualize the two chambers, and that's it.
That's the most common misconception, and it's a really important one to clear up right away. If you ask a layperson, they'll almost always say Parliament is the Lok Sabha and the Rajya Sabha,
The two houses.
the two houses. But according to the Constitution, the Parliament is actually a triad. It consists of three distinct components. You have the Lok Sabha, which is the House of the People. You have the Rajya Sabha, the Council of States. And this is the part that usually trips people up, both on exams and just in general understanding. You have the President of India.
Okay, let's unpack this immediately because that's the one that seems out of place. The president. The president sits in Rashtrapati Bhavan, which is, a fair distance from the Parliament House. Right. They don't debate bills. They don't bang the table. They don't vote in the sessions. So why are they considered an integral part of the Parliament?
Well, that's the crucial anomaly of our system, and it speaks to the fundamental design of our democracy. You're absolutely right. The president is not a member of either house. They do not sit in the sessions to vote or debate.
Okay.
However, functionally, the parliament cannot exist without them. Think of it this way. The two houses are like the factory floor, where the legislation is assembled piece by piece. But the president is the quality control officer at the end of the line who gives the final stamp of approval.
So a bill that's passed by both houses, it doesn't actually become law until the president signs it?
It doesn't become an act.
Yeah.
Without the president's assent, it's effectively just a piece of paper with a lot of good intentions. It has no legal standing.
So without that signature, it's just a draft.
A very well-debated draft, but a draft nonetheless. And it goes beyond just signing laws. The president plays a vital role in the entire life cycle of the parliament itself. The president is the one who summons the sessions to begin.
So they call everyone to work, essentially.
Exactly. They also prorogue the sessions, which means formally ending them for a period. And critically, the president has the power to dissolve the Lok Sabha entirely. So structurally and functionally, you just cannot separate the head of state from the legislature.
That feels very British.
It is entirely British. We follow what's called the Westminster model. In Britain, the parliament consists of the Crown, the House of Lords, and the House of Commons. When India adopted its constitution, we essentially just replaced the Crown with our elected president.
Right. And this is a huge contrast to the American model, which I think a lot of us are more familiar with from movies and TV.
Oh, absolutely. It's a common point of confusion. In the U.S., the president, the executive, is in a totally different box, legally speaking. He's part of the executive branch, but he is not considered part of the legislature, which they call Congress.
So a strict separation of powers.
A very strict separation. The U.S. president cannot dissolve Congress. Congress sits independently of the president's summons. We, on the other hand, operate on a principle of interdependence. The executive is part of the legislature. It's more of a fusion of powers rather than a clean break.
That's a vital distinction to keep in our minds as we go through this. So, okay, we have this triad. Let's zoom in on the two houses themselves. Let's start with the upper house, the Rajya Sabha. Why do we call it the Council of States? What does that name really mean?
Well, the name is its job description. Its primary role is to represent the federal nature of India. So while the Lok Sabha represents the people directly based on population.
One person, one vote.
Exactly. The Rajya Sabha represents the specific interests of the states and the union territories as distinct political units. It's meant to act as a kind of buffer, a check against the, you could say, national populism of the lower house.
And the composition of it is quite specific, isn't it?
Very. The maximum strength is fixed at 250 members. Now, the current strength is 245.
And are all of those 245 members elected?
Almost all of them. 238 are representatives who are elected, but indirectly. They're elected by the members of the state legislative assemblies. But, and this is another unique feature, there are 12 members who are nominated directly by the president.
These are the so-called celebrity spots, right? We often see actors or athletes or famous artists nominated here.
Well, that's how it often plays out in the headlines, and sometimes that's who gets picked. But the constitutional intent was actually quite high-minded. The Constitution says these nominated members should have special knowledge or practical experience in fields like literature, science, art, or social service.
So the idea was to get specific expertise into the debate.
Precisely. The idea wasn't just to have famous faces, but to bring in deep expertise. Scientists, economists, historians, artists, people who might not possess the political savvy or even the desire to survive the rough and tumble of a general election campaign.
So it's a way to get brains into the building without forcing them to go out and ask for votes.
You could put it that way. It enriches the debate with perspectives that aren't purely political. And it's worth noting, The American Senate has absolutely no equivalent to this. It's a purely political body. There are no reserved seats for scientists or poets in the U.S. Senate.
Now, speaking of the U.S. Senate, I know that in America, every state gets 2 senators. Doesn't matter if you're tiny Wyoming or massive California, you get 2 seats. Is our Rajya Sabha set up that way? Equal representation for all states?
No, and that is a major, major difference in how our federalism is structured. In the U.S., they have what we call symmetrical federalism. All states are treated as equal units in the Senate.
1 state, 2 votes.
Exactly. But in India, the allocation of seats in the Rajya Sabha is based on population, as laid out in the fourth schedule of the Constitution. So a massive state like Uttar Pradesh gets 31 seats in the Rajya Sabha. A smaller state like Tripura gets just 1.
So it's not symmetrical at all. The larger states still have much more of a say, even in the Council of States.
They do. It ensures that the larger populations have a larger voice across the board. Now, whether that truly protects the spirit of federalism or actually undermines the voice of smaller states is a subject of great debate, but that is the structure we have.
Okay, another key feature you mentioned in the notes is its permanence. The Rajya Sabha is a continuing chamber. What does that mean in practice?
It means it can't be dissolved, ever. Governments come and go, the Lok Sabha can be dissolved and sent back for fresh elections, but the Rajya Sabha remains. It is designed to be the stable hand on the tiller, providing continuity.
But the members themselves don't stay forever, do they?
No, they have fixed terms. And here's the clever part. 1/3 of the members retire every 2 years. So it's this constant, slow, revolving door. You always have a mix of senior experienced members and newly elected ones. It ensures a continuity of memory and policy without ever emptying the room completely.
That's quite an elegant system. Okay, let's move downstairs, metaphorically, to the Lok Sabha, the lower house. This is where the action usually is, right? The house of the people.
This is the heartbeat of Indian democracy. This is where the direct will of the people is expressed. The maximum strength here is set at 543, though the current strength is 542. And these members are, as the name suggests, directly elected by you and me.
And regarding who gets to vote, I saw in the notes that the voting age wasn't always 18.
No, it's a relatively recent change. For a long time, it was 21. It was the 61st Constitutional Amendment Act in 1988 that lowered the voting age to 18.
That must have been a massive expansion of the electorate.
Huge. It brought in the entire youth demographic, which, as we know, is an enormous chunk of India's population. It fundamentally changed the calculus of every election after that.
Now, unlike the Rajya Sabha, this house definitely has an expiration date.
It does. The normal term is 5 years, calculated from the date of its first meeting after the general elections. After 5 years, it dissolves automatically.
But it can be dissolved earlier.
Oh, yes. The president can dissolve it earlier on the advice of the prime minister, usually if the government loses its majority and no stable alternative can be found.
Is there any situation where its life can be extended beyond 5 years?
Yes. There is one very specific exception. During a national emergency. In that situation, the term of the Lok Sabha can be extended by Parliament for 1 year at a time.
So in a major crisis, they can pause the election cycle to maintain stability.
Exactly. But the Constitution is very strict about this not being abused. The moment the emergency ceases to operate, that extension cannot last for more than 6 months. You have to go back to the people as soon as possible.
I want to touch on something that I found really curious in the source material regarding the number of seats. We conduct a census every 10 years, right? So you would normally expect the number of seats per state to change as populations shift. But the source says we were working off some very old data.
This is the freeze. And it's one of the most significant and I would say controversial political engineering decisions in independent India. The 84th Amendment Act in 2001 froze the allocation of seats in the Lok Sabha among the states. And this freeze lasts until the year 2026.
And the base they used for this freeze?
The 1971 census.
1971. That was over 50 years ago. Why would you use such old data? It seems completely counterintuitive to a democracy to base representation on data from a time before most of the population was even born.
It sounds illogical on the surface, but there was a very compelling reason for it. It was all about population control and a sense of fairness. The logic was that the southern states, like Kerala and Tamil Nadu, had very successfully implemented family planning policies. They controlled their population growth. The northern states, on the other hand, were slower to do so, and their populations, well, they exploded. So if you kept updating the seat count strictly based on the current population.
The northern states would just keep getting more and more seats and more power.
Exactly. And the southern states would essentially be punished for doing a good job. They would lose seats in parliament and therefore power in Delhi because they had followed national policy and stabilized their population.
So they would lose their voice for being successful. I see the problem.
It was a huge political problem.
Okay.
So Parliament decided to hit the pause button, to freeze the representation based on 1971 levels, to give the other states time to catch up on population stabilization without completely shifting the balance of power.
And now we're approaching the end of that freeze.
We are. And this process, which is called delimitation, the redrawing of these constituency lines, is going to be a massive political and constitutional challenge very, very soon.
That is a fascinating bit of context. It really shows how everything in this structure has a very specific and often political reason behind it. Okay, let's talk about how these people actually get into the building. We have two very different ways of voting for these two houses.
Completely different systems. For the Lok Sabha, we use what's called the first-past-the-post system. It's brutally simple.
How so?
If you and I and 3 other people are running for a seat, whoever gets the most votes wins. You don't need a majority. You don't need 50% plus 1.
Yeah.
You just need one more vote than the person who came in second.
Which means you can technically win a seat even if, say, 70% of the people in that constituency voted against you, as long as that 70% was split among all the other candidates.
Precisely. It doesn't always reflect the exact vote share of a party nationwide. A party could get, say, 35% of the national vote, but end up with 60% of the seats if their vote is concentrated efficiently in the right places.
And for the Rajya Sabha, it's not that simple, is it?
Not at all. For the Rajya Sabha elections, we use a system called proportional representation by means of the single transferable vote. It's a much more complex ranking system where the MLAs voting for the candidates list them in order of preference. 1, 2, 3.
It sounds much more complicated, so why the double standard? Why not use the seemingly fairer proportional representation system for the Lok Sabha too? I mean, mathematically, it seems like having the number of seats match the percentage of votes is more democratic.
Well, the constitution makers debated this very heavily, and they rejected proportional representation for the Lok Sabha for 2 main reasons. The first was, quite simply, complexity.
You mean for the voters?
Yes. Remember, in the 1950s, India had very low literacy rates. Asking voters to understand and correctly fill out a ballot paper where you have to rank your preferences like 1, 2, 3, 4 was seen as a recipe for a huge number of invalid votes. First past the post is easy to understand. Pick one symbol, stamp it. Or now, press the button next to it.
Simplicity was key. And the second reason, stability. Proportional representation systems tend to produce very fragmented parliaments. You end up with lots of small parties, and no single party gets a clear majority. This often leads to unstable coalition governments where tiny parties can hold the entire government hostage.
So they feared constant political chaos.
They feared coalition chaos, yes. First past the post, for all its representational flaws, tends to exaggerate the winner's margin, which more often than not produces clearer majorities and more stable governments. They essentially decided to sacrifice perfect mathematical representation for a stable, working government that could actually pass laws and govern.
That's a trade-off I hadn't really considered. Stability versus perfect representation. All right, so we have the people in the building. Now we need someone to keep them all in line. Let's talk about the referees, the presiding officers. In the Lok Sabha, that's the speaker of the Lok Sabha. They are the head of the House. They're the guardian of the powers and privileges of all the members and the House as a whole. In the official hierarchy of the country, the Speaker holds a very high position, on par with the Chief Justice of India. They are the ultimate authority within the chamber.
And they have some, well, superpowers that regular members don't have.
They do, some significant ones. First, the Speaker does not vote in the first instance on any bill or motion. They only get to vote if there's a tie. This is called the casting vote.
And the idea behind that?
The idea is to maintain their neutrality. They're not supposed to take a side. They only step in to break a deadlock, and the convention is that they should vote in a way that maintains the status quo to allow the House another chance to decide.
What about joint sittings? We talked about that mechanism for breaking deadlocks between the two houses. If they all meet together, who presides? Is it the Speaker or the Rajya Sabha chairman?
It is the Speaker of the Lok Sabha who presides over a joint sitting, not the chairman of the Rajya Sabha. That's a crucial point that gives the Speaker, and by extension, the Lok Sabha, a procedural edge in those situations.
And maybe their most potent power. They get to decide if a bill is a money bill, right?
That is perhaps their most absolute power. We'll get into why the money bill label is so important later, but for now, yes. If the Speaker certifies a bill as a money bill, Their decision is final.
Final as in?
Final as in it cannot be challenged in a court of law. It cannot be challenged by the Rajya Sabha. It cannot even be challenged by the president. It gives the Lok Sabha immense, almost total control over the nation's purse. And the speaker holds the key to that definition.
Now here is where it gets really interesting for me regarding their political affiliation. In the UK, which is the model we're following, when someone becomes Speaker of the House of Commons, they resign from their political party. They become strictly politically neutral. Do we do that here?
No, and this is a really significant deviation from the British tradition. In India, the speaker does not have to resign from their party. They are, of course, expected to be impartial and neutral in their conduct within the House, but they retain their party membership.
That must put them in a very tough spot. You're refereeing a game where your own team is playing.
It is a point of contention very often. Opposition parties frequently question the speaker's impartiality because of that lingering party tie. It's a structural challenge to the role's perceived neutrality.
What happens if the speaker isn't there, if they're ill or away?
Then the deputy speaker takes over all their duties. And if both the speaker and the deputy speaker are absent, there's something called a panel of chairpersons. It's a list of up to 10 senior members who are nominated by the speaker at the start of the session, and any one of them can step in to preside.
And what about the Rajya Sabha? Who's the referee there?
The Rajya Sabha is presided over by its chairman. But here's the big twist. The chairman of the Rajya Sabha is not a member of the House.
How does that work?
The chairman is the vice president of India by virtue of their office. It's an ex officio position. So, unlike the speaker, who is elected from among the MPs, the chairman is essentially an outsider who presides over the chamber.
So because they aren't a member, they also can't vote in the first instance, I assume.
You're exactly right. Just like the speaker, they only get a casting vote in the event of a tie.
I also saw another term in our notes, pro tem speaker. That sounds very temporary.
It is. Pro tem is Latin for the time being. Imagine a new Lok Sabha has just been elected. The old speaker's term ends immediately before the first meeting of the new House. But you need someone to preside over that very first meeting.
To swear everyone in.
Exactly. To administer the oaths to all the new members and to oversee the election of the new permanent speaker. You can't have a headless House, even for a day. Yeah. So the president appoints a pro tem speaker, and by convention, it's usually the senior-most member of the new House. Their job is ceremonial, but essential. Get everyone sworn in, get the new speaker elected, and then their role ceases to exist.
A necessary handover. Right.
Yeah.
So the machine is built, the referees are in place. Now let's turn the machine on. Let's get into the daily grind, the sessions, and the various motions. I see these terms thrown around in the news all the time. Adjournment, prorogation, dissolution. They sound kind of synonymous, but I have a feeling they are very, very different.
Oh, they're legally very distinct concepts. Let's start with the smallest one, adjournment. Adjournment is just a short break. It suspends the sitting for a specified time. It could be for a few hours, for a day, or even for a few days or weeks. This is done by the speaker. It's like calling a lunch break or just ending the day's work.
Okay, so adjournment keeps the session alive. It just pauses the work for a bit. What's prorogation then?
Prorogation is much bigger. It doesn't just end the sitting, it terminates the entire session of the House. This is done by the president on the advice of the government. When the House is prorogued, it basically goes into recess until the next session is summoned by the president. It also has the effect of wiping the slate clean for certain pending notices and bills.
And dissolution, that sounds final.
That is the death of the Lok Sabha. It ends the very life of the existing House. And a new general election must be held to form a new one. And remember, only the Lok Sabha can be dissolved. The Rajya Sabha, as we said, is a permanent House.
There's also this funny term in the notes, a lame duck session.
Yes, a lame duck session is the very last session of an existing Lok Sabha after a new Lok Sabha has already been elected in a general election. The members of that old, outgoing Lok Sabha who failed to get reelected are called lame ducks.
Why?
Because they're still sitting there, maybe finishing up some legislative business, but everyone knows they've lost the election and are on their way out. Their political power has evaporated. It's a bit harsh, but it's an accurate description.
It certainly is. Now, let's look at the daily schedule when they are in session. We have the famous question hour.
That's usually the first hour of every parliamentary sitting, from 11 a.m. to 12 p.m. And it is the primary, most potent tool for daily accountability. This is where members of parliament can ask direct questions to the ministers about the functioning of their departments. Why is this road not built? Where did this money go? Why is this policy failing? It's direct scrutiny.
And I see there are different types, starred and unstarred questions. What's the difference? Does a starred question get a gold star for being good?
Not quite. The star simply determines the format of the answer. A starred question, marked with an asterisk, requires an oral answer from the minister on the floor of the House. And because the minister is answering verbally, it allows the member who asked the question and other members to ask supplementary questions, follow-ups. It allows for a live, real-time grilling.
And unstarred?
An unstarred question gets a written answer. The minister tables a written reply, which becomes part of the official record. There's no oral discussion, and therefore no supplementary questions are allowed. It's for when you want detailed facts and figures, not necessarily a political debate.
Then, immediately after question hour comes 0 hour. This isn't actually in the rule book, is it?
No, 0 hour is a purely Indian parliamentary innovation. It's not mentioned anywhere in the rules of procedure. It's the gap that starts immediately after question hour, ends at noon, and lasts until the regular agenda for the day is taken up.
The zero time.
Exactly. In this informal time, members can raise matters of urgent public importance without giving the required 10 days prior notice. It's spontaneous, it's often chaotic, but it's a very vital safety valve for raising immediate issues that just can't wait for the formal notice periods.
It sounds a bit like the Wild West hour of Parliament.
Yeah.
Now let's talk about how the Parliament uses specific tools or motions to control the government. The big one, the nuclear option, is obviously the no confidence motion.
The ultimate weapon. Article 75 of the Constitution says that the Council of Ministers is collectively responsible to the Lok Sabha. The no confidence motion is the mechanism to test that responsibility. If a motion expressing a lack of confidence in the government is introduced.
And it needs support to be introduced, right?
Yes, it needs the support of at least 50 members to be admitted by the Speaker. If it's admitted, debated, and then passes by a simple majority, the government must resign. They have lost the confidence of the House.
And they don't even need to state a specific reason in the motion itself, do they?
No, the motion can simply state that this House expresses its want of confidence in the Council of Ministers. The reasons are given during the debate, but they don't have to be in the motion itself. It's a pure test of numbers and political trust.
How is that different from a censure motion? That also sounds pretty bad for the government.
It is bad, but it's not fatal. A censure motion is more specific. It must state the reasons for its adoption. It's usually a criticism of a specific policy or the action of an individual minister or a group of ministers. If a censure motion passes, it's a strong rebuke, a big political embarrassment for the government, but they don't automatically have to resign. It's like a powerful slap in the wrist versus the firing squad of a no-confidence vote.
We also have something called an adjournment motion.
Yes, and this is a serious one, too. It's a proposal to set aside the normal business of the House to discuss a definite matter of urgent public importance. Admitting an adjournment motion is a big deal because it implies that the government's regular business is not as important as this urgent issue. So it always involves an element of censure, of scolding the government for letting this crisis happen.
Okay, and then during the budget, we have the cut motions. These seem to be a really clever way of expressing grievances through money.
They are. It's financial accountability at a micro level. When the budget is being discussed, members can move to reduce the amount of money being asked for by a ministry, what's called the demand for grant. There are 3 types, and they're quite symbolic.
Let's go through them.
First, you have the policy cut. This represents a fundamental disapproval of the underlying policy of the ministry. The motion asks that the amount of the demand be reduced to 1 rupee.
To 1 rupee. That is incredibly insulting.
It's meant to be. It's the ultimate legislative insult. It says, we think this entire policy is worthless, so here's 1 rupee for your trouble. If it passes, it's treated as a defeat for the government.
What's the next one?
Then there is the economy cut. This is more practical. The motion suggests a specific reduction in the amount, let's say by a few crore, because the member believes that the spending proposed is wasteful or extravagant. It's a call for efficiency.
Yeah, and the third.
And finally, there's the token cut. This is where the demand is reduced by a symbolic Rs100. This isn't about the policy or the amount. It's just a procedural device to voice a specific grievance within that ministry's sphere of responsibility. It's a way to force a debate on a particular issue.
I just love the symbolism of the 1 rupee cut. It's so wonderfully petty, but so powerful.
Okay.
Let's move from these daily tools to the core production line. How laws and budgets are actually made. When a new bill is introduced, it goes through 3 readings, correct?
Yes. Every bill, whether it's an ordinary bill or a constitutional amendment, goes through 3 stages or readings in each house. The first reading is just the formal introduction. The minister asks for leave to introduce the bill. It's put on the table, and it's published in the Gazette of India. There's usually no debate at this stage.
So it's just announcing, here's the bill.
Exactly. The second reading is the most critical and substantial stage. This is where the real work happens. The bill undergoes detailed scrutiny. It might be referred to a select committee of the House or a joint committee of both houses. This is where clause-by-clause discussion happens, and amendments are proposed, debated, and voted upon.
So the second reading is where the bill gets shaped and potentially changed significantly. What about the third reading?
The third reading is basically the final vote. The debate is confined to arguments either in support of the bill as a whole or for its rejection. You can't propose any more amendments. It's a final yes or no on the bill in its amended form.
Okay, so a bill passes the Lok Sabha after 3 readings. Then it goes to the Rajya Sabha. What happens if the Lok Sabha passes a bill, but the Rajya Sabha rejects it? Or they suggest changes the Lok Sabha doesn't like? Or they just sit on it for months?
If there's a disagreement, or if more than 6 months pass without the second house taking any action, we have a constitutional deadlock. The Constitution provides a mechanism to resolve this, a joint sitting of both houses.
And who calls that?
The president summons both houses to meet in one room in the Central Hall of Parliament. And as we mentioned, the Lok Sabha Speaker presides. Now, just do the math. The Lok Sabha has 543 members. The Rajya Sabha has 245. In a vote, who almost always wins?
The Lok Sabha, just by sheer force of numbers?
Exactly. The will of the directly elected House usually prevails in a joint sitting. So the deadlock is resolved, typically in favor of the government of the day, which commands a majority in the Lok Sabha.
But this joint sitting mechanism doesn't apply to every kind of bill, does it?
No, and this is a crucial exception. Joint sittings are not applicable for 2 types of bills, constitutional amendment bills and money bills. They have their own special, more stringent procedures.
Which brings us back to the money bill. You mentioned earlier that the Speaker decides what this is, and that their decision is final. Why is this category of bills so special? What makes something a money bill?
A money bill, as defined under Article 110, deals purely and exclusively with matters of taxation, government spending from the Consolidated Fund of India, government borrowing, and so on. Basically anything to do with the government's wallet.
So the nation's purse.
Precisely. And the Constitution givers wanted the directly elected House, the Lok Sabha, to have the final say over the people's money. It's a core democratic principle, no taxation without representation. So the Rajya Sabha's powers here are severely restricted.
How restricted?
They cannot reject a money bill. They can't even amend it. They can only make recommendations. And they must return the bill to Lok Sabha within 14 days.
And if they don't return it in 14 days?
Then it is deemed to have passed by both houses in the form it was originally set by the Lok Sabha. And if the Rajya Sabha does make recommendations, the Lok Sabha is free to accept or reject any or all of them. The Lok Sabha's will is supreme.
Wow. And the president's role?
The president also has less power here. They can't return a money bill for reconsideration by the houses. Since it was introduced in the Lok Sabha with their prior permission anyway, they generally have to give their assent.
So for anything related to money, the Lok Sabha is king. Let's look at the budget process specifically. It goes through presentation, discussion, scrutiny. But then there's this term that sounds absolutely terrifying, the guillotine.
It is a procedural execution. The budget involves voting on demands for grants for every single ministry and department. This takes a lot of time, and Parliament allots a specific number of days for this process.
But they never get through it all, do they?
Almost never. Usually on the last allotted day for voting, there are still many ministries whose demands haven't been discussed at all. But the clock runs out. So the Speaker applies the guillotine. They put all the remaining undiscussed demands to vote at once without any discussion whatsoever.
So potentially billions and billions of rupees could be approved in a matter of seconds without a single word of debate.
That is exactly what happens every year. It highlights a major weakness in detailed financial control. The Parliament simply runs out of time, and a huge chunk of the budget passes completely unscrutinized for those specific departments. It's procedurally efficient, but you could argue it's fundamentally undemocratic.
That is genuinely concerning. There's also another term related to the budget, the vote on account. What is that for?
Well, the whole budget process of presentation, discussion, and passing all the bills takes until late April or even May, but the new financial year starts on April 1st. The government needs money to pay salaries, run its programs, and just keep the lights on during that 2-month gap.
And they can't just take money out of the national vault.
No, they can't withdraw a single rupee from the Consolidated Fund of India without the authority of law. The vote on account is that law. It's an advance grant from Parliament to the government, usually for about 1/6 of the total estimated expenditure, to keep the country running for those first couple of months until the full budget is passed.
A sort of provisional budget.
Right.
Right. Now, with all this happening, laws, budgets, complex motions, it's obvious that the parliament as a whole is too huge and too busy to look at every single detail. This is where the watchdogs come in, the parliamentary committees.
Exactly. Parliament is a massive deliberative body. It cannot scrutinize every government receipt or every line of a complex bill, so it delegates the detailed work to smaller committees of MPs. And probably the most important of these, financially speaking, is the Public Accounts Committee, or the PACACs.
What does the PAC do?
The PAC's main job is to examine the annual audit reports of the Comptroller and Auditor General of India, the CAG. The CAG is the supreme auditor of the government. The PAG, with the CAG acting as its friend, philosopher, and guide, goes through these reports to see how the money was actually spent. Did the ministries spend it on what they said they would? Was there waste, corruption, or inefficiency?
But isn't this all happening after the money has already been spent?
And that is the fundamental limitation of the PAC, and it conducts a post-mortem. They are looking at the body after the crime, or the expenditure has already happened. They cannot intervene while the money is being spent.
So they can't stop waste, only point it out after the fact.
Right. Also, their recommendations are only advisory. They can table a report in Parliament saying this was wrong,
Yeah.
and it can cause a political storm, but they can't force the government to fire someone or change a policy immediately.
So we have these committees, then we have privileges. MPs have certain protections to allow them to do their job, don't they?
They do. Under Article 105, the most important individual privilege is freedom of speech in Parliament. This is absolute. No member of Parliament can be dragged to court for anything they say on the floor of the House or for any vote they cast.
That allows them to speak fearlessly, I suppose.
Yes, to speak truth to power without fear of defamation suits or other legal action. They also have freedom from arrest in civil cases for a period of 40 days before and 40 days after a session of Parliament.
Civil cases only, so if they commit a crime?
Criminal cases are completely different, and preventive detention laws also apply. But for civil matters, they are shielded during that period to ensure they can attend the session and perform their duties without being harassed by civil lawsuits.
But the analysis here points out a big caveat. The Indian Parliament, for all its powers, isn't truly sovereign in the way the British Parliament is.
No, it is not. In Britain, they have a system of parliamentary sovereignty. There's a famous saying that the British Parliament can do anything except make a man a woman or a woman a man, though legally they could probably even do that now. Their power is, in theory, unlimited.
And in India?
In India, our parliament is powerful, but it is not sovereign. It is limited. First, by our written constitution. It can only make laws within the framework of the Constitution. Second, by our federal system. Parliament can't just make laws on subjects that are on the state list. And crucially, third, by the power of judicial review. The Supreme Court can strike down a law passed by Parliament if it finds that it violates the fundamental rights or the basic structure of the Constitution. The British Parliament faces no such judicial limit.
So we've built the machine, we've described the operators, and we've looked at the rule book. But the big question remains, is it effective? Our final segment here asks, is the control of Parliament over the government actually effective in practice?
This is where we have to be very realistic, and where the theory meets a much messier reality. The source material talks at length about the ineffectiveness of parliamentary control. And there are some very significant hurdles. First, the sheer size and technical complexity of modern administration. A generalist politician, an MP, simply cannot be an expert on defense, finance, technology, and health all at once.
So they lack the technical expertise to effectively challenge the bureaucrats who live and breathe this stuff every day.
Exactly, and we've already mentioned the guillotine.
Which makes a mockery of detailed financial scrutiny for many ministries.
It does. Then there's the massive growth of what's called delegated legislation. Parliament will pass a skeleton law, a broad framework, and then delegate the power to the bureaucracy to write the detailed rules and regulations. This effectively shifts a huge amount of lawmaking power from the elected legislature to the unelected executive.
What about the role of the opposition? In the UK, they have a formal shadow cabinet.
Right. In the UK, for every minister, the opposition party appoints a shadow minister whose job is to become an expert on that specific portfolio. to critique the government effectively, and to be ready to take over at a moment's notice. We have no such structured system in India. The opposition critiques and can be very effective, but often without that specialized shadow preparation.
But the Rajya Sabha still plays a role here, doesn't it? It's not just a rubber stamp, especially when the government doesn't have a majority there.
Absolutely. The Rajya Sabha often serves as that vital cooling chamber or a revising house. If the Lok Sabha, riding on a wave of populism or a massive majority, tries to pass hasty or poorly thought-out legislation, the Rajya Sabha can slow it down, force a debate, and suggest important amendments. It also serves its primary function of protecting the interests of the states against potential overreach by the center.
The source also makes a quick mention of a youth parliament scheme.
Yes, that's a wonderful scheme run by the Ministry of Parliamentary Affairs. It aims to train the younger generation in the procedures, the discipline, and the tolerance required for a functioning democracy. It's an attempt to build a future generation of citizens and parliamentarians who understand these complex rules we've just spent all this time discussing.
So to try and bring this all together, we've gone from the simplicity of first past the post elections through the labyrinth of question hour and the chaos of 0 hour, past the brutal efficiency of the guillotine, and into the detailed post-mortem work of the committees.
And what we see is that while the system is robust on paper, in practice, it is very heavily weighted towards the executive, towards the government of the day, especially government with a strong majority in the Lok Sabha.
Which brings us to our final provocative thought for you, the listener, to take away from this deep dive.
I want you to think about that concept we discussed, the post-mortem nature of most financial control. If Parliament largely only gets to check where the money went after it has already been spent, and if the executive, the Prime Minister, and the Cabinet commands a massive majority in the Lok Sabha, which allows them to pass bills, win confidence votes, and control the daily agenda, then does the Parliament truly control the government? Or, in reality, does the government now control the Parliament?
That is a very heavy and very important question to end on. Next time you watch the news and see the proceedings, maybe see the members shouting in the well of the House, remember, it's all part of this massive, intricate, and yes, slightly imperfect machinery. Maybe try to catch the next question hour. You might just see it with fresh eyes now. Thanks for diving in with us.
Thank you. Keep learning.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It certainly is. We're leaving the theoretical frameworks behind now and stepping right into the machinery room of the Indian state.
The machinery room, I like that.
Yeah, we're looking at the judiciary, the guardians of the law, and then the state executive, the actual machinery that runs the provinces day to day.
And usually when we talk about machinery, it sounds a bit dry, a bit, I don't know, technical. But looking at the outline for this deep dive, this seems more like a battlefield.
That's a very good way to put it.
I mean, we've got the Supreme Court wresting power away from the executive, governors getting fired en masse when governments change. It's a constant tug of war over who actually holds the keys to the Constitution.
That is a very, very accurate way to frame it. It's less about static rules and more about, well, dynamic power struggles. So our mission today is to decode that.
Yeah.
We'll start with the structural hierarchy of the Supreme Court. Then look at the controversial evolution of how judges are appointed, which is, I mean, a saga in itself.
Right.
And then we'll shift gears to the state level to see how the governor and the chief minister operate in this complex system.
Let's start at the top then, the Supreme Court. Now, coming from a background of looking at different democracies, I always sort of assumed federal countries work a certain way. In the U.S., for example, you have a really clear split. Federal courts for federal laws, state courts for state laws. If you break a Texas law, you go to a Texas court. Simple.
Right. That is the classic dual system of courts. The U.S. has that. But India does not.
Which is surprising, isn't it, given how much we talk about federalism in India?
It is. It really is. India has what we call a unified judicial system. The best way to think about it is like a single giant pyramid.
Okay, pyramid.
At the very, very apex, you have the Supreme Court. Directly below them are the high courts, one for each state or group of states. And then below them, you have the subordinate courts.
So it's a strict hierarchy, top down.
Strictly vertical. And the crucial difference from the U.S. is that this one single system enforces both central laws and state laws.
Oh, that's the key.
That's the key. So whether you violate a law passed by Parliament in New Delhi or, say, a local act passed by the Tamil Nadu Assembly, you're operating within this one single judicial ecosystem.
So a high court judge isn't just a state judge in the American sense. They're part of a much larger national structure.
Exactly. They are part of the Indian judiciary, full stop. This concept was actually adopted from the Government of India Act of 1935.
Ah, a holdover from the British era.
It is. The logic back then, and it continues today, was to ensure uniformity. They didn't want, different interpretations of justice and law popping up in different provinces.
And the Supreme Court sits on top of this whole pyramid. It was inaugurated pretty much alongside the Republic, right?
Just 2 days later, January 28, 1950, it succeeded the old federal court. But here's an interesting little nuance regarding its power. Before independence, the highest court of appeal for India wasn't actually in India.
Right, you had to go to London, the Privy Council.
Precisely. The Privy Council in Britain, the colonial overlords holding the final gavel, as you might say.
So when the Supreme Court was established, was its power just a copy-paste of the Privy Councils?
Actually, no. And this is important. Its jurisdiction, its authority to hear cases, was deliberately made wider than both the old federal court and the Privy Council. It was designed from day one to be the ultimate arbiter, with absolutely no foreign body above it.
Okay, let's look at the composition then. I think most people imagine this, grand bench of judges, but the numbers themselves have changed quite a bit over time.
Drastically. I mean, if you walked into the Supreme Court in 1950, it was a fairly intimate club. You had the Chief Justice and just 7 other judges.
Only 8 total.
A total strength of 8. That seems incredibly small for a country the size of India, even back in 1950.
I'll say.
It was. And as the population exploded and the legal system became more accessible and, frankly, a lot more complex, that number just had to grow. Parliament has the power to increase the number of judges.
So they've been adding seats over the years.
Periodically, yes. They bumped it to 10 in 1956, then 13, 17, 25. And as of the latest amendment in 2019, the strength is now 34. That is 1 Chief Justice plus 33 other judges.
34 judges. It sounds like a lot, but considering the backlog of cases we always hear about, it probably still feels understaffed.
It often is.
However, I want to get to the real meat of the matter. The numbers are one thing, but who picks these 34 people?
You have just identified the single most controversial, most thought-over question in the entire history of the Indian judiciary.
It seems like it should be a simple enough process on paper. The president appoints the judges.
On paper, yes. The Constitution says the president appoints judges after consultation with the Chief Justice of India, or the CGI.
Consultation. That's a very polite, very non-threatening word. If I consult you on where to get dinner, I'm asking your opinion. I'm not legally bound to eat where you say.
And that is exactly how the executive, the government, the politicians interpreted it for decades. But the judiciary, well, they eventually decided that they didn't like being just consulted.
Right.
This led to a series of landmark cases known as the 3 Judges cases that completely rewrote the dictionary.
Okay, you have to walk us through this. Because this sounds, to be frank, like a power grab.
It's a fascinating evolution. It all starts with the first Judges case in 1982. At this point, the Supreme Court was, let's say, relatively submissive. They ruled that consultation means merely an exchange of views.
So not binding.
Exactly. It does not mean concurrence or agreement.
So in 1982, the court basically said, yes, the government can ignore the Chief Justice's advice.
Effectively, yes. This gave the executive the clear upper hand in judicial appointments.
Yeah.
But you have to remember the context. This is the post-emergency era. The judiciary had been bruised and its confidence was low.
Okay.
But fast forward to 1993, the second Judges case. The court pulls a complete 180-degree turn.
What changed?
They overruled their earlier judgment. They held that consultation actually means concurrence.
Wait, hold on a second. They ruled that the word consultation literally means agreement.
Legally, yes. In the context of judicial appointments, they ruled that the advice tendered by the Chief Justice is binding on the president. The president cannot appoint someone the CGI has not recommended.
That is some serious linguistic gymnastics. They effectively seized the power of appointment right out of the government's hands.
They did. The justification was the independence of the judiciary. They argue that the executive, who is a litigant in most cases before the court, shouldn't have the final say on who the judges are.
Okay, that logic makes some sense.
But they did add a check. The CGI can't just act like a dictator. He must consult his 2 senior-most colleagues.
So it went from the government decides to the CJI and his 2 friends decide.
And then came the third Judges case in 1998. This didn't change the power balance so much as it expanded the circle. It established what we now call the collegium system.
The collegium. We hear that word all the time.
This is where it comes from. The court ruled that the CJI must consult the 4 senior-most judges. And here's the kicker. If even 2 of those judges disagree with a name, the CJI cannot send that recommendation to the government.
So this is the collegium. A closed club of the top 5 judges hiring the next generation of judges. It sounds incredibly insular.
It is unique. India is the only major democracy where judges appoint judges. In the U.S., the president picks and the Senate confirms. In the UK, there's an independent commission. But in India, the judiciary successfully walled itself off.
But the government didn't just take this lying down, did they? I seem to recall the NJJC controversy a few years back.
Oh, they definitely fought back. In 2014, Parliament passed the 99th Constitutional Amendment with almost unanimous support from all political parties.
A rare sight.
Very rare. They wanted to replace the collegium with something called the National Judicial Appointments Commission, or NJC.
And what was the pitch? Let's make this more democratic.
The pitch was transparency and accountability. The NJJC was supposed to be a mixed body. It would have the CJI and senior judges, yes, but also the union law minister.
A politician.
A politician. And 2 eminent persons selected by a committee that included the prime minister. So yes, it was about giving the executive a foot back in the door.
And the Supreme Court's reaction.
They slammed that door shut. Hard. In 2015, in what's now called the 4th judge's case, the court struck down the NJJC as unconstitutional.
They struck down a constitutional amendment, one passed by the elected parliament.
They did. They argued that the independence of the judiciary is a basic feature of the Constitution, and having the law minister, an active politician on the Appointments Commission, was seen as a fundamental threat to that independence.
So the NJJC died, and the old collegium system just came right back.
It was restored.
That is a massive flex of judicial power. It's essentially saying, we interpret the Constitution, and we say you can't change the Constitution to touch us.
It creates a lot of friction. Critics will tell you it's undemocratic, a self-perpetuating oligarchy. Supporters will say it's the only thing stopping politicians from packing the courts with yes men.
Speaking of yes men, what about the Chief Justice of India specifically, the big boss? Is that appointment also part of this collegium game, or is there a different rule for the top job?
For the CJI, there is a very strict convention, the seniority rule.
Simple as that. The oldest one gets the job.
Not oldest, but the one who has been on the Supreme Court bench the longest. The senior-most judge of the Supreme Court automatically becomes the Chief Justice upon the retirement of the incumbent.
Is that an ironclad rule? Or have politicians tried to mess with that too?
It is ironclad now, but only because it was violated so spectacularly in the past.
When was this?
In the 1970s, during the tenure of Prime Minister Indira Gandhi, the convention was broken twice. The 70s really were the Wild West for the Indian Constitution.
It seems that way.
Indeed. In 1973, the government appointed Justice A.N. Ray as CJI. To do that, they had to supersede or, skip over 3 judges who were senior to him.
And why would they do that?
Because those 3 judges had just delivered a landmark ruling against the government in a major case.
So it was a punishment, rule against us, and you don't get the promotion.
That was the clear message. And they did it again in 1977 when Justice M.U. Beg was appointed, superseding one senior judge. This created a huge outcry about a committed judiciary, judges committed to the ruling party, not the Constitution.
So how was it fixed?
That's why the second judge's case in 1993 was so important. It didn't just create the collegium for other judges. It specifically codified the seniority rule for the CJI. Now the government has no choice. The senior-most judge must be appointed.
Okay, so we know how they get the job. But who are these people? What are the qualifications? I assume you need to be a high court judge for a long time first.
Usually, yes. That's the most common path. But the Constitution is actually quite a bit more open. To be a Supreme Court judge, you must be a citizen of India, obviously. Then you need to meet one of 3 criteria.
Okay, what are they?
1, you've been a high court judge for at least 5 years.
That's the standard path.
2, you've been an advocate, a lawyer, in a high court for at least 10 years.
So you can go straight from the bar to the Supreme Court bench.
You can. It's less common, but it happens. Justice Indu Malhotra was a recent example of being directly elevated from the bar. But there is a third category that I find fascinating. It's a great point for anyone studying this closely.
Go on.
You can be appointed if you are a distinguished jurist in the opinion of the president.
A distinguished jurist? What does that even mean? A top law professor, a brilliant legal scholar?
Theoretically, yes. Someone with profound legal knowledge who hasn't necessarily practiced in court or served as a judge.
Yeah.
But here's the catch. This provision has, for all practical purposes, never been used for the Supreme Court. It just sits there in the Constitution, unused.
a power that's never been switched on. Now, here's a little trivia question for you. Is there a minimum age? Do you have to be at least, say, 45 or 50?
You would think so, wouldn't you? It seems logical. But legally, no. The Constitution specifies no minimum age for appointment.
That's surprising. So technically, a 25-year-old legal prodigy could be a Supreme Court judge.
Well, they'd somehow have to rack up 10 years of practice as an advocate, which is impossible at that age.
Yeah.
But yes, purely on the age metric, there's no floor. However,
Mhm.
practically speaking, because of the experience requirements, most judges are in their late 50s or early 60s when they're finally appointed.
And they retire at 65.
Correct. No life tenure like in the U.S. Supreme Court. They serve until the age of 65.
Now let's talk about the dark side. Removal. Impeachment. We've seen judges in lower courts get into trouble. But has a Supreme Court judge ever actually been fired?
The short answer is no. No Supreme Court judge has ever been successfully impeached and removed from office.
Really? Never. Is that because they're all saints? Or because the process is basically impossible?
It's because the process is a fortress. The Constitution makers wanted judges to be fearless, so they made firing them incredibly, incredibly hard. You can only remove them on two grounds: proved misbehavior or incapacity.
Proved being the operative word there.
Absolutely. And the process of proving it is complex. Under the Judges Inquiry Act of 1968, you first need a removal motion signed by 100 members of the Lok Sabha or 50 members of the Rajya Sabha.
That's a high bar just to start the paperwork.
It gets higher. The Speaker of the House or the Chairman of the Rajya Sabha can simply refuse to admit the motion. Just say no.
So it can die before it even starts.
Exactly. But if they do admit it, they have to form a 3-member committee to investigate the charges.
And who is on this committee?
It has to be the CJI or another Supreme Court judge, a Chief Justice of a high court, and a distinguished jurist.
So the judiciary gets to investigate its own members.
Precisely. If that committee finds the judge guilty, only then does it go back to the House for a vote. And it's not a simple majority. It requires a special majority.
What does that entail?
That means a majority of the total membership of the House A&D, a majority of 2/3 of the members present and voting.
So you need a massive political consensus to fire one judge.
And we came close only once. The case of Justice V. Ramaswamy in the early 1990s, the inquiry committee actually found him guilty of financial irregularities, misusing public money for his official residence.
So proved misbehavior was established. The condition was met.
It was. But when the motion went to the Lok Sabha for the vote, the ruling party at the time, the Congress Party, abstained from voting. They just sat out.
They didn't vote yes or no.
They didn't vote at all. And because of that, the motion didn't get the required 2/3 majority, and it failed. He was never removed.
So even if you're found guilty, if the politics of the day are on your side, you can stay.
Well, the public pressure and stigma are usually enough to force a resignation in such cases, but technically, yes, the impeachment mechanism is extremely rigid.
Briefly, before we move to their powers, the money, I heard they got a raise a few years ago.
They did in 2018. The Chief Justice now gets 2.80 lakh per month, and the other judges get 2.50 lakh. Plus, of course, an official residence, car, security, and a pension of 50% of their last drawn salary. It's all designed to ensure they are financially secure and hopefully incorruptible.
Let's shift to what they do with all this security and power. Two big concepts always come up here: judicial review and judicial activism. Let's start with review. This is the power to strike down laws, correct?
That's right. Judicial review is the judiciary's power to examine the constitutionality of any legislative act or executive order. If Parliament passes a law that violates the fundamental rights in the Constitution, for instance, the Supreme Court can declare it void.
And is this an Indian invention?
It actually originated in the U.S. in the famous 1803 case Marbury v. Madison. But the Indian Constitution explicitly grants this power in several articles. And the Supreme Court has gone a step further. It has declared judicial review to be a basic feature of the Constitution.
There's that phrase again, basic feature, meaning even Parliament can't pass a constitutional amendment to take this power away.
Exactly. The judiciary is the final interpreter and guardian of the Constitution.
But then we have judicial activism. This feels different. Review is checking if a law is legal. Activism feels like judges making the law.
That is the core of the debate, yes. Judicial activism is when the judiciary steps out of its traditional role of merely interpreting the law and takes a more proactive role in protecting citizens' rights, sometimes even directing the government on policy matters.
Where did this come from?
The term is American, coined by Arthur Schlesinger Jr. way back in 1947. But in India, it really exploded in the mid-1970s and 80s. Justices like V.R. Krishna Iyer and P.N. Bhagwati are the titans here.
And what was their thinking?
They looked at the state of India, the crushing poverty, the illiteracy, the apathy of the executive branch, and decided that judicial restraint, which is just sticking to the strict letter of the law, wasn't enough.
They felt they had to intervene because the government wasn't doing its job.
Precisely. The philosophy is that if the legislature and the executive fail in their duties, the judiciary must step in to protect the people. But this led to the invention of perhaps the most powerful tool in the Indian legal arsenal, the PIL.
Public interest litigation. We hear this term constantly. Someone filed a PIL. How did that change the game?
It completely changed the ancient legal concept of locus standi.
Locus standi, Latin for a place to stand, or your right to bring a case.
Right. The old rule was only the person who is directly injured or whose rights are violated can go to court. If I punch you, you have to sue me. Your neighbor can't sue me on your behalf.
Which makes sense in a society where everyone has equal access to the courts, but in a country where millions are too poor or uneducated to even know their rights.
Exactly. The old rule meant that the vast majority of the poor had no real access to justice. So Justice Bhagwati and others relaxed this rule. They said, any public-spirited person or any social action group can approach the court on behalf of those who cannot approach it themselves.
That is a revolutionary idea. It basically crowdsourced justice.
It did. Take the famous Hussainara Khatun case. A lawyer filed a PIL based on nothing more than a newspaper report about under-trial prisoners rotting in Bihar jails for years, often longer than their actual sentences would have been.
And what happened?
Because of that one PIL, about 40,000 such prisoners were released from jails across India. That is the power of PIL.
That's the hero side of the story. But I have to play the skeptic here. Doesn't this open the floodgates? I mean, can't people just file PILs for publicity?
Oh, absolutely. And they do. The Supreme Court has had to issue strong warnings against what they call publicity interest litigation or private interest litigation.
Or my personal favorite, PESA interest litigation.
Yes, people filing suits to extort money from companies or to settle corporate or political scores. The courts have to be very careful to filter out the noise. And there's also the bigger criticism of judicial overreach.
The court trying to run the country?
Exactly. Deciding everything from how to manage the COVID-19 pandemic to how to run the National Cricket Board. The Supreme Court itself cautioned in 2007 that courts shouldn't take over executive functions. It's a very fine line to walk.
When does the guardian of the law become the nanny of the state?
That is the eternal tension.
Okay, let's leave the marble halls of the Supreme Court for a bit and travel to the often chaotic world of state politics. We're moving from the unitary judiciary to the federal executive.
This is where things get messy and very political.
We have two main characters here at the state level, the governor and the chief minister. Let's start with the governor. In school, I was always taught the governor is just a figurehead, a ribbon cutter, basically.
That is the polite fiction we're all taught. The governor is the constitutional head of the state, yes. But their role is fundamentally dual. They are the head of state, but they are also the agent of the central government.
Agent. That sounds like something out of a spy movie, but it implies they work for Delhi.
They are appointed by the president, which, in practice, means the prime minister and the cabinet in Delhi. And crucially, they hold office during the pleasure of the president.
Which means they can be fired whenever the central government feels like it.
Yes. And history shows this power has been, well, weaponized.
Give us an example.
Look at 1989. The VP Singh government came to power at the center, defeating Congress. They wanted their own people in the states, so they asked for the resignation of all governors who had been appointed by the previous Congress government.
They just cleaned house, sacked them all.
Wholesale removal. And the irony. When the Congress Party returned to power in 1991, they did the exact same thing to the governors that VP Singh's government had appointed.
So much for being a neutral, independent constitutional head. They are treated like political employees of the party in power at the center.
The Supreme Court did try to fix this. In a 1979 ruling, it clarified that the governor's office is an independent constitutional office, not subordinate to the central government, but practically. If the president, meaning the center, wants you gone, you are gone.
Let's talk about their powers. We know they sign bills into law, But the governor has a special card up their sleeve regarding state laws, don't they? Something the president can't do with central laws.
Yes, and this is a major point of friction in center-state relations. When a state assembly passes a bill and sends it to the governor, they have four options. They can give assent, withhold assent, or return it for reconsideration. But the fourth option is the nuclear one.
Which is?
They can reserve the bill for the consideration of the president.
So they can take a law passed by an elected state legislature and just send it to the central government for approval?
Exactly. This is mandatory if the bill endangers the position of the state high court. But they can use this power for other reasons, too. It effectively gives the center a veto over state legislation.
That seems like a massive loophole in the idea of federalism. If a state wants to pass a law the center hates, the governor can just freeze it by sending it upstairs to the president.
That is a very common complaint from opposition-ruled states. They see the governor's office as a tool to thwart the will of the state legislature.
What about pardoning power? We know the president of India can pardon a death sentence. Can the governor save someone from the hangman's noose?
No. That is a crucial distinction and something that often comes up. The governor can pardon, suspend, or remit sentences for offenses against state laws. But the governor cannot pardon a death sentence?
Even if the crime was under a state law.
Even then.
Yeah.
Only the president has the power to pardon a death sentence. Also, the governor cannot deal with sentences from a court-martial. That's military jurisdiction, so it's only the president.
So the governor has significant power, but it's often controlled by or limited in comparison to the center. Now let's look at the person who actually has to win elections, the chief minister.
The real executive. If the governor is the nominal constitutional head of state, the CM is the real head of government.
The state-level equivalent of the prime minister.
Exactly. The governor appoints the CM, but they're almost always bound by convention to pick the leader of the party or coalition that has a majority in the assembly.
Unless there is no clear majority.
Then it gets very interesting. In the case of a hung assembly, the governor can use their discretion. They can invite the leader of the single largest party or a post-poll coalition and say, okay, you have 1 month. Go and prove you have the numbers on the floor of the House.
And that 1 month usually involves a lot of what the media calls resort politics and horse trading.
Unfortunately, yes, that has become a feature of our politics.
Here's a quirk I found in the notes, which seems incredible. Can you be a chief minister if you aren't even a member of the assembly? Can I just walk in off the street and be appointed CM?
If the majority party MLAs choose you as their leader, yes. We call it the non-member rule. A person who is not a member of the legislature can be appointed chief minister.
But surely there's a timer on that. You can't just do that forever.
There is. You have 6 months. You must get yourself elected to the state legislature within 6 months of being appointed. If you fail to do so, you lose the job.
Has anyone actually used this route?
Oh, many times. It's often used to parachute a national leader into a state leadership role. Bansi Lal in Haryana is a classic example from the past. Morarji Desai in the old Bombay state. Even in recent times, we see leaders taking the oath first and then fighting a by-election to enter the assembly.
And the CM doesn't work alone. They have their Council of Ministers. And I noticed there's a specific constitutional requirement for some states to have a tribal welfare minister.
Yes, this is a special mandate for states with large tribal populations. The Constitution names 4: Chhattisgarh, Jharkhand, Madhya Pradesh, and Odisha.
Why those specific states?
Because the welfare of the scheduled tribes is seen as a special constitutional responsibility of the state government in those regions. Interestingly, Bihar used to be on this list.
What happened to Bihar?
The 94th Constitutional Amendment removed it from the list. The reason is simple. The tribal-dominated areas of southern Bihar were carved out in the year 2000 to create the new state of Jharkhand. So Bihar no longer needed the mandate, but the new state of Jharkhand certainly did.
That makes perfect sense. Finally, let's touch on responsibility. In a system like the UK's, ministers have what's called legal responsibility. They have to personally sign off on official acts and can be held legally accountable. What about in India?
No legal responsibility. An Indian minister does not need to countersign the governor's official orders. And very importantly, the courts are barred from inquiring into the nature of the advice the ministers gave to the governor.
So the advice given in a cabinet meeting is a complete black box.
It's protected to ensure the confidentiality and candor of cabinet discussions. But they do have collective responsibility to the Legislative Assembly, meaning the entire Council of Ministers is treated as one single unit. If the chief minister resigns, or if they lose a vote of no confidence, the entire council resigns. They swim or sink together.
It's a high-stakes team sport.
It absolutely is.
So let's just zoom out for a moment. We have covered a huge amount of ground here. We started with the unified Supreme Court, this massive, powerful pyramid that has fought tooth and nail for its independence.
To the point of striking down constitutional amendments to protect its appointment process.
Right. And we saw how they expanded their own role through things like PILs, becoming a voice for the voiceless, while constantly risking that accusation of overreach.
And then we move to the states. Here, the governor walks this very fine tightrope between being a constitutional head and an agent of the center, and often falls off that tightrope during political crises.
And finally, we have the chief minister, who holds the real on-the-ground power, but has to constantly navigate the numbers game in the assembly and the complex relationship with the governor.
It paints a picture of a system that is robust, for
Yeah.
sure, but one that is constantly vibrating with tension. The judiciary versus the executive. The center versus the state.
And that tension is arguably what keeps the democracy alive and dynamic. If everyone agreed all the time, we might actually be in trouble.
That's a great way to put it.
Which leads me to a final provocative thought for you, our listeners, to mull over. We talked at length about the basic structure doctrine, this idea that the Supreme Court can strike down amendments passed by a democratically elected parliament like they did with the NJAC.
The ultimate judicial veto.
So the question is this: where does the ultimate sovereignty truly lie in India? Does it lie with the parliament, the body elected by the people with the mandate to write and change the laws, including the Constitution? Or does it lie with the unelected judiciary who claim the final right to say, no, you can't change that part?
It really boils down to, is the Constitution what the people, through their representatives, say it is?
Huh.
Or is it what the judges say it is?
Is this the perfect balance for protecting democracy from the tyranny of the majority? Or is it a fundamental friction point where the will of the people can be vetoed by the wisdom of a select few? We will let you think about that.
It is the debate that defines much of our constitutional history.
Thanks for taking the deep dive with us. We'll see you next time.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It absolutely is. Most people, when they study Indian polity, they kind of stop at the parliament in New Delhi.
Right.
They get the prime minister, the Lok Sabha, the president. But if you start there, you're essentially looking at the steering wheel of a car while totally ignoring the engine, the transmission, the wheels.
I like that analogy. You might know where the car is pointed, but you have no clue what's actually making it move.
Exactly.
And that is a perfect framing for what we're doing today. We're shifting our gaze away from the center. We're climbing down that ladder, or maybe digging into the foundations to look at the machinery of the state legislatures, the judiciary's hierarchy, and that massive, sprawling giant local self-government.
This is really where the rubber meets the road. We're going to unpack how power is carved up and distributed in the states, how justice is administered, or sometimes, delayed from the high courts down to these mobile village courts.
And then the big one, how democracy actually functions, or at least tries to function, at the grassroots level with panchayats and municipalities.
Right. And it's important to understand why this matters. This isn't just about memorizing rules for a test. It's about understanding how the Constitution tries to balance power and make sure justice reaches the common citizen, whether they're in a high-rise in Mumbai or some remote hamlet in a tribal belt. It's the real architecture of governance.
Okay, so a heads up for everyone listening, especially the learners out there prepping for exams. This is going to get heavy on the structural details. We're talking specific articles, constitutional amendments. We're not just skimming the surface today.
No, we are definitely not.
So let's start at the state level. The state legislature, I think the common assumption is that it's just a copy-paste of parliament. A lower house, an upper house, and a governor who's like a mini president.
And, in many ways, they do mirror parliament. The framework is laid out in Articles 168 to 212, but there is a massive difference right at the start, and that's about bicameralism.
Having two houses.
Exactly. At the center, the Constitution mandates two houses, Lok Sabha and Rajya Sabha. It's non-negotiable. But in the states, uniformity is just not the rule.
Right, because most states in India are unicameral. They just have one house, the Legislative Assembly, the Vidhan Sabha.
But the Constitution leaves the door open for a second house, the Legislative Council, or Vidhan Parishad.
And that list of states with two houses, it's a very exclusive club. It's a classic exam question because it keeps changing.
It really does. As of right now, we are looking at 6 states: Andhra Pradesh, Telangana, Uttar Pradesh, Bihar, Maharashtra, and Karnataka.
I feel like that list used to be longer. Jammu and Kashmir was a prominent member for a long time, wasn't it?
It was. But that seat at the table, it was removed. The Jammu and Kashmir Legislative Council was abolished by the J&K Reorganization Act of 2019.
So when the state was reorganized into union territories, the council just dissolved.
That's it. So we're down to 6.
What's fascinating to me about the Legislative Council is that it seems to be subject to political whims. I mean, look at Tamil Nadu.
Oh, Tamil Nadu is the classic case study. It's this on-again, off-again relationship with the upper house. They had one, then they abolished it back in 1986.
Right.
Then, decades later in 2010, a new government came in and passed an act to revive it. They wanted it back.
And then what happened?
Well, the government changed again, a rival party came to power, and the proposal just stalled. It was never actually implemented. So it's in this, constitutional limbo.
This inconsistency just begs a structural question. How does a state actually get a council or get rid of one? I mean, it's not as simple as the chief minister just signing an order, is it?
No, and this is where the Constitution gets very, very technical. It's a tag team effort between the state and the center. Parliament has the final say, but it can't just act on its own.
It needs a trigger from the state.
Precisely. The state legislative assembly, the lower house, must pass a resolution formally requesting it.
And I'm guessing that resolution needs more than just a casual aye.
Definitely. It requires what's called a special majority.
Okay, let's define that because that term gets thrown around a lot.
It's a double lock. First, you need a majority of the total membership of the assembly, not just who's there on the day.
Right.
And second, you need a majority of not less than 2/3 of the members who are actually present and voting. So it's a really high bar. The idea is to make sure there's a genuine broad consensus in the state for this.
Okay, so the state clears that very high bar. They
Yeah.
send the resolution to Delhi. What does Parliament do? You'd think, since you're changing the structure of a state's legislature, it would need a full-blown constitutional amendment under Article 368.
You would think that. Logically, it makes perfect sense. But the Constitution throws a curveball here.
It often does.
Parliament passes this creation or abolition as just ordinary legislation.
You're kidding. So just a simple majority.
Just a simple majority. And Article 169 explicitly says that this act is not to be considered an amendment to the Constitution for the purposes of Article 368.
That is a fascinating nuance. So it's incredibly hard for the state to start the process. But technically, very easy for Parliament to approve it once the request arrives.
Exactly.
But why did the Constituent Assembly even make it optional? I mean, why not just have 2 houses everywhere for better deliberation?
Well, there is a fierce debate about this. A lot of members of the Constituent Assembly were very critical of the idea.
On what grounds?
They felt legislative councils would be dilatory, that they would just delay important laws without adding much value. They also argued it was just too expensive for the poorer states to maintain.
And the other criticism I always hear is that it's a backdoor for politicians.
Precisely.
Yeah.
That was a huge concern, that it would just become a parking lot for politicians who couldn't win a direct election, a way to get unelectable leaders into the government.
So they left it to the financial and political will of each state.
If you can afford it and you genuinely want it, you can have it. If not, stick to one house.
Speaking of that backdoor argument, let's look at who actually sits in these councils. Because the composition, it's not just people the governor likes. It's a very complex formula.
It's a real mixed bucket of representation. It's designed, in theory, to bring in different voices from society, not just career politicians.
Okay, let's unpack the fractions.
Yeah.
How is the council composed?
All right. First, 1/3 of the members are elected by local bodies. So members of municipalities, district boards, they get to vote for their own representatives in the state's upper house.
That creates a direct link between local and state government.
It's meant to. Then another 1/3 are elected by the MLAs of the Legislative Assembly.
Okay.
But importantly, this is done through proportional representation, so it's not winner take all. The opposition gets to send people too.
So that's 2/3 of the seats covered. What about the final third?
Yeah.
This is where it gets really unique.
It does. This is where we get into this sort of guild concept. 1/12 of the members are elected by graduates.
Graduates, you mean anyone with a degree?
Anyone who's been a graduate for at least 3 years and lives in the state. They have their own constituency. It's called a graduate's constituency.
Wow. That's a very specific vision of democracy, giving extra weight to the educated class.
And similarly, another 1/12 are elected by teachers.
Also with specific rules.
Yes, they have to have been teaching for at least 3 years in institutions that are not lower than a secondary school. So you have a teacher's constituency.
So we have local bodies, MLAs, graduates, and teachers. Who covers the rest?
The remainder, which is about 1/6, is nominated by the governor. And these are supposed to be people with special knowledge or practical experience in literature, science, art, social service, and this is a very Indian addition, the cooperative movement.
That cooperative movement part is so important. In states like Maharashtra or Karnataka, the cooperative sector is a massive economic and political force.
A huge force. So while critics call it a backdoor, the proponents argue this structure brings in seasoned professionals, artists, and grassroots leaders who might not have the money or muscle to fight a direct election.
Okay, moving quickly to the Legislative Assembly, the Vidhan Sabha. This is the real powerhouse, right? Direct elections, popular mandate. Are there strict limits on how big or small these can be?
There are constitutional guardrails. Generally, the assembly shouldn't have more than 500 members or fewer than 60.
But India is so varied, some states are tiny.
And that's why Parliament has made exceptions. States like Sikkim, Goa, Mizoram, their minimum limits are set lower than 60 to accommodate their smaller populations.
And can't forget the social justice component here.
Absolutely not. Article 332 is crucial. It mandates the reservation of seats for scheduled castes and scheduled tribes in the assembly based directly on their population ratios in that state.
So the demography of the state is reflected in the legislature.
That's the goal.
That covers the lawmakers. Now let's shift gears to the institution that interprets those laws. The judiciary, the high courts.
The guardians of state law. And it's worth noting, this institution is actually older than the current political map of India.
Right, it's a colonial legacy.
It is. The high court system goes all the way back to 1862. The British established the first ones in Calcutta, Bombay, and Madras. Allahabad followed a few years later.
And after 1950, they just evolved into the state high courts we know today.
Correct. Now, one topic that always generates a lot of friction is the appointment, and especially the transfer of judges. It often looks like this tug of war between the judiciary and the executive.
So how does a high court judge actually get moved from, say, Madras to Allahabad? Who makes that call?
This is a highly sensitive area. For a long time, there was this fear that the government could use transfers as a weapon to punish independent judges.
Right.
But the third judge's case in 1998 really solidified the current process. The Supreme Court made it very clear. The Chief Justice of India cannot just wake up and decide to move a judge on his own.
It's not a solo decision. It needs a consensus.
It needs the collegium.
Yeah.
The Chief Justice of India must consult a collegium of the 4 senior-most judges of the Supreme Court. But the consultation doesn't even stop there.
Who else is involved?
They also have to consult the Chief Justice of the High Court, where the judge is coming from, and the Chief Justice of the High Court, where the judge is going to.
So it's a multi-layered check.
Exactly.
Yeah.
It's designed to filter out any arbitrariness and ensure transfers are done for the administration of justice, not for, political convenience.
Okay, now let's talk power. This is where it gets really interesting for anyone studying the Constitution. There's a common misconception that the Supreme Court is more powerful in every single aspect. But there's one specific area where the High Court actually has a wider scope.
You're talking about writ jurisdiction. This is a favorite question for constitutional scholars.
It is.
Under Article 32, the Supreme Court can issue writs habeas corpus, mandamus, all of those, but only for the enforcement of fundamental rights. That's the boundary. If your fundamental right isn't violated, you generally can't go straight to the Supreme Court under Article 32.
But the High Court operates under a different article, Article 226.
Correct. And Article 226 empowers the High Court to issue those same writs for fundamental rights. And here's the magic phrase: for any other purpose.
For any other purpose. That sounds like such a small addition, but legally that must be an ocean.
It is massive. It means the High Court can issue writs to enforce ordinary legal rights, contractual rights, statutory rights. Say the government messes up your pension calculation. That's not really a fundamental right violation.
Right, it's just an administrative error.
But you can go to the High Court for a writ to get it fixed. You couldn't necessarily go to the Supreme Court under Article 32 for that. So in that very specific sense, the High Court's writ jurisdiction is wider.
That's a critical distinction. The High Court is also sort of the administrative boss of the entire state's judiciary, isn't it?
It has what's called supervisory jurisdiction, power over all courts and tribunals in its territory, except for military courts, of course.
And this isn't just about cases. It's about day-to-day management.
Yes, it's administrative. The High Court sets the rules of practice, the forms to be used, the fees to be paid. It manages the promotions and postings of district judges. It effectively runs the whole judicial ecosystem of the state.
Then there's appellate jurisdiction hearing appeals.
Yes, both civil and criminal. In criminal cases, if a subordinate court sentences someone to more than 7 years in prison, an appeal goes to the High Court. But there's one detail here that's chillingly important, and it really underscores the gravity of the High Court's role.
You're talking about death sentences.
Yes, the confirmation of death sentences. If a sessions court, the district level court, awards a death sentence, that sentence cannot be executed unless the High Court confirms it.
Even if the convict doesn't appeal, what if they just accept it?
Even then, even if the convict sits in his cell and says, I accept this, I won't appeal, the execution cannot happen. The High Court must review the case. The system is designed to have a second, high-level pair of eyes on the evidence before the state takes a life.
Wow, that really drives home the responsibility they carry. Before we move down the ladder, what about contempt of court? We hear about it in the news all the time.
There are two main flavors, civil and criminal. Civil contempt is usually pretty straightforward. It's willful disobedience of a court order. The court says, pay the fine, and you don't. That's civil contempt.
And criminal contempt.
That's more severe and more abstract. It involves acts that scandalize the court, lower its authority, or interfere with a judicial proceeding. It's about protecting the dignity and the perceived impartiality of the institution itself.
Okay, let's descend that ladder. Below the High Court, we have the subordinate courts. For a lot of people, this hierarchy is just a blur. Can we visualize it?
Let's think of it as two parallel tracks. On one side, you have the civil side, on the other, the criminal side.
Got it.
At the very top of the district pyramid is the district and sessions judge. It's the same person. When they hear civil cases, they are the district judge. When they hear criminal cases, they are the sessions judge.
So just wearing two different hats.
And below them. On the civil side, the ladder goes down to the subordinate judge, and at the bottom, handling smaller financial disputes, is the munsif judge.
And the criminal side.
Below the sessions judge, you have the chief judicial magistrate, the CJM, and below the CJM, you have the judicial magistrate.
And the main difference is the kind of punishment they can hand out, right?
Exactly. A judicial magistrate can generally sentence someone for up to 3 years. The chief judicial magistrate can go up to 7 years. If a crime deserves more than that, or a life sentence or death, it has to go up to the sessions judge.
Now, besides these regular courts, we've seen this explosion of tribunals, the Green Tribunal, tax tribunals, administrative tribunals. Where did this parallel system come from?
This was constitutionalized by the 42nd Amendment back in 1976. It added a whole new part to the Constitution, Part 4A. It brought in Article 323A for administrative tribunals to handle disputes about government jobs.
Right, service matters.
And Article 323B for a whole host of other things like taxation, foreign exchange, land reforms.
The idea was efficiency, I assume, to create specialized bodies that could move faster than the clogged-up civil courts.
That was the intent, but it led to a constitutional conflict. For a while, people were asking, are these tribunals a substitute for the High Court? Can you just bypass the High Court and go straight to the Supreme Court?
And the Supreme Court had to step in and settle that.
Yes, in the landmark L. Chandra Kumar case of 1997, the court ruled that the power of judicial review of the High Courts is a basic feature of the Constitution. You cannot strip it away.
So the hierarchy was restored. Tribunals are under the High Court?
Exactly. Their decisions are subject to the writ jurisdiction of the High Courts. You cannot bypass them.
Speaking of bypassing courts, we have to talk about alternative dispute resolution, ADR. With millions of cases pending, the system had to find an off-ramp.
And the most uniquely Indian innovation here is the Lok Adalat.
The People's Court.
Yes. It's deeply rooted in Gandhian principles. The first one was held in Gujarat in 1982, and then it got statutory status through the Legal Services Authorities Act of 1987.
So why would I, as a citizen, choose a Lok Adalat over a regular court? What's the incentive?
Two huge incentives, money and finality. First, there are no court fees in a Lok Adalat. In fact, if your case is already in a civil court and you move it to a Lok Adalat and settle it, your original court fees get refunded.
That's a big financial carrot. What's the stick? Or the other carrot?
The other, and maybe bigger carrot, is the finality. The award of a Lok Adalat is treated like a decree from a civil court, and it is final and binding on all parties. And here's the kicker. No appeal lies in any court against it.
That's it. Once you agree, the book is closed.
The book is closed. You can't then take it to the High Court or Supreme Court. It forces a definitive end to the dispute, which for many people is a huge relief.
I can imagine.
And we also have family courts from an act in 1984, which focus on conciliation rather than just fighting. And for rural areas, the Gram Nihilais,
The mobile courts.
justice at the doorstep. And Yadikari, who is a first-class magistrate, travels to the villages. The goal is to stop poor villagers from having to sell their land just to afford the travel and legal fees to go to the district court.
It's an incredible concept, taking the state to the citizen instead of making the citizen crawl to the state.
It is. But let's zoom out even further now. We've done the state legislature, we've done the courts. Let's look at the third tier of governance, the part that's closest to the ground, local self-government.
This is a huge topic. And historically, it was kind of a neglected child in the Constitution, wasn't it?
It was. Originally, Article 40 in the Directive Principles just said the state should organize village panchayats. And in politics, should is a very, very weak word.
It's a suggestion, not an order.
Exactly. It took decades of committees and experiments to turn that should into a must.
Right. There's a whole alphabet soup of committees. All want right, Metza.
That was a start in 1957. They recommended democratic decentralization and a three-tier structure. Rajasthan was the first state to adopt it in 1959. Then came the Ashok Mehta Committee in 1977, which had different ideas.
But the real game changers were the committees in the late 80s, right? L.M. Singhvi and P.K. Thungan.
Crucial committees, because they were the ones who argued that without constitutional recognition, these local bodies would always be weak.
At the mercy of the state governments.
Completely. State governments could dissolve them, starve them of funds, delay elections for years. They argued that local government needed the armor of the Constitution itself.
And that advocacy eventually led to the watershed moment in 1992, the 73rd and 74th Amendment Acts.
The twin pillars of grassroots democracy in India. Let's dive into the 73rd Amendment first, which gave us the Panchayati Raj institutions.
Okay.
It added Part 9 to the Constitution and Schedule 11, which lists 29 different functions, like agriculture, health, sanitation, that should be handled by panchayats.
What's the structure it builds?
It mandates a three-tier structure. Village panchayat at the bottom, an intermediate or block level in the middle, and the district panchayat at the top. But the foundation of it all, the soul of the system, is the Gram Sabha.
The Gram Sabha is unique because it's not made of elected representatives.
No, it is direct democracy. The Gram Sabha is made up of all the registered voters in the village. It is the only body in the entire Indian system where the people themselves sit and deliberate, rather than sending someone else to do it for them.
The 73rd Amendment also mandated direct elections for all seats and, crucially, introduced deep social reforms through reservation.
This cannot be overstated. It mandated reservations for SCs and STs in proportion to their population. But the truly revolutionary part was reserving at least one-third of the seats and one-third of the chairperson positions for women.
This created a pipeline of female political leadership at the grassroots level that just didn't exist before.
It challenged centuries of patriarchal power structures in the village. But, elections are one thing, power is another. To make sure these bodies weren't just puppets, the amendment created two independent institutions.
The State Election Commission.
Right, to conduct elections independently without the state government's political interference.
And second, it addressed the money question.
The State Finance Commission. Its job is to review the finances and recommend how taxes and resources should be shared between the state and the panchayats. Because without independent funds, self-government is just an empty slogan.
Now, there's a special twist here. The 73rd Amendment didn't automatically apply to the tribal regions of the country, did it?
No, it didn't. Schedule V areas, the tribal regions, were initially exempt because their customary laws and community structures are so different. It took another few years, until 1996, for Parliament to pass the PISA Act.
The provisions of the Panchayats, extension to the Scheduled Areas Act, PISA is often called a constitution within constitution for tribal areas. Why is it so radically different?
Because it completely flips the hierarchy of power. In a normal panchayat system, the elected council holds most of the administrative power. In PISA areas, the Gram Sabha is supreme.
So the entire community assembly is the boss.
Yes. The PISA Gram Sabha has the legal authority to preserve its traditions and customs, but more importantly, it has economic teeth.
Like what?
It has control over minor forest produce. It controls money lending to scheduled tribes. It has the power to prevent land alienation, meaning outsiders can't just come in and buy up tribal land. It manages village markets.
So under PISA, you can't just set up a mine or a dam without the consent of the Gram Saba.
In theory, that's exactly right. It empowers the community to be the guardians of their own resources. Now, shifting from the village to the city, we have the 74th Amendment Act.
This added Part NEXA, the municipalities, and Schedule 12, with 18 urban functions.
And the structure here depends on the size of the urban area. You have a Nagar Panchayat for a transitional area, a place becoming a town, a municipal council for a smaller city, and a municipal corporation for a large city.
One of the biggest criticisms of Indian urbanization is just the chaos. Unplanned growth, different bodies not talking to each other. Does the Constitution offer any solution for that?
It actually does, and this is a part of the 74th Amendment that is so often overlooked or poorly implemented. It mandates the creation of planning committees.
The District Planning Committee, the DPC.
Yes, the DPC's job is to consolidate the plans prepared by the rural panchayats and the urban municipalities in the district into one single draft development plan. The idea is that the city and the surrounding villages can't be planning in silos.
They share water, roads, labor.
Exactly. And for the megacities, for metropolitan areas with over 1 million people, there's the Metropolitan Planning Committee, or MPC. They're supposed to look at the even bigger picture of integrated infrastructure and environmental conservation.
It's fascinating that the machinery for integrated planning is right there in the Constitution. The tragedy is so often in the implementation.
Indeed. Many states have been reluctant to give these committees real power.
Finally, before we wrap up this tour, we have to acknowledge that India is not a monolith. The Constitution recognizes that different regions have different needs.
You're talking about Part X1, the special provisions. We all get fixated on Article 370, but the Article 371 series is really the glue that holds this incredibly diverse federation together.
And this covers a whole range of states.
It does. Articles 371 through 371J provide special provisions for 12 states, including Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, and others.
And the logic here is asymmetric federalism. Basically, treating unequals as equals can be unfair.
That's it exactly. It addresses specific regional needs. So, for example, in Maharashtra and Gujarat, the governor has special responsibilities to set up development boards for backward regions like Vidarbha to make sure they get their fair share of funds.
And in the Northeast, the focus is more on culture.
Right. In Nagaland and Mizoram, the provisions protect their religious or social practices, their customary law, and their ownership of land. Parliament can't just legislate on these matters without the state assembly agreeing.
It's a brilliant mechanism to accommodate diversity within the union.
It is.
Okay, let's just try to synthesize all of this. We have covered a massive amount of ground today. We started with the state legislature and the tricky math of the legislative council. We moved to the high courts, their wider writ jurisdiction, that critical check on death sentences.
We climbed down the ladder to the subordinate courts, the conflict over tribunals, the final and binding nature of lok adalats. And then we explored the entire universe of grassroots democracy panchayats, the radical power of PISA, and the planning mandates of municipalities.
So what's the big picture takeaway from all this?
I think it's that the Indian Constitution is incredibly detailed in its attempt to engineer justice and democracy. It doesn't just trust that things will work out. It creates specific institutions, commissions, committees for specific problems. It is a highly engineered system.
But here's the provocative thought I'm left with. We have all this hardware. We have the 73rd and 74th Amendments, which on paper are revolutionary. We have lok adalats designed to bypass the backlog. But do we have the software?
That is the question, isn't it? The structure is massive, it's detailed. But you look at the reality. Millions of pending cases still in the courts. Local bodies struggling because state governments won't release funds or devolve real power. We have the hardware of the Constitution.
But is the software, the political will, the funds, the active functionaries, is it actually running?
That is the funds, functions, and functionaries problem. Constitutionalization gives these bodies status, but it doesn't automatically give them strength.
A Gram Sabha has power on paper. But if people don't show up, or if its decisions are just ignored by a bureaucrat, then the paper is just paper.
Precisely.
Well, on that note, here's a challenge for you listeners. Do you know if your city even has a functional ward committee? Do you know when the last Gram Sabha meeting was held in your village? The machinery's there. Maybe it's time we looked under the hood ourselves.
Absolutely. Active citizenship is the only fuel that can make this engine run.
Thanks for joining us on this deep dive through the state and local machinery. Keep learning and keep diving deep. Welcome back to the deep dive. We spend so much time obsessing over the front end of democracy.
We really do.
We watch the speeches, we track the campaigns, we obsess over the drama of election night. It's like watching this high-stakes theater performance. You see the actors, you hear the lines, you applaud or boo the story.
Right.
But today we are going backstage.
That is a very, very apt analogy. Because if the stage rigging snaps or the trapdoor gets stuck or, the lighting board catches fire, the play is over. It just stops.
It doesn't matter how charismatic the lead actor is, the show is canceled.
Exactly. The whole thing comes grinding to a halt.
Exactly. We are looking at the machinery of the Republic. We've got a massive stack of sources today, constitutional articles, historical amendments, administrative reports that outline the structural backbone of the Indian Constitution.
We're talking about the guardians, those constitutional bodies that are meant to act as referees, and what we're calling the special zones.
Union territories and tribal areas where the rules of the game, they just change entirely.
It's a fascinating mix of topics because it reveals how the Constitution tries to balance two very different, almost contradictory things. On one hand, you need a unified, strong central administration to keep the country running.
A single, consistent system.
Yes. But on the other, you have this desperate need to preserve distinct local cultures and, to maintain fairness across 1 million-plus people. It's a monumental task.
It's the hidden operating system of the country. We assume our vote counts, we assume the people hired to run the government are qualified, and we assume the map of India is just fixed.
Right.
But as our sources show, there is a complex, really intricate set of gears turning to make all that happen.
And those gears are designed with very specific checks and balances. So that's what we're going to explore. The Election Commission, the UPSC, the unique status of union territories, and the special protections for tribal areas.
It's a lot to cover, and honestly, some of this stuff is wilder than the headlines. It's the how behind the what. So let's get right into it.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant. We are starting with the Guardian of Elections, the Election Commission of India, or the ECI.
Right, Article 324. Now, I think most people know the ECI runs elections. That's sort of its entire brand. But our notes make a very specific distinction about which elections they run. And I have to admit, this tripped me up at first.
It trips many people up. It's one of the most common points of confusion. The Constitution, under Article 324, establishes the ECI as a permanent and independent body.
Permanent, meaning it doesn't get dissolved after an election. It's always there.
Always there, always working. And its scope of authority, its jurisdiction, covers the parliament, so the Lok Sabha and Rajya Sabha, the state legislatures, the office of the president, and the office of the vice president.
Okay, let's unpack this slowly. That covers the big national and state stuff. The prime minister, who comes from the Lok Sabha, the chief ministers who come from the state legislatures, and the head of state, the president.
All the big federal pieces.
But what about when I go to vote for my local municipal councilor or for the panchayat member in a village? I mean, that feels like an election.
It is an election, but that is the key distinction. The Election Commission of India does not handle panchayat or municipal elections.
Wait, really? I just assumed it was all one big umbrella. The Election Commission handles elections. Full stop.
Not at all. It's a very common misconception. The Constitution actually provides for entirely separate state election commissions for those local bodies.
So each state has its own little ECI for local stuff?
Precisely. The ECI is strictly for the federal and state legislative levels. It is what's called an all-India body, meaning it serves both the central and state governments, but its mandate, its authority, stops before you get to that third tier of governance.
That is a crucial aha moment right off the bat. It means we effectively have these parallel machineries running for different levels of democracy.
That's a perfect way to put it.
Now, another thing that surprised me in the source material is that the Election Commission hasn't always looked the way it does today. I picture, a boardroom full of commissioners, but that wasn't always the case, was it?
No, it wasn't. And this is a great example of how political and social changes force the machinery itself to evolve. It's not static. From 1950, right from the beginning, all the way until October 15, 1989, the Election Commission was a single-member body.
Just one person?
Just the Chief Election Commissioner, or CEC. One person at the helm.
So, for nearly 40 years, The responsibility of the world's largest democracy, all of its elections, rested on one pair of shoulders. That is mind-boggling.
It is.
What happened in 1989 to change that? Why the sudden need for backup?
It was one single massive policy change, the voting age. On October 16th, 1989, the government lowered the voting age from 21 down to 18.
Ah, the youth vote.
Precisely. Suddenly, you had millions and millions of new voters, teenagers, college students entering the system all at once. The workload just exploded.
I can't even imagine the logistics, the paperwork.
The logistical nightmare of registering all those new people, updating the rolls, it was immense. So to cope with this, the president appointed 2 more election commissioners to assist the CEC, and overnight it went from a one-man show to a multi-member body.
But then there was a bit of a flip-flop, right? The notes mention a reversal. It wasn't a smooth transition.
No, it was a chaotic period politically. In 1990, just a year later, the 2 extra posts were abolished.
Gone.
And it went right back to being a single-member body. It seemed like the experiment had failed, or maybe politics got in the way, but that didn't last. In October 1993, the pendulum swung back. The 2 commissioners were brought back.
And it's stayed that way since.
Yes. Since 1993, it has remained a multi-member body consisting of the chief election commissioner and 2 other election commissioners.
So we have 3 people at the top now. This raises a really important question about power dynamics. If you have a chief and then 2 commissioners, does the chief get to boss the other 2 around? Like, is it a hierarchy or are they a team?
It sounds like a hierarchy, doesn't it?
Yeah, I'm the chief, so my vote counts double or something.
That is a very common misconception. Despite the title chief, the CEC and the other 2 election commissioners have equal powers, completely equal. They receive the same salary and allowances, which are pegged to that of a judge of the Supreme Court.
So if they disagree on something, let's say a really contentious issue, like whether a powerful politician violated the code of conduct, what happens then? Does the CEC have the final say?
They vote. If there is a difference of opinion, the matter is decided by the majority, 2 to 1, one way or the other. The chief acts as the chairman of the commission. They facilitate the meeting, but they don't have a veto. He is first among equals, not the boss.
That seems like a really smart safeguard. You don't want one person having absolute unchecked control over the entire democratic process.
Absolutely not.
Speaking of safeguards, let's talk about independence. This is the big one. If the government in power is the one appointing these people, what stops them from just firing a commissioner who refuses to play ball?
This is where the Constitution is very clever, specifically regarding the chief election commissioner. The CEC has what's called security of tenure. They do not serve at the pleasure of the president, even though the president appoints them.
Meaning the president can't just wake up one day, read a headline they dislike, and say, "You're fired."
Exactly. That phrase, "at the pleasure of the president," applies to many other posts, but not this one. The CEC can only be removed in the same manner and on the same grounds as a judge at the Supreme Court.
And that requires?
What?
That requires a resolution passed by both houses of parliament with a special majority based on proven misbehavior or incapacity. It is an incredibly difficult bar to clear.
It's basically impeachment.
Effectively, yes. It's designed to be nearly impossible unless there's a broad bipartisan consensus that something has gone terribly wrong.
Okay, so their job is safe. What about their salary? Can the government squeeze them that way?
Nope.
Their service conditions cannot be varied to their disadvantage after their appointment. So the government can't punish a strict CEC by suddenly cutting their salary or taking away their office perks. The protections are robust.
However, the sources we have also point out some flaws or maybe gaps in the Constitution regarding the ECI. It's not all bulletproof, is it?
No. And these are often the points that come up in critical analysis or, in those examinations. There are 3 main gaps that stand out in the text of the Constitution itself.
Yeah, what's the first one?
First, the Constitution does not prescribe any specific qualifications for the members of the Election Commission.
Wait, really? None at all. No legal background required, no mandatory administrative experience. You just have to be a person.
The Constitution itself is silent on it. It doesn't say they must be lawyers or former judges or top civil servants. In practice, they usually are very senior bureaucrats from the IAS, but constitutionally, the government could appoint anyone.
That feels like a massive loophole you could drive a truck through.
It's a point of significant debate. The second gap is the term length.
But we know they serve for 6 years or until age 65.
We know that because it's in a separate act of parliament. But the Constitution itself does not specify the term of the members. It leaves that to be determined by the president, which in practice means the government of the day. The Constitution didn't lock it in.
So a future government could, in theory, pass a new law and change the term length.
In theory, yes. It's not constitutionally fixed. And the third flaw.
Let me guess. This has to be the one that gets the most attention.
It is. The third, and perhaps most controversial flaw, is the lack of a post-retirement ban.
Explain that one for us.
Well, unlike some other bodies we will discuss later, retiring election commissioners are not debarred, they are not forbidden from accepting further appointments by the government.
I see. So the fear, the concern, is that a commissioner might be lenient on the government in power in hopes of getting a nice, cushy ambassadorship or a governor's post after they retire.
That is the concern regarding the potential for a conflict of interest. It leaves a window open for potential influence. It's a carrot that the government can theoretically dangle.
Interesting. Okay, let's move to what they actually do. We know they count votes, but the machinery aspect goes way deeper than just election day. The sources say they act in 3 capacities.
Yes. Administrative, advisory, and quasi-judicial. Administratively, they handle the absolute bedrock of logistics, preparing the electoral rolls, making sure everyone's registered, and the massive, politically sensitive task of delimitation.
The limitation is drawing the boundaries of the voting districts, the constituencies, right? That sounds incredibly political.
It is hugely sensitive. They determine the territorial constituencies throughout the country based on the latest census data. It can change the political fortunes of an area overnight. They also grant recognition to political parties and allocate those famous party symbols.
Which brings us to the quasi-judicial part. I love the idea of the ECI acting as a court.
It is essential. Political parties fracture and split all the time. If 2 factions of a political party break away and both claim the original party symbol, the hand or the lotus or the bicycle, the ECI has to step in.
They can't both use it.
Yeah. So the ECI holds hearings. They listen to both sides, and they act as a court to settle the dispute and decide who is the real party that gets to keep the symbol.
And finally, the advisory role. What does that cover?
They advise the president or the governor on the disqualification of members of parliament or state legislatures. If an MP is accused of, say, holding an office of profit, the president will seek the ECI's opinion.
And is that opinion binding?
On that matter, yes, it is.
Okay, and the most visible power they have? The Model Code of Conduct. We hear this term every single election cycle.
This is their most visible policing role. It's a set of norms agreed upon by the political parties. Once the election dates are announced, the ECI monitors everything rigorously. They can cancel polls if there is evidence of rigging or widespread violence.
And they get a huge amount of power during this period, don't they?
A tremendous amount. Crucially, during this period, they can request any staff they need from the president or governor to help run the election. And that staff, from local teachers to district administrators, falls under the ECI's control.
So for the duration of the election, the entire bureaucracy basically answers to the commission, not the government.
That's right. It effectively becomes a temporary government for the specific purpose of conducting a free and fair election.
All right, so that's the team ensuring we vote fairly. Now let's talk about the team ensuring the government itself is run by competent people. We're moving to part 2. The watchdog of merit, the Union Public Service Commission, or UPSC.
The Central Recruiting Agency. If the ECI is the gatekeeper of democracy, the UPSC is the gatekeeper of the administration. It's the body that recruits the people who will actually run the country. It is established under Articles 315 to 323 and Part 14th of the Constitution.
This is the body that conducts the famous, notoriously difficult IAS and IPS exams that millions of people study for. But looking at its structure, it seems the Constitution is a bit vague here, too, similar to what we saw with the ECI.
It is similar in some ways. The Constitution says there shall be a commission, but it doesn't specify the exact number of members. It leaves that entirely to the discretion of the president.
So the government of the day decides how big the commission is.
Yes. In practice, it usually consists of a chairman and about 9 to 11 other members. But here, unlike the ECI, the Constitution does give a hint about qualifications.
Ah, okay. So it's not a total free-for-all.
No. It mandates that 50% of the members must be persons who have held office for at least 10 years under the government of India or a state government.
Okay, so at least half the room needs to have been in the trenches of the bureaucracy for a decade. That makes sense. You need people who understand the job to hire for the job.
It ensures that there's a core of practical administrative experience on the commission.
What about their tenure? How long do they serve?
They serve for a term of 6 years or until they reach the age of 65, whichever is earlier. They can also resign at any time by addressing their resignation to the president.
And removal. Is it as tough as the chief election commissioner?
It is stringent, but the mechanism is slightly different and actually quite unique. The president can remove the chairman or any member for certain specific reasons.
Like what?
Things like insolvency, if they go bankrupt, or if they take up paid employment outside their official duties, or if the president deems them unfit to continue due to, and I quote, infirmity of mind or body.
Those seem straightforward, objective criteria. But what about the term misbehavior? That sounds very subjective. Who gets to define misbehavior?
And that is the crucial clause. If the grounds for removal is misbehavior, the president cannot act alone. He must refer the matter to the Supreme Court for an inquiry.
They can't just decide it themselves.
Yeah.
The president can't just say, I think this is misbehavior, you're out.
Absolutely not. The Supreme Court conducts a full inquiry, and this is the critical part. The advice the Supreme Court gives to the president after that inquiry is binding.
Wow. So if the president wants to fire someone for misbehavior and the Supreme Court investigates and says, no, this is not misbehavior, the president is handcuffed.
Completely. The president cannot remove them. It takes the decision out of political hands and puts it squarely into judicial hands. It's a massive shield for their independence.
And there are other shields, too. Their expenses are charged on the Consolidated Fund of India, which means Parliament doesn't get to vote on their budget year after year.
Correct. It can be discussed, but not voted on. It prevents the government from using budgetary pressure to influence them.
But the biggest safeguard is the one we noted was missing from the Election Commission.
The post-retirement ban.
Yes. Tell me about that. It's much stricter here, isn't it?
Far stricter. The chairman of the UPSC is ineligible for any further employment under the government of India or a state. Full stop. Once you are done, you are done. No exceptions.
So no dangling a governor position or an ambassadorship to get the UPSC chairman to, say, favor a certain candidate's nephew.
Correct. The temptation is removed entirely. A regular member of the UPSC can move up to become the UPSC chairman or the chairman of a state public service commission, but that is it. That's their entire career path. No other government jobs are open to them.
It forces a cooling off into a deep freeze.
It's a very clear line.
That's a very strict rule, but I can see why it's necessary for a true meritocracy. Now, we know they conduct exams for all India services and central services, but the notes mention a consultative role. What does that mean?
This is a huge part of their job. The government is required by the Constitution to consult the UPSC on major personnel matters. This isn't just about initial recruitment. It's about methods of recruitment for various posts, principles for promotions and transfers, and disciplinary matters.
Disciplinary matters, like...
If the government wants to censure or dismiss a civil servant, or recover losses from their salary for negligence, they are supposed to consult the UPSC first. The idea is to get an impartial, expert opinion.
But, and here is where it gets really interesting, the notes in our sources say this advice is not technically binding.
That is the nuance, and it's a very important one. The UPSC is, at its core, an advisory body. The government can reject its advice.
So, they can just ignore the watchdog. Doesn't that make them toothless? If the government could just say, thanks, but no thanks.
Not exactly. They can ignore the advice, but there's a political cost, a check and balance. If the government rejects the UPSC's advice, they have to answer to Parliament.
How so?
They are required to present a memorandum to Parliament explaining why they chose not to follow the Commission's advice.
So they have to go on the public record and justify their decision.
Yes. It acts as a check through transparency and accountability. It's a name and shame system, essentially. It is a guiding influence, but a powerful one, because openly rejecting the advice of an independent body like the UPSC looks suspicious and invites a lot of scrutiny from the opposition and the media.
Before we move on, there's one major area where the UPSC doesn't have jurisdiction, right? Something to do with reservations.
Yes, under Article 335 of the Constitution, the UPSC's consultative role is limited when it comes to the reservation of posts for backward classes or scheduled castes and scheduled tribes. The government can make provisions for these reservations without consulting the UPSC.
And the logic there is?
The logic is that reservation is a matter of social justice policy decided by the elected government, not a matter of administrative merit to be decided by a recruiting agency. It separates the two functions.
Got it. So we've covered the vote, ECI, and the administration, UPSC. Now let's look at the map itself. Part 3 of our deep dive is direct control, the Union territories.
This is where we shift from the guardians to the special zones. In a federal system like India, power is usually shared between the center and the states. There's a clear division. But union territories, or UTs, are a complete deviation from that federal principle.
How so?
They represent a unitary relationship where the central government is in direct control. The power isn't shared, it's exercised directly from New Delhi.
Why do we even have them? Why aren't places like Chandigarh or Puducherry just part of the neighboring states? It seems messy on a map to have these little pockets.
It seems messy, but there's a historical and political logic to it. It's not random. The sources categorize the reasons for their creation very clearly. First, you have political and administrative reasons. The best examples are Delhi and Chandigarh.
Chandigarh is a great example. It's the capital of two different states, Punjab and Haryana.
Exactly. If you gave it to Punjab, Haryana would be furious. If you gave it to Haryana, Punjab would be furious. The only solution was to make it neutral ground, a shared capital administered directly by the center.
And Delhi is the national capital.
Of course. The second category is cultural distinctiveness. Think of Puducherry, which was a French colony, or Dadra and Nagar Haveli and Daman and Diu, which were Portuguese.
Right. They had completely different legal systems, languages, architecture, and cultures compared to the British-ruled areas that surrounded them for centuries.
Merging them immediately into the neighboring states might have completely destroyed that distinct identity. So UT status acted as a kind of preservation bubble.
Okay, that makes sense. What's the third reason?
Strategic importance. This is why we have the Andaman and Nicobar Islands and Lakshadweep as UTs. They are remote island chains, vital for national security and maritime interests. They need direct central oversight.
And the last one was special care.
Yes, special care for backward or tribal people. Historically, many of the northeastern states we know today, like Mizoram, Manipur, and Arunachal Pradesh, actually started out as union territories. The idea was to provide focused development and special attention from the center before they were ready to become full states.
And the map is still changing. We absolutely have to talk about the 2019 reorganization of Jammu and Kashmir. That was a massive constitutional moment. Our sources give a very specific breakdown of why the state was split into two separate UTs, J&K and Ladakh.
Yes, and it's important to look at the specific rationale that was presented in Parliament for this split because the government treated the two regions very differently based on their perceived needs.
Let's start with Ladakh.
For Ladakh, the argument was about geography and, crucially, aspiration. It's a vast geographical area, but with a sparse population and very difficult mountainous terrain.
And the people there had been asking for this for a long time, right? They felt culturally distinct from the Kashmir Valley.
Yes, there was a long-standing demand from the people of Ladakh for UT status to fulfill their local aspirations and manage their own affairs separately. But note the key difference in the structure. Ladakh was created as a UT without a legislature.
Meaning it's directly administered by the center through a lieutenant governor, no local assembly, no chief minister. On the other hand, the Union Territory of Jammu and Kashmir was created with a legislature. Why the different approach?
Correct. The rationale given there was primarily about security. The government argued that due to the cross-border terrorism and the internal security situation, the center needed direct control over the police and public order,
Which it gets through UT status.
while still allowing for a local elected assembly to handle other day-to-day governance matters. It was presented as a temporary measure to stabilize the region.
That brings us to the administration structure.
Yeah.
Who actually runs these places? We hear about lieutenant governors and administrators. Is there a real difference, or is it just branding?
Legally, they are both agents of the president. They are not like state governors who are constitutional heads of state in their own right. These are administrators directly representing the center. However, the terminology varies. We use lieutenant governor, or LG, for Delhi, Puducherry, the Andaman and Nicobar Islands, J&K, and Ladakh.
And administrator.
We use the title administrator for Chandigarh, Dadra, and Nagar Haveli, and Daman and Diu, and Lakshadweep. Generally, the LG title is used for the larger or more complex UTs.
And then there's the special case of Delhi, the National Capital Territory. It seems to be a hybrid, monster part state, part UT, and constantly in the news because of it.
It is a completely unique constitutional arrangement created by the 69th Constitutional Amendment back in 1991. It gave Delhi a legislative assembly of 70 members and a council of ministers headed by a chief minister.
So they have a chief minister, they pass their own budget, they make laws. It looks just like a state.
It looks like one, but with a massive constitutionally mandated power gap. The Delhi Assembly can make laws on most subjects on the state list, except for 3 critical areas, and you will see these 3 areas in the news constantly.
Let me guess. Police, public order, and land.
Exactly. Public order, police, and land remain under the exclusive control of the central government.
So the Delhi police doesn't report to the Delhi chief minister.
No, they report to the central government's home ministry via the lieutenant governor. The same goes for major decisions about land use and zoning and managing public order.
That explains so much of the constant political friction we see. So if the elected Delhi government and essentially appointed LG disagree on something, who wins?
The Constitution provides a mechanism. In case of a difference of opinion between the lieutenant governor and the ministers, the LG refers the matter to the president, which in practice means the central government decides. So the center holds the ultimate trump card in any major dispute.
Moving for the capital to the remote frontiers. Part 4. Protecting the distinct scheduled and tribal areas. This is Part X of the Constitution, Article 244. This feels like the most complex part of the machinery.
It is, in many ways, the final piece of our machinery, and it's incredibly nuanced. The Constitution explicitly recognizes that the one-size-fits-all legal and administrative system of India might actually harm or destroy indigenous cultures. It accepts that certain areas need a completely different rulebook to protect their unique culture, their customs, and their economic interests, especially land from being swallowed up by the mainstream population and economy.
We have 2 key schedules here, the 5th and the 6th. I always get them mixed up. What's the easiest way to tell them apart?
Think of it this way. The 5th schedule is about providing general protection and special governance, while the 6th schedule is about granting specialized, significant autonomy. Protection versus autonomy.
Okay, let's start with the 5th schedule, with protection. Where does it apply?
The 5th schedule applies to scheduled areas in 10 different states. Think of the central Indian tribal belt Andhra Pradesh and Telangana, Jharkhand, Chhattisgarh, Gujarat, Himachal Pradesh, Madhya Pradesh, Maharashtra, Odisha, and Rajasthan.
That's a huge chunk of the country. So what special protections do these areas get?
The president has the power to declare, increase, or decrease the boundaries of these areas. But the real day-to-day power lies with the governor of the state, who is given a special responsibility for these areas.
What can the governor do with that responsibility?
It's a very powerful tool. The governor is empowered to direct that a specific act of parliament or an act of the state legislature does not apply to that scheduled area, or that it applies only with certain modifications and exceptions.
That's incredibly powerful. So if, say, a new national land acquisition law is passed that could hurt tribal interests, the governor can essentially block it for that specific area.
Yes, they can act as a constitutional filter. They also submit annual reports on the administration of these areas to the president. And each state with scheduled areas must have a Tribal Advisory Council, or TAC.
What does that do?
It consists of 20 members, and the key rule is that 3/4 of them, 15 members, must be the scheduled tribe MLAs from that state. They advise the governor on the welfare and advancement of the tribal people.
So it's an advisory body made up mostly of elected tribal representatives.
Correct.
Now let's move to the 6th schedule. You called this the autonomy model, the Northeast model.
Correct. It applies to 4 specific states. An easy mnemonic to remember them is AMTM Assam, Meghalaya, Tripura, and Mizoram.
Why do these 4 states get this extra special schedule? Why not just put their tribal areas in the 5th schedule like all the others?
The notes we have, quote, the anthropological reasoning used by the Constituent Assembly. The observation at the time was that the tribes in the 5th schedule areas, while distinct, had to some extent assimilated into the general life of the people in their states. But the tribes in the AMTM states had not.
So they were seen as more culturally separate.
Yes. The framers felt they had retained their distinct culture, customs, and civilization almost entirely separate from the non-tribal population. They were seen as distinct nations within the states.
So the 5th schedule areas were somewhat mixed, but the 6th schedule areas were seen as distinct cultural islands that needed much stronger walls.
Exactly. To protect that, the Constitution allows for the creation of autonomous districts. And this is where it gets really interesting regarding power. In the 5th schedule, the councils are largely advisory. In the 6th schedule, the autonomous district councils have actual legislative power.
They can make their own laws.
Yeah.
For real.
On specific subjects, yes. They can make laws on land use, forests, canal water, shifting cultivation, the establishment of village councils, inheritance of property, marriage, and divorce.
So on core, day-to-day cultural and economic matters, they are self-governing.
Largely, yes. If the district council passes a law on these subjects, it binds that area, though it does require the governor's assent. They can even set up their own village councils or courts to settle disputes according to their own tribal customs.
That is practically a state within a state.
It is the closest thing to it in the Indian Constitution. It's a radical level of autonomy. And our sources mention a very specific and important example of this model being adapted in Assam, the Bodoland Territorial Council, or BTC.
Right, the 2003 amendment. This is a big deal.
It was. This was created to end a long-standing and violent conflict for a separate Bodoland state. As a compromise, the Bodoland Territorial Council was created under the 6th Schedule and was granted enhanced powers, with 46 members, to satisfy the political and cultural aspirations of the Bodo people.
So it's an example of how the Constitution acts as a living peace treaty, using these special zone provisions to accommodate anger and aspiration within the framework of the nation to prevent it from breaking apart.
That's the perfect summation. It's a tool for conflict resolution.
So what does this all mean? We've looked at the ECI, the UPSC, the UTs, and the tribal areas. That is a lot of hidden machinery.
If we synthesize this, if we zoom out, the big picture is that the Indian Constitution is not a rigid, flat document. It's more like a topographical map. It creates these high peaks of independence, like the ECI and UPSC, to maintain fairness and merit across the whole country.
The national standards.
Yes. But it also carves out deep valleys and specialized zones, the union territories and the tribal areas, to handle the complex reality that India is incredibly, profoundly diverse.
It acknowledges that you can't treat Delhi the same way you treat a tribal district in Mizoram. And you can't let the people who are running the government also be the people who decide who gets hired for the government. You need separation.
Precisely. The balance of power is the key theme running through all of this. And here is a final provocative thought for you to mull over. We saw that the center holds very tight, direct control over union territories and has significant influence over tribal areas, usually justified for reasons of security and development.
Right.
But the only things really checking the center's own political and administrative power are these so-called independent bodies, like ECI and the UPSC.
And as we discussed, the government of the day appoints the very people who run those bodies.
Correct. Their independence relies heavily on the character of the people appointed and the legal difficulty of removing them. But the appointment process itself is still largely in the executive's hands. So how delicate is that balance, really? Is legal protection on paper enough if the gatekeepers themselves are chosen by the very people they are supposed to be watching?
That is a thought that will keep you up at night. The system is brilliant in its design, but it ultimately relies on the integrity of the people running it. Next time you see a news headline about an election dispute or a UPSC reform or a lieutenant governor clashing with a chief minister, remember the machinery we talked about today? It's all running in the background.
Indeed. Keep watching the machinery, not just the play on stage.
Thanks for listening to The Deep Dive. We'll see you next time. Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
It absolutely is. We often talk about government in terms of the people at the front, the prime minister, the cabinet, the faces you see on the news.
The drivers of the car, so to speak.
Exactly. But for this deep dive, we're not looking at the drivers. We're popping the hood. We're going to get our hands dirty and look at the engine itself.
Actual machinery. I like that. We're not talking about the paint job. We're looking at the gears and the pistons that make the whole thing run.
That's the plan. We are jumping straight into these specific, often overlooked bodies that handle the country's money, that safeguard its laws, and I think most importantly, that manage its social protections.
And looking at the notes we've got here, this machinery is... well, it's pretty complex. I have to admit, when I first looked at the outline for today, my first thought was that someone had spilled a giant bowl of alphabet soup on the page.
I can see that.
You've got the CAG, NETI, GST, then NCSC, NCST, and NCBC. It's just this, endless stream of acronyms.
It can definitely feel that way. But I think our mission here is to decode that soup. The real task is to figure out the distinction between the bodies that are, let's say, written into the very DNA of the Constitution itself.
The constitutional bodies.
Right. And then the others, the ones created later by a law passed in Parliament or just by an executive order, those are the non-constitutional or statutory bodies.
So if we're sticking with our car analogy, it's the difference between the parts that came from the factory baked into the original design
Mm-hmm.
and the aftermarket parts you add on later when you realize you need, I don't know, a new spoiler or better speakers.
That's a perfect analogy. The constitutional bodies are those factory parts. They're integral, they're hard to remove. The others are added as new needs arise over time.
Okay, so where do we start? Which part of the engine do we look at first?
Well, let's start with the fuel that makes the whole machine go. Money.
Always a good place to start, the money managers. And first up is the Finance Commission.
Article 280. This is really the bedrock of what we call fiscal federalism in India. It's the mechanism that balances the financial power between the center and the states.
Now, this isn't a permanent office, right? They don't just sit there year after year.
No, that's a key point. It's what's known as a quasi-judicial body.
Quasi-judicial. That sounds important. Break that down for me.
It means it has some of the flavor of a court. It weighs evidence, it makes judgments, but it's not a formal part of the judiciary. And it's constituted by the president every 5 years, or even sooner, actually, if he thinks it's necessary.
So it's like a special committee that gets assembled every 5 years to take a fresh look at the country's finances.
Precisely. It pops into existence, does this incredibly critical work of setting the financial rules of the game for the next half-decade, and then submits its report.
So if it's quasi-judicial, who are the judges? Who sits on this commission?
That's where the structure is so important. The composition is very carefully defined to get a balance of expertise. You have one chairman, who must be a person with experience in public affairs.
Which is a pretty broad category.
It is, but it generally means a senior public figure, a former governor, someone of that stature. And then you have 4 other members.
Just 4. For a country as massive and economically diverse as India.
Only 4. But the qualifications for those 4 are laid down by Parliament to ensure they cover all the necessary bases.
Okay, so what kind of experts are we talking about?
Well, typically you'll have one member who is qualified to be a judge of a high court.
For the legal perspective.
Exactly. Then you need someone with specialized knowledge of the finances and accounts of the government.
The accountant. The person who knows where all the skeletons are buried in the ledgers.
You could say that. Then the third member will have wide experience in financial matters and in administration, so a seasoned bureaucrat, often.
Someone who knows how the government machinery actually works on the inside.
And finally, you need someone who has special knowledge of economics, the academic, the theorist, who can look at the bigger picture.
So you've got a lawyer, an accountant, a bureaucrat, and an economist. It's like a supergroup of financial governance.
It's designed to be a cross-functional team that can look at the problem from every angle.
Okay, so we have the supergroup. They get together every 5 years. What do they actually do? We hear about the Finance Commission report, usually when there's a big fight between the states and the center over money.
That fight is at the heart of their core function. Their number one job is the distribution of what are called the net proceeds of taxes.
So all the tax money the central government collects in this giant pot.
A giant pot of money from income tax, corporation tax, customs duties, you name it. The Commission's first task is to recommend how to slice that pie between the union government and the states.
That's the big one. How much the center keeps versus how much is given to the states to run their affairs.
Correct. That's called vertical distribution. It's that primary division of resources. But then it gets even more complicated.
How so?
Let's say the Commission decides the states should get, for example, 41% of the total tax pot. The next question is, how do you divide that 41% among the 28 states? Does a massive state like Uttar Pradesh get the same amount as a tiny state like Goa?
I'm guessing no. That would be a recipe for chaos.
Absolutely not. And that second slicing of the pie is called horizontal distribution. The Commission has to devise a complex formula to do this.
A formula based on what?
All sorts of things. Population is a big one, of course. Area is another. But they also use more nuanced criteria, like forest cover, to reward states for environmental conservation, and something called income distance.
Income distance.
Basically, how far a state's per capita income is from the richest state. It's a way to give more money to the poorer states to help them catch.
The ones that empowered panchayats in municipalities.
Exactly. So now the Finance Commission also has to suggest measures to augment the state's own consolidated fund, specifically to help those grassroots local governments. They're looking out for the village level, too.
Okay, this body sounds incredibly powerful. They basically write the financial future of the country for a 5-year block. So when they issue their report, that's it, right? The government have to follow it. It's in the Constitution.
And that is where we get to the most interesting nuance. This is the fine print, and it's something that Dr. P.V. Rajamanar, who was the chairman of the Fourth Finance Commission, talked about quite a bit.
I'm looking at his quote here. It seems to throw a wrench in the works.
It does, because, as he pointed out, the recommendations of the Finance Commission are technically advisory in nature.
Advisor, hold on. You mean the government can just look at this massive year-long effort by these top experts and say, thanks, but no thanks?
Legally, yes. Dr. Rajamanar stated it very clearly. He said, and I'm quoting here, "The Constitution does not state that the government of India shall be bound by the recommendations."
So a state can't sue the central government based on the commission's report saying you owe us this money.
That's correct. It doesn't create a legal right to the funds.
That feels like a massive loophole.
right.
It almost makes them sound toothless.
Mhm.
What's the point of this whole quasi-judicial exercise if the government can just ignore the verdict?
It creates a fascinating constitutional tension. But think about the alternative. If the recommendations were absolutely legally binding, you'd essentially have an unelected body of 5 people dictating the entire national budget.
With no recourse for the elected government.
Exactly. By making it advisory, the ultimate responsibility still rests with the parliament, which is accountable to the people. However, and this is a very big tangent, however, there is a strong convention.
A convention.
Yes. Because it's a high-powered constitutional body, its recommendations carry immense weight. A government would have to have an extremely compelling and politically defensible reason to reject its core recommendations. It almost never happens.
So it's binding by tradition and political pressure, not by law. It's a sort of gentleman's agreement at the heart of the Constitution.
That's a great way to put it. It relies on the maturity of the democratic system to function.
Okay, so that's the old guard of financial management, but there's a new kid on the block now, right? The GST Council.
A much newer body. This is Article 279A, brought in by the 101st Amendment Act in 2016.
This came with the whole GST revolution, the one nation, one tax idea.
It did. The goods and services tax was designed to replace this incredibly complex, messy web of different taxes levied by the center and the states. But to manage this new, unified system, you couldn't have the center calling all the shots.
And you couldn't have every state doing its own thing either. That would defeat the purpose.
Precisely. So they needed a new kind of institution, a joint forum where the center and the states would, in effect, have to manage the tax system together.
A partnership.
Yeah.
So who's in the room for these meetings?
It's a very important room. The chairperson is the Union Finance Minister. Then you have the Union Minister of State in charge of revenue or finance. And then, crucially, you have the minister in charge of finance or taxation nominated by each of the state governments.
So every single state and the center are represented at the table.
Every single one. And they have to make recommendations on everything. What tax rates to apply, what goods should be exempted, what the threshold limits for businesses should be, all the nuts and bolts.
Okay, I have to ask. I've been in meetings with 5 people where we couldn't agree on what to order for lunch. How on earth do 30-plus governments agree on something as contentious as tax rates? Is it a simple majority vote?
No, and this is where the design of the council is, I think, quite brilliant. It's a masterclass in political engineering. To pass any decision, you need a majority of not less than 3/4 of the weighted votes of the members present and voting.
3/4, 75%. That is a very high bar.
It is. Now, here's the really clever part. The weighting of the votes. The vote of the central government has a weightage of exactly 1/3 of the total votes cast.
33.3%.
And the votes of all the state governments taken together have a weightage of 2/3.
66.6%. Okay, let me do the math on that. If the center wants something, they have 33%. They can't get to 75 on their own.
Not even close. They are powerless alone.
And if all the states, every single one of them, gangs up together against the center, they have 66%, they still can't get to 75.
You've got it. That is the genius of the system. Neither the center nor the states can unilaterally impose their will on the other.
It's a mathematical deadlock.
It's a mathematical incentive to cooperate. The center has a veto because you can't reach 75% without their 33%. But the states, if they stick together, also have a veto. They are forced, by the math, to find a consensus.
They have to turn their keys at the same time for the lock to open. That's actually fascinating. They literally engineered cooperative federalism into the voting formula.
That's exactly what it is.
All right, let's shift gears. We've talked about the money. Let's move on to the people.
Hmm.
This next section in our notes is called the social guardians.
Yes, the national commissions. And the story here is really one of evolution. It's about the Constitution recognizing over time that just having general principles wasn't enough. You needed active bodies to protect the rights of vulnerable communities.
And it started out quite small, didn't it?
Very small. The original Constitution, in Article 338, just provided for a special officer for scheduled castes and scheduled tribes.
Some person. Just
Yeah.
one officer to oversee the welfare of millions of people across the entire country.
That was the original provision. It became clear very quickly that this was wildly inadequate for the scale of the task.
So what happened next?
The government realized this needed to be a proper institution. So in 1978, they set up a non-statutory multi-member commission through an executive resolution. But it still didn't have that constitutional power.
It was an add-on, not a factory part.
Exactly. The big change came with the 65th Amendment Act in 1990. That's when we got a formal multi-member national commission for SCs and STs with a constitutional mandate.
But even then, they were both under one roof. Scheduled castes and scheduled tribes were handled by the same body.
They were, and that became the next point of evolution. The realization grew that the issues faced by scheduled castes, who primarily suffer from the social evil of untouchability and caste hierarchy, are very different from the issues faced by scheduled tribes.
Right. For tribal communities, the issues are more about land alienation, access to forests, displacement, and preserving a distinct cultural identity.
Completely different sets of problems. Lumping them together meant neither group got the specialized attention they needed.
So the system adapted again.
It did. The 89th Amendment Act of 2003 bifurcated the combined commission. It created two separate powerful bodies. Under Article 338, we now have the National Commission for Scheduled Castes, or NCSC, and a new Article, 338A, was added for the National Commission for Scheduled Tribes, the NCST.
Okay, let's go back to that word we used earlier, teeth. We talked about the Finance Commission being advisory. Are these commissions just advisory too? Can they just write reports that get filed away?
No, absolutely not. This is where the source material is very clear. These commissions have serious teeth. While they are investigating any matter or complaint, they have all the powers of a civil court.
A civil court. What does that mean in practice? What can they actually do?
It means they're not just writing polite letters. They can summon and enforce the attendance of any person from any part of India and examine them on oath.
So they can compel a district magistrate or a senior police officer to appear before them.
Yes, and they can require the discovery and production of any document. They can receive evidence on affidavits. It's a proper investigation. It gives them the power to demand accountability and to get to the truth.
That's a huge difference. They're not just observers, they're active investigators.
And that power is essential for them to be effective guardians.
I see in the notes here that when the NCST was created as a separate body, it was given some very specific new mandates in 2005.
That's right. The government laid out functions that were tailored specifically to the unique challenges of tribal communities. For instance, measures to be taken over conferring ownership rights in respect of minor forest produce to STs.
Minor forest produce. That sounds, well, minor. But for a tribal community living in a forest, I imagine that's their entire economy.
It's their lifeblood. It's things like tendu leaves, honey, bamboo, medicinal herbs. Securing their rights to this produce is a massive step towards economic empowerment.
What else was on that list?
The list is quite comprehensive. Safeguarding rights of tribal communities over mineral resources, water resources, and a really big one, measures to prevent the alienation of tribal people from their land.
Stopping outsiders from illegally or unfairly taking over their land.
And if they are displaced, say, for a big development project like a dam or a mine, ensuring they are properly rehabilitated, it's about protecting their home.
There's an interesting term here, shum cultivation. The commission has a role there.
Jum, or shifting cultivation, is a traditional agricultural practice, sometimes called slash and burn. It can be ecologically damaging if not managed well.
So the commission is supposed to just ban it.
No, and that's the nuance. The mandate isn't just to stop it. It's to suggest measures to reduce and eventually end the practice by ensuring the land and the people are rehabilitated.
So help them transition to more sustainable forms of agriculture. Don't just punish them for a traditional practice.
Exactly. It's a developmental and humane approach, not a punitive one.
Okay, so we have the NCSC for scheduled castes, the NCST for scheduled tribes. That leaves the third major category, the backward classes?
The NCBC, the National Commission for Backward Classes, and its story is a great example of a body being leveled up over time.
What do you mean by that?
It started its life as a statutory body. It was created by an act of parliament in 1993, following the Supreme Court's landmark judgment in the Mandel case.
So it existed, it had a legal basis, but it wasn't a constitutional body. It didn't have that same level of armor.
Correct. But very recently, the 102nd Amendment Act of 2018 gave it full constitutional status. A new Article 338B was inserted, which puts the NCBC on the exact same footing as the NCSC and the NCST.
So now it has the same powers.
The civil court power.
The exact same powers and duties. It was a major step to empower the commission. And at the same time, another new article, 342A, was added, which empowers the president to specify the lists of socially and educationally backward classes. So across the board, the trend seems to be towards giving these social safeguards the highest possible protection by writing them directly into the Constitution.
Which brings us neatly to our next section, the watchdogs. And there's a body here that I think most people have never even heard of.
You mean the Special Officer for Linguistic Minorities?
I do. Article 350B.
I have to admit, until we prepared for this deep dive, I was one of those people. It really feels like a hidden track on the constitutional album.
It's not well known, which is a shame because its role is critical, and it wasn't even in the original Constitution. It was added by the Seventh Amendment Act of 1956.
1956. Wait, that's right around the time of the state's reorganization commission, isn't it? When they redrew the map of India along linguistic lines.
Precisely. That's the context. They created states for Tamil speakers, Telugu speakers, Marathi speakers, and so on. But borders are never perfect. There are always people who end up on the wrong side of a new line.
Linguistic minorities. So if you're a Bengali speaker living in Assam or a Kannada speaker living in Maharashtra, this special officer is your constitutional protector.
That is their mandate. To investigate all matters relating to the safeguards provided for linguistic minorities under the Constitution. And here's a little trivia for you. Where do you think its headquarters is located?
It has to be New Delhi. Everything is in Delhi.
You'd think so, but no. The headquarters is in Allahabad, or Prayagraj as it's now known.
Really? Why there?
It's a deliberate choice to signal a decentralized approach. They also have regional offices in places like Belgaum, Chennai, and Kolkata. They are deliberately placed in areas where linguistic tensions can be high rather than being isolated in the capital.
That's a really interesting detail. It shows a different way of thinking about governance.
Yeah.
But okay, from the obscure watchdog to the biggest watchdog of them all, the one that Dr. Ambedkar called the most important officer under the Constitution.
The Comptroller and Auditor General of India, the CAG, Article 148.
I love the title they give the CAG. Guardian of the Public Purse. It sounds like a character from a fantasy novel.
It's a role that requires that kind of stature in a democracy. Ambedkar didn't mince his words. He put the CAG in the top tier of democratic institutions, one of the four bulwarks, along with the Supreme Court, the Election Commission, and the Union Public Service Commission.
So in simple terms, the CAG's job is to check the government's receipts.
In very simple terms, yes. They audit all expenditure from the Consolidated Fund of India, the contingency funds, the public accounts for both the union and the states. Basically, if a single rupee of taxpayer money is spent, the CAG's office is there to ask, was this spent correctly? Was it spent for the purpose Parliament approved? Was there any waste or corruption?
And to do a job like that, they must be completely independent. You can't have the government you're auditing also controlling your salary.
Absolutely. Their independence is sacrosanct. For instance, the CAG's salary and the administrative expenses of the office are charged upon the Consolidated Fund of India.
Meaning Parliament doesn't vote on it. It's a non-votable expense.
Exactly. It's guaranteed. It can't be used as a political weapon. Also, another key point is that no minister can represent the CAG in Parliament. The CAG is accountable to Parliament directly.
Okay, but I want to dig into that title. Controller and Auditor General. Controller sounds very controlling.
It does. And the source material here points out a fascinating and critical distinction. In the Indian context, the controller part of the title is essentially a misnomer.
How is that?
We inherited the title from the British system. In the UK, the CAG is both a controller and an auditor. The controller function means they have control over the issue of money from the exchequer.
So in Britain, the government can't even take money out of its bank account without the CAG's approval first.
That's right. The UK's CAG has the power to say no before the money is spent. They hold the keys to the treasury, in a way.
And in India.
In India, the CAG's role is almost entirely that of an auditor general. The work happens after the expenditure has already been incurred.
So it's a post-mortem. We can find out why the patient died, but we couldn't stop them from taking the poison in the first place.
That's a very good way to describe the limitation. And this limitation, combined with the very nature of auditing, has led to some really sharp criticism over the years. You saw the notes on Paul H. Appleby's critique?
I did. He did not hold back. He called the office of the CAG a legacy of colonial rule.
He argued it was a colonial institution designed for suspicion and control, not for a modern developing state. He claimed its function has a repressive and negative influence.
Repressive is a strong word. What was his argument?
It was a psychological one. He believed that the constant fear of an audit makes public administrators risk-averse. They become reluctant to make bold or quick decisions because they're terrified of the audit paragraph that might pop up 2 years down the line criticizing some minor procedural flaw.
So the fear of being second-guessed leads to paralysis by analysis.
Exactly. Appleby's other point was that auditors, by their nature, don't necessarily understand the complexities of administration. They're trained to find fault. They might not appreciate that a decision that looks messy on paper was the best possible choice in a crisis.
It's that classic tension between accountability and efficiency.
Yeah.
If you have too many checks, nothing gets done. If you have too few, money gets wasted or stolen.
The eternal balancing act of public administration. Now, one more detail on the CAG you should know. Their role isn't the same for all public sector companies.
Right, I saw there are different categories of audit.
Broadly, 3. First, there are the corporations that are audited totally and directly by the CAG. Think of bodies like ONGC, Air India, Damodar Valley Corporation. The CAG is their primary auditor.
Okay, bucket 1, what's bucket 2?
Bucket 2 is where the CAG plays a supplementary role. Corporations like the Central Warehousing Corporation are audited by private professional auditors, and the CAG can then conduct a supplementary audit or a test audit to check their work.
So they audit the auditors, in a way.
Yes. But then there's bucket 3, and this is the one that often surprises people.
It includes some very big names. LIC, State Bank of India, and the Reserve Bank of India.
Correct. For these institutions, the CAG has no role in their audit. They are audited entirely by private auditors.
Wait, the Controller and Auditor General doesn't audit the country's central bank?
Correct.
Why on earth not? That seems like a massive gap.
The rationale is to preserve the operational autonomy and specialized financial nature of these bodies. The argument is that a central bank, for instance, needs a different kind of oversight than a government department. But yes, it's a fact that surprises many.
Truly fascinating. Okay, let's touch briefly on the government's lawyers. When the government gets sued, who puts on the robes and goes to court?
That's where our legal officers come in. At the national level, you have the Attorney General of India, provided for under Article 76.
And this isn't just any lawyer the government hires.
No, the qualification bar is extremely high. A person appointed as Attorney General must be qualified to be appointed as a judge of the Supreme Court.
So an eminent jurist, a high court judge for at least 5 years, or a high court advocate for 10.
That's right. They are the highest law officer in the country, appointed by the president to advise the government on all legal matters.
And there's a mirror image of this at the state level.
Yes, the Advocate General of the state under Article 165. They're appointed by the governor and must be qualified to be a judge of a high court. They perform the same function for the state government as the AG does for the center.
Okay, so we've looked at the constitutional machinery that's been there for decades, but now we have to talk about a huge renovation project. The section in our notes on the big policy shift, the move from the Planning Commission to Niti Aayog.
This is probably the single biggest change in the machinery of Indian governance in recent memory. It was a seismic shift. On August 13, 2014, the government announced it was scrapping the 65-year-old Planning Commission.
That was a cornerstone of the post-independence economic model, a legacy of the Nehruvian era.
It was an institution. And on January 1st, 2015, in its place, a new body was established, NEE Aayog, which stands for the National Institution for Transforming India.
First question, let's place it in our framework. Is Niti Aayog a constitutional body?
No, it is not.
Is it a statutory body?
Yeah.
Created by an act of parliament?
Also, no. Just like the Planning Commission it replaced, NET Aayog is what we call an extra-constitutional or non-constitutional body. It was created simply by a resolution of the Union Cabinet.
So from a legal standpoint, they're the same type of creature, But in terms of their philosophy and function,
They are polar opposites. The old Planning Commission embodied a top-down approach to development.
a command and control structure.
Very much so. It was a centralized body sitting in Delhi that created five-year plans, and states were expected to fall in line. It was often criticized for having a one-size-fits-all approach that didn't respect India's diversity.
And Niti Aayog is meant to be different.
It's designed to be the opposite. Its core philosophy is bottom-up planning and cooperative federalism. It's envisioned not as a commander, but as a think tank.
A think tank gives advice, it doesn't give orders.
That's the idea, and you can see this in its structure. The chairperson is the prime minister, yes, but the key body is the governing council. And that council includes the chief ministers of all the states and the lieutenant governors of the union territories.
Right, this is what the government calls Team India, bringing everyone to the table.
The idea is to involve states in policy formulation right from the beginning, not just as passive recipients of central plans.
I'm looking at their guiding principles here, the 7 pillars of effective governance. It's a lot of buzzwords. Pro-people, proactivity, participation, empowering, inclusion, equality, transparency. It all sounds very good on paper.
It does. But the single biggest, most fundamental difference between the Planning Commission and Niti Aayog isn't in the buzzwords. It's about money.
Ah, the power of the purse.
The old Planning Commission held the power of the purse. It had enormous financial clout. It had the power to allocate plan funds to central ministries and to state governments.
And as we know in politics, he who controls the money calls the shots.
Precisely. This financial power made the Planning Commission incredibly powerful, so much so that critics like the First Administrative Reforms Commission and figures like K. Santhanam called it a super cabinet.
A parallel cabinet even.
Yes, because it often had more say over a ministry's projects than the finance ministry did. It became this alternative power center.
Okay, so the big question, does Niti Aayog have this power? Does it allocate funds?
No, it has no powers to allocate funds. That is the crucial change. Those financial powers have been vested back entirely with the finance ministry.
So Niti Aayog's role is purely advisory. It's a consultant, a knowledge partner, but it can't write the check. That's the fundamental shift. It can have the most brilliant, well-researched idea in the world, but it doesn't have the financial leverage to force a state or ministry to adopt it. And I imagine not everyone was thrilled with this change.
Not at all. The source material highlights quite a bit of criticism from opposition parties at the time. Some dismissed it as a gimmick and mere window dressing.
I see one critic called it a Niti Aayog, a play on the word Niti meaning injustice.
That's right. There was genuine fear. Gudas Dasgupta of the CPI, for example, argued that dismantling the central planning function would lead to an unregulated economy, one that serves corporate interests over the needs of the poor.
And there was the toothless argument as well, right? That without the power to allocate funds, its advice could just be ignored.
That was the main line of criticism. If a state government simply disagrees with Niti's recommendation, and Niti can't threaten to withhold funds, that stick is gone from its arsenal.
The counterargument, I suppose, is that this forces the central government to rely on persuasion rather than coercion. You have to win the argument on its merits.
That is the philosophical underpinning of the change. It's a move from a hierarchical relationship to a more collaborative one.
And I see they have a monitoring arm, the DMEO.
Yes, the Development Monitoring and Evaluation Office. It was set up and attached to Niti Aayog in 2015.
So if NIAID is the brain of the policy operation, the DMEO is its eyes and ears on the ground.
That's a great analogy. NII helps formulate the strategy, and the DMEO is responsible for monitoring how government programs are actually performing and evaluating their impact.
Wow. We have really covered a huge amount of ground today. We've gone through this whole complex web of government machinery, from the rigid constitutional power of the Finance Commission
to the flexible advisory think tank model of Niti Aayog.
We've seen the protective powers of the social commissions armed with the authority of a civil court.
And the watchful eye of the CAG, the guardian of the public purse, even with all the debates surrounding its role.
It's a real mix of hard power and soft power.
It is. You have the hard constitutional power over the flow of money, and you have the soft power of ideas and influence. And the system needs both to function.
And looking at the story of the social commissions or the linguistic officer, you see a system that is constantly trying to adapt and build in new safeguards for the most vulnerable.
It shows that the Constitution isn't a static document. It's a living one. The machinery evolves, it gets upgraded, new parts are added to deal with new challenges. It's a learning organism.
So when our listeners see one of these acronyms in a news headline tomorrow, what's the big takeaway?
I think the takeaway is to look past the headline. When you hear about a new policy for tribal welfare, ask if the NCST was consulted. When you read about a big audit report uncovering a scam, that's the CAG at work. And when you see a state ranking on health or education, that's probably NEIIOG's data driving the conversation.
These are the hidden gears we said we'd look at.
They are. But before we wrap up, I want to leave you with one final provocative thought to chew on.
I'm all ears.
Okay, so we've established that NEIIOG was created in the name of cooperative federalism, bringing states to the table as equal partners. But by taking away the financial allocation powers from the Semi-Independent Planning Commission and giving them back entirely to the Union Finance Ministry, which is a core part of the central government's executive branch, has the balance of power actually shifted even more towards the center?
That's a fantastic question. You're suggesting that by removing the super cabinet, you've just made the actual cabinet even more powerful and unchecked.
It's something to consider. In the name of cooperation, did the reform unintentionally centralize the most important power of all, the power of the purse?
A question that definitely doesn't have a simple answer. A perfect thought to end on. Thank you so much for walking us through the engine room today.
My pleasure. It was a great discussion.
And to all of you listening, keep an eye out for those hidden gears. We'll see you on the next deep dive.
Moving ahead, let us understand the next important point.
Mm-hmm.
From an examination perspective, this point is significant.
It really is.
We're shifting gears now. We've spent a lot of time in previous deep dives looking at the high-level philosophy of the Constitution.
The ideals, the preamble, all of that.
Exactly, the fundamental rights. But today we're going under the hood.
That's a great way to put it. We're looking at the engine room.
Yes, because, you can write the most poetic constitution in the world, guaranteeing every right imaginable.
But if you don't have the mechanics to enforce those rights,
The gears, the levers, the pulleys.
it's just ink on paper.
It is. So today we are talking about the alphabet soup of Indian democracy, the NHRC, the CVC, the CDI, the NIA.
It can feel a bit overwhelming, can't it? Just a barrage of acronyms.
It really can.
But I think the best way to frame this for you, listening right now, is to think of these bodies not as bureaucracy, but as the watchdogs.
Watchdogs. I like that. That's a good mental hook.
Because democracy is messy. Power gets abused.
Yeah.
These institutions are the fail-safes.
Okay.
They're the statutory and regulatory muscle designed to bark and sometimes, to bite when the system fails.
So different watchdogs for different problems.
Precisely. We have watchdogs for human dignity, watchdogs for transparency, watchdogs against corruption, and of course, watchdogs for national security.
And we are going to categorize them exactly like that to keep this roadmap clear for everyone.
Sounds like a plan.
We'll start with human rights, then move to the information age, tackle the heavy hitters and corruption, and finish with national security.
A logical progression.
So let's not waste time. Let's start with the guardians of dignity.
The National Human Rights Commission, or the NHRC.
Now, here's the first curveball, and I think this trips a lot of people up.
I think I know where you're going with this.
You would assume, given how incredibly important human rights are, that the NHRC is a constitutional body.
Like the Election Commission or the UPSC.
Yeah,
right?
but it's not.
It is not. That is a very common trap. The NHRC is a statutory body.
Meaning it comes from an act of parliament.
Exactly. It wasn't born in 1950 with the Constitution. It was established much, much later in 1993 under Protection of Human Rights Act.
1993, that seems quite late, doesn't it?
It is late. It really reflects a global shift in the 90s where these kinds of national human rights institutions became, central to democratic governance.
Oh, I see.
But just because it's statutory doesn't mean it's weak. The Act itself describes it explicitly as the watchdog of human rights in the country.
And how are they defining rights here? I mean, is it just about things like police brutality?
It's much, much broader. The definition is almost poetic, but it's legally specific. It covers rights relating to life, liberty, equality, and dignity.
Life, liberty, equality, and dignity.
And crucially, these aren't just abstract ideas. These are rights that are either guaranteed by the Constitution or embodied in international treaties that are enforceable by courts in India.
That covers a lot of ground. Now, whenever we analyze these commissions, the text always emphasizes the who.
The composition.
The composition of the body usually tells you how serious the government is about it. So who gets to sit at the head of the table at the NHRC?
And this is where you see the sheer weight of the institution. You can't just put any bureaucrat or a politician in charge.
Right.
The chairperson must be a retired Chief Justice of India.
Wow.
Or a judge of the Supreme Court.
So that sets the bar incredibly high immediately. You're taking someone from the absolute apex of the entire judiciary.
Precisely. It brings instant judicial gravitas. And the other members are, well, they're cut from a similar cloth.
Okay.
You have a serving or retired Supreme Court judge and a serving or retired Chief Justice of a high court.
So it's very heavily judicial.
It is, but not entirely. And this is an important point. The Act also mandates 3 persons with practical experience or special knowledge in human rights.
So not just judges.
Right, because judges know the law, but you also need activists or academics or, experts who know the ground reality of violations.
That makes a lot of sense. And looking at the notes here, the table gets even bigger.
It does.
There's a term used, ex officio members. For those who haven't brushed up on their Latin lately, that basically means they are members by virtue of holding another position, right?
Correct. The NHRC acts as a sort of mothership for rights. It's a central hub.
A hub, okay.
So to ensure every vulnerable section is represented, the chairpersons of several other specific commissions automatically get a seat at the NHRC table.
And who are we talking about here?
It's a very comprehensive list. You have the National Commissions for Minorities, Scheduled Castes, Scheduled Tribes, Women, Backward Classes.
So all the major social justice commissions?
Yes, and the Protection of Child Rights, plus the Chief Commissioner for Persons with Disabilities.
So that's designed to be a convergence point. If there's a systemic issue affecting, say, tribal women, you have the specific representatives for both groups right there in the room.
Exactly. It prevents these commissions from working in silos, which is a huge problem in government.
Now let's get to the politics of it, because this is where the whole watchdog analogy gets tested.
The appointment process.
Yes. If the government can just appoint a friendly judge to head the NHRC, the watchdog isn't going to bark at the government, is it? So who kicks these people?
Yeah, that is the eternal concern with any regulatory body. Independence is defined by the appointment process. The president makes the appointment, sure, but he must act on the recommendations of a very specific 6-member committee.
Okay.
And the composition of this committee is, well, it's a masterclass in checks and balances.
Walk us through that committee. Who's in the room?
Okay, picture the room. At the head of the table, you have the prime minister.
As the head.
Next to him, the speaker of the Lok Sabha and the deputy chairman of the Rajya Sabha, and the central home minister.
So far, that sounds like a government-dominated meeting. That's the ruling party right there.
It looks that way, doesn't it? But here's the twist. The committee must also include the leaders of the opposition in both the Lok Sabha and the Rajya Sabha.
Ah, that is critical. The opposition has a voice and a vote.
A very important one. It means the government cannot simply ram through a candidate in the dead of night. They have to face the opposition. It forces a degree of consensus.
Is that it?
There's one more safeguard. If they're appointing a sitting judge, they cannot do it without consulting the Chief Justice of India.
That protects the judiciary from having its sitting judges sort of poached by the executive without permission.
That's the idea.
So once they're in, do they have job security? Can the government just fire them if they start investigating an inconvenient truth?
It is very, very difficult to fire them. First, they have a fixed tenure, 3 years or until they hit age 70, whichever comes first.
Okay, a fixed term.
And while they can be reappointed, there's a strict cooling-off provision. Once you retire from the NHRC, you are ineligible for any further employment under the central or state governments.
That's obviously to prevent the carrot problem, where a member might play nice, hoping to get a governorship or an ambassadorship later on.
Exactly. No future favors. And regarding removal, the stick, it's equally tough. The president can remove them for clear-cut things like insolvency, holding another paid job, or being convicted of a crime.
The straightforward stuff?
Right. But for misbehavior or incapacity, which is usually the vague charge governments use to get rid of people they don't like.
Right, the catch-all.
For that, The president can't just sign an order.
What's the process?
The president has to refer the matter to the Supreme Court. The Supreme Court then holds an inquiry.
The highest court in the land investigates.
Yes, and only if the Supreme Court upholds the charges can the removal actually happen. It's a very, very strong shield.
So they're secure, they're high profile, they have a diverse team. But let's talk about impact. Critics often call the NHRC a toothless tiger. Is that a fair criticism?
It is a cliche, but, it exists for a reason. The source material highlights some very specific limitations. The NHRC has broad powers to investigate. I mean, they can march into jails, they can intervene in court cases, and they can even investigate suo motu, so on their own, just based on a news report. But
There is always a but.
the but is enforcement. The NHRC can recommend compensation, they can recommend damages, they can recommend prosecution of a guilty official.
Sounds powerful.
But they cannot enforce it. They cannot throw a police officer in jail themselves. They have to rely on the government to accept and act on the recommendation.
So they can bark, point, and shame, but they can't actually bite?
Essentially. Though, to be fair, the government usually does accept the recommendations because the political cost of ignoring the NHRC is very high. But legally, yes, their powers are recommendatory.
And there's also a specific blind spot in the Act regarding the military, right?
Yes, this is a big one. The Act limits the NHRC's powers significantly when it comes to the armed forces. They can't investigate them with the same freedom as they can the police.
And this leads to a definition battle, I imagine. What counts as armed forces?
That is a great point. The A.M. Amati Committee looked into this very question.
What did they find?
They argued that armed forces should be strictly defined. Army, Navy, Air Force. That's it. They said, hey, why are paramilitary forces included in this exemption?
So forces like the BSF or CRPF.
Exactly.
Yeah.
But broadly, the text implies the restriction covers the central armed forces generally. It is a constant friction point between national security imperatives and human rights transparency.
Before we leave rights, we have to acknowledge that India is just too big to be run from Delhi.
Absolutely.
What if a violation happens in a remote village in Tamil Nadu? Does the NHRC fly down for every case?
They can, but the system is designed to be federal. The same 1993 Act allows states to form state human rights commissions, or SHRCs.
And have they?
Yes, about 26 states have done this via official Gazette notifications.
Is it basically a carbon copy of the national version?
It rhymes, as they say. The structure is very similar. The chairperson has to be a retired chief justice or a judge of a high court.
Okay, so the state's highest judicial officers.
Correct.
Yep.
But obviously, the appointment is done by the governor, not the president. And the selection committee mirrors the central one, but at the state level.
So the chief minister, the speaker.
State home minister, and the leader of the opposition in the assembly.
And what if the state has a legislative council, an upper house?
Then you add the chairman of that council and the leader of the opposition in that council as well. It's the same logic. Executive plus opposition equals balance.
And do they have the same toothless issue, the recommendatory powers?
They do. They submit their annual reports to the state government. Now, here's the accountability mechanism.
Okay.
The state government must lay that report before the legislature. And they have to include a memorandum explaining the action they've taken.
And if they haven't taken action?
If they rejected a recommendation, they have to explain why.
So they can't just toss a report in the trash bin. They have to go on record in the assembly and say, we ignored this advice, and here's our excuse.
Exactly. It forces a public conversation and a degree of political accountability.
Finally, the text mentions human rights courts. This sounds like a fantastic idea, fast-tracking these specific cases.
It is mandated by the Act, the idea of setting up a human rights court in every single district. The goal is speedy trials.
And who runs these?
The state government appoints a special public prosecutor who must be a lawyer with at least 7 years of experience. So on paper, the infrastructure is there to make justice accessible locally and quickly.
All right, so we have the machinery for dignity. Let's move to the second pillar we laid out.
The machinery for truth.
The era of transparency.
The right to information. The RTI.
It's hard to overstate just how big a shift this was for India.
It was a complete paradigm shift. Before 2005, the default setting of Indian governance was the Official Secrets Act of 1923.
A colonial-era law.
Right. Everything was a secret unless the government graciously decided to tell you.
And then comes the RTI Act of 2005.
And the polarity completely flipped. Now, the default is transparency. Everything is public unless the government can provide a very good reason why it should be secret.
And to enforce this, we got new watchdogs.
The Central Information Commission, the CIC, and the State Information Commissions. The SICs.
Again, let's check the status constitutional or statutory.
Statutory. Non-constitutional. But a high authority independent body. No question about that.
Who runs the show here? Is it judges again, like the NHRC?
No, and that is a crucial difference. The CIC deals with information, which is a much broader social commodity than just law.
Right.
So the qualifications are much wider. They look for persons of eminence in public life.
And what kind of fields does that cover?
Law, yes, but also science, technology, social service, management, journalism, mass media, administration.
So a very wide net.
They want people who understand how information moves in society, how it's used and abused.
That makes sense. You want a journalist's perspective on transparency, not just a judge's.
Exactly. But there's a very strict no politics rule. They cannot be members of parliament or state legislatures. They cannot hold any office of profit or be connected to a political party.
They need to be neutral arbiters of information.
Absolutely.
And the structure of the commission.
It started as one chief information commissioner and up to 5 commissioners. As of 2019, the source notes it was the chief plus 6.
And the appointment committee? Is it the same Big Six as the NHRC?
It's a leaner version, a much smaller committee, just 3 people.
Who are they?
The prime minister, the leader of the opposition in the Lok Sabha,
There he is again.
and a union cabinet minister nominated by the PM.
So you will always have that opposition voice in the room.
You'll see this pattern everywhere. It's the standard safeguard against complete executive dominance. If the PM and his minister want to appoint a yes man, the leader of the opposition can at least raise a red flag or write a dissent note that becomes public.
So the CIC is the final court of appeal for the citizen. It handles complaints against central government offices, PSUs, banks.
It's where you go when the government refuses to answer your question. It is the appellate body for the curious citizen.
Moving on, we've done dignity, we've done transparency, now we get to the really gritty, messy battlefield. Corruption!
What the Supreme Court called the enemy of the nation.
We have a few bodies here, and they interact in really complex ways. Let's start with the Central Vigilance Commission, the CVC.
The CVC is fascinating because of its history. It started as a humble executive resolution. It was created way back in 1964.
1964, that's ancient in terms of Indian administrative history.
It was based on the Santhanam Committee recommendations. They spent 2 years studying the roots of corruption and said, we need a dedicated body to prevent this.
So it existed from the 60s.
But for decades, the CVC was neither constitutional nor statutory. It just existed. It was suspended in this strange administrative limbo.
When did it finally get its legal teeth?
It finally got statutory status in September 2003. That was the moment it gained real legal weight.
So what does the CVC actually do? Is it a police force? Does it make arrests?
No, it's not police. Think of it more as an auditor of integrity. Its functions are quite distinct.
Okay, what's the main one?
First, it is the supervisor. It supervises the functioning of the CBI.
The Central Bureau of Investigation.
Right. But, and this is a key distinction, only regarding corruption cases.
So it doesn't tell the CBI how to solve a murder.
No. Only cases under the Prevention of Corruption Act, 1988. The CVC reviews the progress of these investigations. It's there to ensure the CBI isn't dragging its feet on high-profile corruption cases, perhaps under political pressure.
It also has a major role with whistleblowers, right?
Yes. This is vital. Under the Public Interest, Disclosure and Protection of Informers Resolution, which goes by the clumsy acronym PIDPI, the CVC is the designated agency to receive complaints.
So if you're a government employee and you see your boss taking a bribe,
The CVC is who you write to. They are meant to be your shield.
does the CVC watch over everyone? I mean, can they look into a corrupt peon or a clerk?
Generally, they focus on the big fish. Their jurisdiction covers Group A officers of the central government, all India Services officers, your IAS, your IPS and senior levels in public sector banks and PSUs.
You top brass.
The logic is that if you clean the top, the bottom will eventually follow.
The source also mentions something called CDIs, Commissioners for Departmental Inquiries. What are they?
Right. So when a bureaucrat is accused of misconduct, they don't go straight to jail. First, there's an internal departmental inquiry. The CVC provides the officers, the CDIs, who act as the judges in these internal tribunals. They determine if the officer broke the rules administratively.
So the CVC is the supervisor and the internal judge. But who is the actual investigator? Who kicks down the door?
And that brings us to the most famous and perhaps most controversial acronym in India,
The CBI.
the Central Bureau of Investigation.
The primary investigator. We see them in movies, on the news. But you have a fact here that honestly blew my mind when I first read it.
I think I know which one you're talking about.
The CBI is not a statutory body.
It is the single most surprising fact in Indian administrative law. It's astonishing.
Mm.
The NHRC has an act, the CVC has an act, the Lokpal has an act.
They're not the CBI.
The CBI. It runs on a Home Ministry resolution from 1963 and derives its police powers from a colonial law, the Delhi Special Police Establishment Act, 1946.
Wait. So India's premier investigating agency, the one that handles modern cybercrime and massive international financial fraud, is running on a 1946 legal chassis.
Essentially, yes. It does not have its own CBI Act. It is a legal quirk that has persisted for decades and has been the subject of countless legal challenges.
Does that make it vulnerable?
It creates complications, definitely, especially regarding its jurisdiction over states, which we can get to. But despite the legal oddity, its mission is crystal clear. Their motto is industry, impartiality, and integrity.
And while we often associate them with solving high-profile murders or finding missing kids in the news, that's not their main job, is it?
No. Institutionally, their core mandate is fighting corruption, investigating major economic offenses, and tackling serious organized crime. They're also the nodal agency for Interpol in India. So if a fugitive flees to London, the CBI is the one that coordinates the chase.
Let's look at the structure. It must be huge.
It's massive, and it has evolved. It started with 6 divisions, but as of 2019, the source lists 7 branches. They have specialized units for economic offenses, cybercrime, forensic science, and of course their own training academy, Ghaziabad, since 1996.
But the driver of that machine is what really matters. The director of the CBI. This is arguably one of the most powerful and sensitive seats in the entire republic.
It is.
How do you get that job?
Well, this has been a constant tug of war. Governments, historically, love to control the CBI director because the CBI can be used as a weapon against political opponents.
The whole caged parrot criticism that the Supreme Court made.
Exactly. To stop this, the appointment process has been tightened significantly over the years. The director is appointed by the central government, but they must listen to a high-powered committee.
And who's on this one?
Look at this committee. The Prime Minister,
Of course.
the leader of the opposition in the Lok Sabha,
The check and balance.
the Chief Justice of India.
Wow. Okay, so you have the head of the executive, the head of the opposition, and the head of the judiciary all in one room to pick one police officer.
That tells you how high the stakes are. The CJI's presence adds a massive layer of judicial oversight. It's very hard to push a purely puppet candidate when the Chief Justice is sitting right there looking at the file.
And there was a little tweak made in 2014 regarding the opposition leader, right?
Yes, a very practical one. In the 2014 election, no opposition party got 10% of the seats. So, strictly speaking, there was no official leader of the opposition.
A constitutional vacuum.
Right. So the government passed an amendment saying, okay, in that case, the leader of the single largest opposition party takes the seat. They didn't want the seat to stay empty on a technicality.
And once the director is in, how long do they have?
2 years. A secured tenure. This was mandated by the CVC Act of 2003. So even if the director opens an investigation into the government's best friend, they cannot be transferred out the next day. They have 2 years to do their job without fear or favor.
Speaking of investigating friends of the government, we have to talk about Section 6A. This seems to be a major point in the source material.
This is a landmark moment in the history of the CBI's independence. Section 6A of that old Delhi Special Police Establishment Act was a very controversial provision.
What did it do?
It basically said that if the CBI wanted to investigate an officer of the rank of Joint Secretary or above, they needed the government's permission first.
That sounds like a get-out-of-jail-free card for the top bureaucracy.
Yeah.
You can investigate the clerk, but you need my permission to investigate me.
That is exactly how the Supreme Court saw it. They struck it down completely.
And the language the court used was powerful, wasn't it?
Incredibly powerful. They called corruption an enemy of the nation.
Enemy of the nation. That puts it on par with terrorism or war.
Yes. They ruled that status shouldn't shield a corrupt bureaucrat. You cannot divide corrupt officials into 2 classes. Those you can investigate freely and those who are protected. The law must be equal for all.
One last structural weakness of the CBI, the general consent issue. We hear about this in the news all the time. States withdrawing consent from the CBI. What does that actually mean?
This goes right back to the heart of India's federalism. In the Constitution, police is a state subject. The CBI is a central agency.
A fundamental conflict.
It is. Under that 1946 Act, The CBI legally needs the state government's permission to enter a state and investigate a case there.
So if a crime happens in Bengal or Maharashtra, the CBI can't just drive in and take over.
Not automatically. Usually, states give a standing general consent, which is
Yeah.
basically a pass that says come in whenever you need to.
Hmm.
But if a state government is in a political fight with the central government, they can withdraw that consent.
And then what happens?
Then the CBI is stuck. They have to ask for specific permission for every single case, or they have to go to a high court or the Supreme Court and get an order to enter. It's a major bottleneck.
That seems like a massive handicap for a so-called national agency.
It is. And it contrasts sharply with the next agency we'll discuss, the NIA. But before that, we have to look at the capstone of this entire anti-corruption framework. We have the CDC supervising, the CBI investigating. But who watches the watchers?
The ombudsman, the Lokpal.
The Lokpal and the Lokyuktas. This concept traveled a very long way to get to India. It started in Sweden, of all places, in 1809.
1809.
It took India a little while to catch up. The Administrative Reforms Commission recommended it back in the 1960s. But we didn't actually get the Lokpal and Lokyuktas Act until 2013.
Wow, that's a 50-year delay. Why do scholars love this concept so much? What's the big idea?
They call it a bulwark against administrative tyranny. In a modern state, the administration has vast power over your life. The ombudsman is the citizen's defender against the misuse of that power.
So the 2013 Act finally passes after huge public movements. Who does it cover?
Almost everyone, all groups A, B, C, and D of the bureaucracy.
Yeah.
But the headline, the big one, is that it covers the Prime Minister.
The Prime Minister of India is under the jurisdiction of the Lokpal.
Yes. Now, there are some very strong safeguards. You can't just file a frivolous complaint against the PM to create a media circus. There are subject exclusions like international relations, public order, space, atomic energy.
National security stuff.
Right. And the process for handling a complaint against the PM is very strict and confidential. But in principle, the PM is not above the law.
How does the Lokpal handle the sheer volume? There are millions of government employees.
It's designed to use the existing machinery. If a complaint comes in about a Group A or B officer, the Lokpal sends it down to the CDC for a preliminary inquiry. The CBC then reports back to the Lokpal.
So it delegates.
For the big fish, yes. For Group C and D employees, the CBC handles the case under the Lokpal's overall oversight. The Lokpal is the ultimate boss.
What are the Lokpal's superpowers? What makes it different from just another court?
Two things really stand out in the Act.
Yeah.
First, superintendents. The Lokpal can direct any investigation agency, including the CBI.
Any agency.
Yes. And if the Lokpal gives a case to the CBI, the government cannot interfere. For that case, the CBI reports directly to the Lokpal, not the government.
That directly addresses the caged parrot issue we talked about.
In theory, yes, it solves it. Second is asset confiscation. This is the nuclear option against corruption.
What does it do?
The Lokpal has the power to confiscate assets that were acquired through corrupt means, even while the prosecution is still pending.
So you don't have to wait 20 years for a final conviction from the Supreme Court?
No. If the initial inquiry shows the assets are very likely corrupt, they can be seized right away. It completely changes the incentive structure. You can't enjoy the loot while you drag out the trial for decades.
That is a huge power. And the search committee that selects the Lokpal also has a unique quota system.
Yes, this was a big point of debate. The Act mandates that 50% of the search committee members must come from SC, ST, OBC, minorities, and women categories.
Why was that included?
To ensure that the body selecting the ultimate ombudsman represents the true diversity of India, not just the traditional power elites.
And quickly, at the state level, we have Lokyuktas.
Mandated by the Act, but it's a bit of a patchwork quilt out there. Every state has tweaked the model.
How so?
Some states require judicial qualifications for the Lokyukta, like UP and Gujarat. Others, like Bihar and Rajasthan, don't. Some include the chief minister in their net, like Himachal and Andhra, while others keep the CM out. It varies quite a bit.
Okay, so we've covered rights, transparency, and corruption. We have one final piece of the puzzle left.
The youngest and most specialized of all these bodies.
The National Investigation Agency, the NIA.
This one has a very tragic, very specific origin story.
It was born from the ashes of the 26/11 Mumbai terror attacks in 2008.
That attack changed everything.
It really did.
It exposed a fatal flaw in our national security architecture. Terrorism is national, often international, but our police forces were fragmented, siloed by state borders.
You had terrorists moving across the country, but the Maharashtra police couldn't operate in Gujarat and so on.
Exactly. The Second Administrative Reforms Commission had already recommended a federal agency, But 2611 was the catalyst that forced Parliament's hand. The NIA Act was passed in 2008.
So how is the NIA different from the CBI? They both seem like national police forces.
Two ways: focus and power. The CBI is a generalist. They do corruption, economic crime, special crimes like murder. The NIA is a specialist.
A specialist in what?
It is strictly for counterterrorism, terror financing, and offenses under specific scheduled acts, things like the Atomic Energy Act or the Anti-Hijacking Act. They don't investigate bank fraud.
Okay, so a narrow but deep focus. And the power.
This is the big one. Remember the general consent problem the CBI has?
Yes, needing the state's permission?
The NIA doesn't have it. The NIA has concurrent jurisdiction.
What does that mean in plain English?
It means the NIA is empowered to investigate terror offenses affecting the sovereignty, security, and integrity of India anywhere in the country. They do not need the state government's permission to step in.
So if there's a terror plot in any state, the NIA can go in, take over the case, and the state police can't stop them.
Exactly. It is a true federal police force, but with a very strict and limited mandate for terror cases only. It acts as the country's central nervous system for counterterrorism, collecting intel, maintaining a national terror database, and coordinating across all states.
It's a specialized shield built for a very specific threat.
It is.
So we have unpacked the alphabet soup. It's a lot to take in, I know. We have the NHRC watching our dignity, the CIC ensuring we know what's happening, the CVC and Lokpal fighting corruption, the CBI investigating crimes, and the NIA shielding us from terror.
And if you step back and look at the synthesis of it all, you shouldn't just see a list, you should see a system.
The system of.
It's a complex web of checks and balances, just like the framers of the Constitution intended for the government itself.
So the CVC watches the CBI.
The Lokpal watches the CVC and the CBI.
The courts watch everyone.
And ideally, the people, the citizens, watch them all through the window, provided by the CIC and the RTI Act.
The robust design on paper.
It really is. But that brings us to the final takeaway from all this. We can memorize the composition of the committees and the tenure of the chairpersons for an exam. But the soul of these institutions isn't in the statute book.
What do you mean by that?
I'll leave you with this thought to mull over. We have the laws, we have the acts, and we have the institutions like Lokpal and the CBI. We have the fancy offices and the retired judges. But their effectiveness, at the end of the day, depends on one single thing.
And what's that?
The political will to let them function without interference.
It's the difference between having a watchdog and keeping that watchdog on a very, very tight leash.
Precisely. It is the eternal battle in any democracy between statutory power and political reality. A watchdog is only as useful as the master allows it to be.
That is something to chew on. These bodies are only as strong as the independence they are actually granted in practice, not just on paper.
Indeed.
Well, that is it for this deep dive into India's institutional framework. Hopefully that alphabet soup makes a little more sense to you now. Until next time, keep asking questions.
And keep learning.
See you in the next deep dive.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant. We are moving away from the noisy debates of Parliament, the shouting matches, the walkouts, the breaking news tickers, and we are diving straight into the engine room of the Indian state.
The silence of the machinery, so to speak.
Exactly. We're looking under the hood today, not just at the politics we see on the news, but the machinery that actually grinds the gears. We're talking about the nuts and bolts of the state. Who legally owns the assets when a government topples? Can you actually sue the government if their driver crashes into you? How is the country structured to handle massive disasters like the tsunami? And of course, the very specific, often controversial rules running our bureaucracy.
It's a fascinating mix today. Usually when people talk about the Constitution or Indian polity, they get caught up in the rights part. Fundamental rights, freedom of speech, equality, religion.
Yeah, the big headlines.
Yeah. Right. That's the poetry of the Constitution. It's the soul. But the source material we have in front of us today, well, this is the plumbing.
The plumbing.
Absolutely. We are covering Articles 294 to 300, the Disaster Management Act, the 97th Amendment regarding cooperatives, and the complex world of civil services. This isn't about high ideals or philosophy. It's about authority, responsibility, and liability.
Okay.
It answers the question, how does this massive abstract entity called the state actually function as a legal person? When does it pay the bill? When does it own the land? How does it hire and fire?
That's the operating system logic. It's the code running in the background that keeps the apps working. So let's unpack this. We have a lot of ground to cover, and we should probably be thorough. Let's start with the government as a legal entity.
Sounds good.
The sources mention Articles 294 and 295 regarding the succession of property. Now, to the uninitiated, succession of property sounds like we were talking about a family inheritance dispute or maybe a scene from a fantasy show, but we were talking about the state here.
Right. To understand this, you have to transport yourself back to a very specific moment in history, 1947 or even 1950, when the Constitution came into effect. You had the Dominion of India, you had provinces, you had princely states. It was a bit of a patchwork.
A real mix.
So when the Republic of India is born, what happens to the desks, the buildings, the debts, the bank accounts? Does the new government say, new phone, who dis, and just walk away from the old debts?
Sorry, that debt belonged to the British Raj. Talk to them. They moved to London.
Exactly. That would be absolute financial chaos. You just can't have a country filing for bankruptcy or erasing asset registers just because the name changed or the constitutional status shifted. Creditors would lose faith. The economy would collapse.
Of course.
So Articles 294 and 295 are purely about continuity. They clarify that all rights, liabilities, and obligations that belong to the former Dominion of India or the provinces before the Constitution commenced automatically transferred to the Union or the corresponding state governments.
It's a legal passing of the baton.
It is. If the old province owed money for a road project, the new state owes that money. If the old administration owned a courthouse, well, the new state owns the courthouse. The state doesn't just reset every time there's a political shift or a constitutional change.
It provides stability.
It provides stability to creditors, citizens, and international partners alike. The entity remains, even if the label changes.
Makes perfect sense. It ensures the government pays its bills. But here's where it gets really interesting and a bit darker, maybe. The source material brings up these Latin terms, eschit and bona vacantia, under Article 296. It sounds like a spell from Harry Potter, or maybe a rare disease. I'm sorry you've been diagnosed with a sheet. What are we looking at here?
It does sound archaic, doesn't it? These are very old common law concepts that we've retained in our constitutional framework. Escheat basically refers to the transfer of estate or property to the state when an individual dies intestate, meaning without a will, and has no legal heirs.
So let's paint a picture. Imagine a reclusive millionaire. No kids, no spouse, no distant cousins, no will. Passes away. The mansion doesn't just become finders keepers. I can't just walk in and claim it.
No, you can't just move in and start redecorating. That's where escheat kicks in. The state steps in as the ultimate heir. The logic, you see, is that there is no such thing as property without an owner. If the lineage ends, the property reverts to the sovereign, which in our case is the state.
And bona vacantia, what's the difference?
It is similar. It literally translates from Latin to ownerless goods. If property is abandoned, or let's say a company dissolves and leaves assets behind with no claimant, it doesn't just sit there in limbo. The Constitution dictates that this property vests in the state.
So if there's no owner, the government becomes the owner by default. It's like the ultimate vacuum cleaner of assets.
That's a colorful way to put it, but yes. The logic is that property must always have an owner to ensure it's managed, maintained, and liable for taxes. If no person claims it, the state claims it.
Now, does this apply to finding treasure in your backyard? Or, more realistically, finding oil? Because Article 297 talks about things of value lying under the ocean. This feels like it has massive geopolitical implications.
This is a massive point for the economy and national security. Article 297 states that all lands, minerals, and other things of value underlying the ocean within the territorial waters, or the continental shelf, or the exclusive economic zone, the EEZ of India, vest in the Union.
Wait, vest in the Union, not the nearby state.
That's the key distinction. If you find oil off the coast of Maharashtra or Tamil Nadu, generally, those rights in the EEZ belong to the Union government in New Delhi, not the state government adjacent to it.
I can see why that would be a point of contention. A state might look at that oil rig and say, hey, that's in our backyard.
They might, but the Constitution is clear. It consolidates strategic resources under central control. You don't want individual states competing over maritime boundaries or selling off oil rights independently to foreign companies. It treats the ocean wealth as a national asset to be used for the development of the entire country, not just the coastal state.
Okay, so the government owns things. It inherits things. It claims ownerless things. But the government also buys things. It builds bridges, hires IT consultants, buys fleets of cars. Article 299 deals with government contracts. The notes here mention a formalities trap. Sounds ominous. Is it a trap for the government or the person doing business with them?
It is a trap for the careless private citizen or contractor. This is a vital protection mechanism for public funds, but it catches a lot of private contractors off guard. You see, that government isn't a person. You can't just shake hands with India over a cup of tea.
Right.
So for a contract to be legally binding on the government, Article 299 lays down three very specific non-negotiable conditions.
Walk us through them. I'm a contractor. I want to pave a road for the Public Works Department. What do I need to ensure I actually get paid?
Pay attention here, because this has bankrupt people. First, the contract must be expressed to be made by the president or the governor. It can't just say, between the Department of Roads and Mr. Smith. It has to be in the name of the head of state.
Okay, that's number one.
Second, it must be executed on behalf of the president or governor. And third, and this is where people mess up, it must be executed by a person who is specifically authorized to do so under the relevant rules.
So let's play this out. I'm a high-ranking officer, a joint secretary. I really need this road paved before a VIP visit. I send you a letter on my official letterhead saying, I agree to pay you 50 lakhs to pave this road, signed, me. You pave the road, it's beautiful, then the government changes its mind, or maybe I get transferred and the department refuses to pay. Can I take that letter to court?
You can take it to court, but you will likely lose. The court will look at Article 299 and say, was this expressed in the name of the president?
No.
Was this executed on behalf of the president?
Yeah.
Was this officer authorized to sign this specific type of contract? Maybe not. If those specific constitutional formalities aren't met, the contract is void.
Not voidable, but void.
Void ab initio. It's as if it never existed in the eyes of the law.
That is harsh. So I paved the road for free.
Potentially. Or you have to sue for something called quantum meruit, which means fair payment for work done. But you can't enforce the contract terms itself. You can't claim damages for breach of contract because there was no contract.
Wow.
And here is the kicker. The officer who signed it, that joint secretary, they might be held personally liable.
Personally, like out of their own savings.
Yes. Because they didn't follow the constitutional procedure, they stripped themselves of the protection of the state. They acted outside their authority.
Yeah.
However, if the procedure is followed, if the contract is proper, the president or governor is not personally liable.
Of course not.
They are immune. The liability falls on the state funds, not their personal bank accounts.
That seems to be the theme here. The state pays, the individual doesn't, unless the individual messes up the paperwork. Which brings us to the most relatable question in this section. We've all seen government vehicles driving, let's say, assertively.
Assertively is a very polite way to describe it.
Right. So let's say a government truck hits my car, or a police officer wrongfully detains me. Can I sue the government? Article 300 discusses suits and proceedings. What's the verdict? Can I take the state to court?
This is an area where the law has undergone a massive evolution. If you asked this question in 1860, the answer would have been a flat no. We inherited this British common law concept. The king can do no wrong. This is known as sovereign immunity.
Which is a great policy if you're the king, not so much if you're the peasant getting run over by the king's carriage.
Precisely. In the early days, specifically referencing the Pinot Steam Navigation Company case from the colonial era, the courts drew a hard line between sovereign functions and commercial functions.
Okay, what's the difference?
Sovereign functions are things only the state can do. Waging war, making treaties, perhaps general administration. Commercial functions are things like running a railway or a bus service.
So if an army tank hits me during a drill, bad luck, sovereign immunity. But if a government bus hits me, I can sue.
That was the old logic. But as the state grew, that distinction became, well, ridiculous. The state does everything now. It runs hotels, steel plants, banks, airlines. So the source highlights a shift, specifically referencing the Common Cause case of 1999 and the prisoner murder case of 2000.
The prisoner murder case, that sounds intense. What happened there?
It was a tragic case involving the safety of prisoners in state custody. The argument was that maintaining prisons is a sovereign function, so if a prisoner is killed by other prisoners due to negligence, the state shouldn't be liable.
Oh, wow.
But the Supreme Court effectively said that in a modern welfare state, the government enters so many spheres of life that the old distinction is blurring. You cannot hide behind sovereign immunity for negligence. If a government employee, through negligence, causes harm, a tort, in legal terms, the state is liable, just like any other employer would be.
The text mentions the Castore Law case from 1965 as well. That seems to be the villain of this story, or at least the cautionary tale.
Customary law is the classic example of the old rigid view. In that case, police officers misappropriated gold that had been seized from a jeweler. The officers stole it and fled to Pakistan. The jeweler sued the state for the value of the gold. The court back in 1965 upheld the state's immunity, saying the police were performing a sovereign function of law enforcement and seizure, so the state wasn't liable for the theft committed by its employees.
That sounds incredibly unjust. We stole your gold, but we did it while wearing a uniform, so it's legal.
Exactly. It was widely criticized, and that's why modern judgments have largely overruled that reasoning. The courts have stated clearly, the state cannot claim immunity for violating a citizen's life or liberty. The king can do wrong, and more importantly, the king must pay for it.
So there's accountability.
It adds a necessary layer of financial accountability. You can't just shrug and say sovereign function.
It's a relief for the common citizen.
Yeah.
It means the state isn't just a leviathan that can crush you without consequence. Now, speaking of accountability and managing chaos, let's shift gears to disaster management. The source material draws a direct line from a massive tragedy to a piece of legislation.
Yes. Sometimes laws are born out of calm debate, and sometimes they're born out of trauma. The turning point here was the 2004 tsunami.
I remember that. It was unprecedented.
It was, and it exposed the gaping holes in India's approach. Until then, our approach was ad hoc. A disaster happens, we scramble, we send blankets, we send rice. It was purely relief-centric. We were reactive.
Right.
In response, the government enacted the Disaster Management Act, 2005. The source emphasizes that this act fundamentally changed the philosophy from just relief, cleaning up the mess, to prevention, mitigation, and preparedness.
It's the difference between having a first aid kit and wearing a seatbelt.
Perfect analogy. And to enforce the seatbelt rule, they created a very specific hierarchy. Who do you think runs the show?
Well, in a bureaucracy, usually a committee. Probably buried somewhere in the Home Ministry.
It is a committee, but look at who heads it. At the top, we have the NDMA, the National Disaster Management Authority. It is headed by the Prime Minister himself.
The PM. That's not just a figurehead position.
It signals intent. It puts the highest executive weight behind the decisions. It can have up to 9 members, and the vice chairperson actually holds the rank of a cabinet minister.
That's real power.
That shows you the clout this body carries. If the NDMA says, do this, you do it. It centralizes command during chaos.
And how does that translate down to the states? Because disasters usually happen locally. A flood in Bihar, a cyclone in Odisha.
It mirrors the central structure. At the state level, you have the SDMA, headed by the chief minister. This ensures that the highest executive authority in the state is directly responsible. You can't pass the buck to a junior minister.
I see.
The NDMA sets the policies, approves the national plan, and coordinates enforcement. They also oversee the NDRF, the National Disaster Response Force.
Those are the folks in the orange uniforms we see during floods. They always seem to be the first ones in.
Correct. They are a specialized force trained specifically for chemical, biological, radiological, and nuclear emergencies, as well as natural disasters. But the act isn't just about the guys in orange boats. The source lists functions like recommending funds, coordinating with other countries, but one specific point stands out: integrating disaster prevention into development plans.
What does that mean in practice, integrating into development?
It means if you are approving a new airport, or a metro line, or a hospital, the disaster management guidelines need to be part of the blueprint before you break ground. You don't build the hospital in a floodplain. You don't build the bridge without seismic dampeners.
So it's proactive.
That's the mitigation aspect. It's boring, invisible work, but it saves more lives than the rescue boats. It forces the bureaucracy to think about disasters on a sunny day.
Moving from top-down management to something that is supposed to be more grassroots, let's talk about cooperative societies. The sources discuss the 97th Constitutional Amendment. Now, I have to ask, why was it necessary to amend the Constitution, the supreme law of the land, just for local co-ops?
It does seem like overkill, doesn't it? But this is a great example of the center trying to fix a systemic rot. Cooperatives, think your local housing society or credit society are supposed to be democratic and autonomous, of the people, by the people.
Right, that's the ideal. Neighbors helping neighbors.
But the reality, For decades, they became political tools. Local politicians would capture them. If a board member didn't agree with the government would just suspend the board. They would appoint an administrator, basically a bureaucrat, to run the co-op.
And elections.
Elections wouldn't be held for years. The cooperative became a government department in disguise.
So the 97th Amendment was a rescue mission.
It was an attempt to constitutionalize their independence. It elevated cooperatives to Part IXB of the Constitution. It's no longer just a statute. It's a constitutional right to form and run these properly.
So what changed practically? How does this stop the politician from taking over?
Several ways. First, mandatory diversity. The sources state that the board of a cooperative society must have 1 seat reserved for scheduled castes or scheduled tribes and 2 seats for women. This isn't a suggestion. The state legislature has to ensure it. It breaks the old boys club dynamic that often plagued these local bodies.
And I see a note here about term limits. That's key.
Yes. The term of the board is fixed at exactly 5 years. And crucially, there are strict rules on dissolution. Previously, a government could supersede a board and leave it in limbo forever. Now, a board cannot be superseded or suspended for more than 6 months.
That's a hard stop.
It is.
Yeah.
If you suspend a board, you must hold elections and reinstate a new one within that 6-month window. You can't just leave your administrator in charge indefinitely. It forces democracy whether the local powers like it or not.
It also mentions audits.
Right. It mandates audits within 6 months of the financial year ending and requires annual general body meetings. It's an attempt to force professional corporate management into a sector that was often run like a personal piggy bank.
Speaking of managing personal fiefdoms, let's get to the juicy part. Political parties. The source material has a very interesting analysis of how Indian political parties differ from those in the West.
It's stark contrast.
The text says Western parties are usually socioeconomic. Labor versus capital, Democrats versus Republicans. The right wants lower taxes, the left wants more social services. But here, it says it's different.
It is deeply different. The text notes that while Western parties might split along lines of tax policy or union rights, Indian parties often form on the basis of religion, caste, language, or culture.
So identity politics.
Exactly. You have parties mentioned in the text, like the Shiv Sena, DMK, Akali Dal, or BSP. These aren't just ideological groupings, they are identity groupings. They say, I represent this community or this region.
And there's a phrase here that pops out, personality cult.
Yes, the text doesn't mince words. It mentions that parties are often centered around a supreme leader rather than a collective ideology. It cites examples like AIADMK revolving around MGR and later Jayalalitha, or a Telugu Desam party around NT Ramarao.
It's true. The party becomes an extension of the leader's persona. If the leader leaves, the party often collapses or splits.
Exactly. Even the names of parties often carry the leader's name. Congress, I for Indira. Biju Janata Dal. It is a unique Indian phenomenon. In the UK, you don't have the Boris Johnson Conservative Party.
That would be something. The sources list the pros and cons of these regional parties. On one hand, they seem to make democracy more representative. They give a voice to people who feel ignored by Delhi.
They do. The pro argument is that they provide better governance at local levels because they understand local issues. The text mentions they check the monopoly of a single national party. If a national party gets too arrogant, the regional parties pull them back to earth.
They fill a vacuum.
They fill the vacuum when national parties fail to address local aspirations.
But the cons list is pretty heavy.
It is. The source argues that this narrow focus often ignores the national interest. They promote regionalism over nationalism. A classic example given is interstate water disputes. Think of the Kaveri dispute between Karnataka and Tamil Nadu. Regional parties often block solutions because they can't afford to look weak to their specific voter base. Compromise becomes political suicide.
It leads to that fragmentation we see. Unstable coalitions.
Right. And focusing on short-term populist measures, free TVs, free grinders, or loan waivers, rather than long-term infrastructure just to secure that specific vote bank.
Now, for the listeners who love the technical details, how does a party actually become a national party? I see symbols like the lotus, the hand, the elephant. You can't just draw a symbol on a napkin and claim it.
No, you definitely can't. It's a strict numbers game managed by the Election Commission. This is the math of recognition mentioned in the outline. To be recognized as a national party, a party needs to meet one of three specific conditions. It's like leveling up in a video game.
Lay them on us. How do I get my podcast party to national status?
Okay, get your calculator. Condition 1. You need to secure 6% of valid votes in 4 or more states. This can be in Lok Sabha or Assembly elections. And this is a big Andy. You must win at least 4 Lok Sabha seats.
That sounds incredibly hard. 6% in 4 states plus 4 MPs. Okay, what's option 2?
Option 2. You win 2% of the total Lok Sabha seats. Currently, that's 11 seats. But there's a catch. These members must be elected from at least 3 different states.
So I can't just sweep one state and claim to be national. I need spread.
Exactly. You need a footprint. And condition 3. Be recognized as a state party in at least 4 states.
And what do they get for this? Why chase the status? Is it just bragging rights?
Oh, the perks are significant, actually. The biggest one is the symbol. A recognized national party has a reserved symbol nationwide. No one else can use it. If you are the hand, you are the hand everywhere.
And if I'm unrecognized?
You have to choose from a list of free symbols every time you run. One election, you might be a gas cylinder. The next, you might be a kite. It completely destroys your brand recall.
That's huge in a country with varying literacy levels. The symbol is the party.
Precisely. Also, recognized parties get free airtime on state media during elections. And, this is a small but crucial logistical point, they only need 1 proposer for filing a nomination. Unrecognized parties need 10.
It's the difference between flying business class and flying standby.
That's a good way to put it. It streamlines your entire political operation.
Let's move to the glue that holds this diverse nation together, or sometimes causes friction. Language. The Constitution has a whole part dedicated to this, part of 7.
Right. And this is a sensitive topic. The Constitution establishes Hindi in the Devanagari script as the official language of the Union, but the framers knew this wasn't enough. They set up a mechanism to monitor this, the Parliamentary Committee on Official Language.
The text details the composition of this committee. It's not just a random group of MPs.
No, it's a 30-member committee.
No.
20 from the Lok Sabha and 10 from the Rajya Sabha. They are elected by proportional representation. Their specific mandate is to review the progress of Hindi usage for official purposes and report directly to the president. They are the watchdogs of language policy.
But what about the courts? This is where it gets tricky for the common man. If I walk into the Supreme Court, can I argue in Hindi? Can I argue in Tamil?
Generally, no. The source text is very specific here. Until Parliament decides otherwise, all proceedings in the Supreme Court and High Courts must be in English.
Why English?
Uniformity. The Supreme Court draws judges and lawyers from all over India. If a lawyer argues in Bengali and the judge is from Kerala, the system breaks down. English acts as the bridge language for the legal system. It ensures that the interpretation of laws is consistent across the country.
Is there any wiggle room?
There is a little nuance for high courts. A governor, with the president's previous consent, can authorize the use of Hindi or the official state language for proceedings in the high court. So, in theory, you could argue in Hindi in the Allahabad High Court or the Rajasthan High Court.
However, I sense a however.
However, judgments, decrees, and orders must still be in English, or at least accompanied by an authoritative English translation. The official legal record is maintained in English. You can't have a judgment that no other high court can read.
The source also lists classical languages. We hear about Tamil, Sanskrit, Kannada being classical. What does that mean? It's not just about being old, is it?
It's about heritage and originality. To be a classical language, there are strict criteria. First, a recorded history of 1,500 to 2,000 years. Second, a body of ancient literature considered valuable heritage by generations.
And the third,
Crucially, it must have an original literary tradition. It cannot be borrowed from another speech community.
so it has to be an original root, not a branch.
Exactly. It separates the parents from the children, linguistically speaking.
Finally, let's talk about the people who actually implement all these rules. The bureaucrats, the civil services, the steel frame of India. The text discusses all India services. We hear about the IAS and IPS all the time. What defines them constitutionally?
Article 312 is the bedrock here. The unique thing about all India services, like the IAS, IPS, and the Indian Forest Service, IFOS, is their dual nature. They are recruited and trained by the center. They answer to Delhi initially, But then they are allocated to states. They serve in the states.
They are the connective tissue.
Yes, they are the link between the two levels of government. They bring a national perspective to state administration. They are supposed to be the steel frame because they hold the structure together regardless of which political party is in power in the state.
And who decides if we need a new one? Can the Prime Minister just create an Indian cyber service tomorrow?
No. This is one of the special powers of the Rajya Sabha. Why the Rajya Sabha? Because it represents the states. Since these services impact state autonomy, you are essentially sending central officers to run state departments. The states have to agree.
That makes sense.
So only the Rajya Sabha can initiate the creation of a new All India service. They need to pass a resolution with a 2/3 majority. The Lok Sabha cannot start this process.
Now, for the most controversial part, job security. We often hear that it's impossible to fire a government servant. Government job means life settled. Is that true?
It's difficult, but not impossible. The Constitution sets up a tension between two articles. Article 310 lays down the pleasure doctrine. It says that civil servants serve during the pleasure of the president or governor. Theoretically, this means they can be dismissed at any time. The president is no longer pleased with you. Goodbye.
But clearly that doesn't happen. You don't see mass firings.
Because Article 311 steps in, it provides massive safeguards. It places two major restrictions on that pleasure.
Restriction 1.
A civil servant cannot be dismissed by an authority subordinate to the one who appointed them. If the president appoints you, a joint secretary cannot fire you. You have to be fired by the top boss. This prevents petty office politics from leading to dismissal.
And restriction 2.
This is the big one, the due process clause. No dismissal, removal, or reduction in rank can happen without an inquiry. In this inquiry, they must be informed of the charges and given a reasonable opportunity of being heard.
Reasonable opportunity. That sounds like a lawyer's dream. That sounds like it could take years in court.
Probably. And it often does. This is why accountability can be so slow. The officer can challenge the inquiry at every step. I wasn't heard properly, the evidence wasn't shown to me, the inquiry officer was biased. It drags on. However, the text lists exceptions where this inquiry can be skipped.
Oh, when can they skip it? When does the shield drop?
3 scenarios. 1, if the person is convicted of a criminal charge. If you are convicted of corruption or murder in a criminal court, you don't get a separate departmental inquiry. You are out.
Okay, makes sense.
2, if holding an inquiry is not reasonably practicable, for example, in a chaotic security situation, or if witnesses are being intimidated by the officer. And 3, if the president or governor decides that in the interest of the security of the state, it is not expedient to hold an inquiry.
So for spies.
Exactly. If you catch an officer selling secrets or working against the state, you don't hold a public inquiry and expose the secrets further. You fire them under this exception. It's the nuclear option for personnel management.
Wow. Okay, let's take a breath. We've covered a massive amount of ground. We went from the government being sued for a car accident to how the prime minister triggers disaster response, to the math of how a political party gets the lotus symbol, and finally, why it's so legally complicated to fire a bureaucrat.
It really highlights that the Constitution isn't just a list of high ideals, it's an instruction manual. These dry rules, Article 299, Article 311, the Disaster Management Act, are the operating system of Indian democracy.
Right.
They balance power, they balance the center against the states, they balance the government's power against the citizens' rights, and they balance political will against bureaucratic stability.
And even looking at the cooperatives, it balances local management against political takeover. It's all about checks and balances.
Precisely. It's a machine designed to run even when the operators are flawed. It anticipates that people will be greedy or negligent or power hungry, and it builds guardrails against that.
So here is a thought to leave you with. We talked about the rise of regional parties being a result of national parties failing to address local aspirations. As India grows more diverse and economically complex, will we see more fragmentation? Will we end up with 50 strong regional parties holding the center to ransom, or will national parties learn to absorb these local agendas?
That is the big political question. Can a single umbrella hold 1 billion aspirations, or do we need 50 umbrellas?
And regarding Article 311, does that immense protection given to civil servants ensure they can say no to corrupt politicians, or does it just protect incompetence?
That is the eternal question of Indian administration. Security versus accountability. Where do you draw the line? Too much security leads to lethargy. Too little leads to yes men.
Indeed. So the next time you see a government notification or a political rally or even a disaster relief truck, try to look at it with these constitutional X-ray glasses. You might see the machinery working underneath. Thanks for listening to this deep dive.
It was a pleasure. Keep learning.
Moving ahead, let us understand the next important point. From an examination perspective, this point is significant.
That is quite the serious opening, but you know what? It actually fits perfectly.
Oh.
How so? Well, because today we aren't just skimming the surface of democracy or, chatting about the latest poll numbers. We are popping the hood.
We're looking at the engine room. Yeah.
Exactly. We're looking at the nuts, bolts, the laws, and the sociology that makes the Indian election system the largest democratic exercise in human history actually function.
I'm glad you think so. Yeah. I wanted to start with that intense focus, because when we usually talk about Indian elections, we talk about the speeches, the rallies, the winners, and the losers. It's all very theatrical.
It is.
But beneath all that noise is this massive, silent skeleton of constitutional mandates and bureaucracy. It's like a skyscraper. We admire the view from the top, but we rarely look at the steel beams holding it all up.
That's a perfect analogy. And for anyone who is a learner, whether you are prepping for a competitive exam, a job interview in public policy, or, just trying to be a more informed citizen, understanding the skeleton is non-negotiable.
Absolutely.
We have a massive amount of ground to cover today. We are going to look at the machinery who actually runs the show. We will decode the legal framework, specifically that confusion between the 1950 and 1951 acts.
Right. And then we'll get into the reforms, the technology, and finally, the sociology of why people vote the way they do.
It's going to be a real deep dive.
So let's unpack this starting right at the top, the constitutional powerhouse. Our sources point us directly to Article 324. Now, I know Article 324 is famous. People quote it on the news all the time, but what does it actually do?
Article 324 is the bedrock. In simple terms, it vests the power of superintendence, direction, and control of elections in the Election Commission of India, or the ECI. It is the article that gives the commission its teeth. And the scope here is very specific, which is something people often miss. It covers elections to parliament, the state legislatures, and the offices of the president and the vice president.
So it's a centralized command center.
Yeah.
But notice what you didn't say there. You didn't mention panchayats or municipalities.
Precisely. And that is a common trap. Local body elections are handled by state election commissions. Article 324 is all about the national and state legislative architecture.
Got it. And what about the structure of the ECI itself?
Structurally, it's evolved quite a bit. It's not a one-man show anymore. Currently, the ECI consists of one chief election commissioner and 2 election commissioners.
It's a triumvirate. But here's the logistical problem. The ECI sits in Nirvakan Sadan in New Delhi. They can't personally oversee a polling booth in a remote village in Odisha or a bustling ward in Mumbai.
Not a chance.
They need arms and legs. And that's where the hierarchy of responsibility comes in, right? This is the machinery part of our deep dive.
And this machinery is fascinating because it is essentially a borrowed army. The ECI doesn't have millions of permanent staff. It drafts them. It flows from the national level right down to the person inking your finger.
Let's run through this chain of command, because for a student of polity, these titles really matter. At the state level, you have the CEO, and no, not a chief executive officer like in a corporate boardroom.
No, in this context, the CEO is the chief electoral officer. This officer is appointed by the Election Commission of India, but here is the catch. It's done in consultation with the state government.
Ah, so there's a federal element to it.
There is. Their job is to supervise election work across that entire state. They are the ECI's primary representative in the state capital.
Okay, so the CEO runs the state. Then we move down to the district level. This is usually where the district magistrate or collector puts on a different hat, isn't it?
Correct. When the election notification drops, the district magistrate effectively transforms. They become the DEO, the district election officer.
So it's the same person, different job title.
For that period, yes. The ECI nominates an officer of the state government to this post. They are the ones supervising the work in the district, handling logistics, storage of EVMs, and just the overall management.
But if you want to get to the real ground zero of an election, where the heat really is, you have to look at the constituency level. This is the domain of the returning officer, or the RO.
The RO is pivotal. I often say the RO is the person with the highest blood pressure in the district on counting day.
I can imagine.
They are responsible for the actual conduct of elections in a parliamentary or assembly constituency. They check the nominations, they can disqualify candidates if papers aren't in order, and most importantly, they're the ones who ultimately declare the result for that seat.
They sign the certificate, the final word.
Exactly. And they are assisted by AROs, or assistant returning officers. But we can't forget the preparation phase. Before you can even have an election, you need a list of voters. The RO doesn't make that list.
Right. That happens way before. That responsibility falls to the ERO, the Electoral Registration Officer.
Correct. The ERO, their specific statutory duty is the preparation and revision of electoral rolls. So if your name is missing from the list or spelt wrong, you don't blame the returning officer. You look for the electoral registration officer.
So the ERO makes the list, the RO conducts the race, and finally on the actual day of voting, inside that school or community center, who is the boss?
That would be the presiding officer or the PO. They conduct the poll at the polling station with the help of polling officers. They are the ones ensuring the secrecy of the ballot and the integrity of the machine inside that specific room. They have magisterial powers inside that booth.
It really is a massive pyramid of authority. But here's where it gets really interesting to me. The system doesn't just trust these officers blindly, because these officers live in the district, right?
They do.
They might have local biases or face local pressure. So the Election Commission sends in its own spies. Well, not spies, but observers.
Observers is the correct term, though they certainly act as the eyes and ears of the commission. These are government officials nominated by the ECI to ensure free and fair elections, and crucially, they are parachuted in from outside the state.
To ensure neutrality.
Exactly. A bureaucrat from Tamil Nadu might be sent to observe an election in Bihar. It breaks any local chain of influence.
Let's break them down, because there isn't just one type. It's like a specialized squad. First up, the general observers.
These are usually senior civil servants, IAS officers. They monitor the smooth conduct of the process at every stage. They are the generalists. They look at everything from nomination scrutiny to the transport of EVMs.
Then you have the ones that make the candidates sweat, the expenditure observers.
Absolutely. These are appointed from central government services, often the IRS income tax officers. Their specific task is to follow the money. Elections in India are expensive, and there are legal limits on spending. The expenditure observer monitors candidate election expenses and, crucially, ensures voters aren't being lured. If cash or liquor is flowing, the expenditure observer is the one tasked with spotting it and coordinating the seizure.
Speaking of law and order, there are also police observers.
Yes, these are senior IPS officers. They are stationed at the state or district level, depending on how sensitive the area is. They don't look at the voting machines, they look at the force deployment.
So they're checking if the paramilitary forces are positioned correctly, if the area is secure enough for a free vote.
That's their entire focus, law and order.
Now here's a newer one that I found fascinating in our sources, the awareness observer. This was introduced fairly recently, right?
Yes, first introduced in the 16th Lok Sabha elections back in 2014. Their job is interesting. It's twofold. One, they oversee voter awareness measures, making sure the system is effectively telling people how and when to vote.
Okay, that makes sense.
But two, and this is critical, they monitor the media for paid news.
Paid news. That's when a candidate pays a newspaper to run a flattering article that looks like news, but is actually just an advertisement in disguise.
Exactly. It's designed to mislead the voter. The awareness observer checks that the election machinery isn't interfering with voters' awareness and that the media landscape isn't being manipulated purely by money.
And finally, the most granular level, the micro-observers. These guys sound like they are looking at things under a microscope.
In a way, they are. These are appointed from central government or public sector undertakings to work at specific polling stations. They aren't running the station. The presiding officer does that. The micro-observer just sits there and watches.
A silent guardian.
You could say that. They check the mock poll in the morning, they watch the sealing of the EVM, and if they see any procedural violations inside the booth, they report directly to the general observer. They are the fail-safe at the most granular level.
It's an incredible system of checks and balances. So that's the machinery. But a machine needs an operating manual. This brings us to the legal framework, and specifically, the tale of two acts. I feel like every student of Indian polity gets confused here. We have the Representation of the People Act, 1950, and the Representation of the People Act, 1951. Why two? Why not just one big Indian Election Act?
It is a common point of confusion, but if you look at the timeline of an election, it makes a lot of sense. The easiest way to distinguish them is to think of preparation versus conduct.
Okay, preparation versus conduct.
The 1950 Act is all about setting the stage before the actors even arrive.
Let's unpack the 1950 Act first, then. The Preparation Act.
So the Representation of the People Act, 1950, deals with the structural basics. It handles the allocation of seats in Parliament and state legislatures. It deals with the delimitation of constituencies, literally drawing the lines on the map.
The boring but essential stuff.
Crucially essential. It also handles the qualifications of voters and the preparation of electoral rolls. So if you are asking who can vote or how many seats does the state get, you are looking at the 1950 Act.
Preparation. Got it. So the 1951 Act is the game day rulebook.
That's a great way to put it. The Representation of the People Act, 1951, focuses on the actual conduct of elections. It covers qualifications and disqualifications for membership, so who can run as a candidate.
Right.
It covers corrupt practices, election disputes, and the administrative machinery for running the poll. If you are asking, can a convicted criminal run for office, or is this campaign speech illegal? Because you are deep in the territory of the 1951 Act.
That distinction is super helpful. 1950 prepares the ground. 1951 plays the match. Now, alongside these acts, we have some heavy-hitting constitutional articles, specifically the 320s range. We already touched on 324, but Article 326 is a big one.
Article 326 is the foundation of our democratic inclusivity. It enshrines elections based on adult suffrage. Every citizen who is not otherwise disqualified has the right to vote.
And we should note the history here. Originally, the voting age was 21, right?
It was. It was lowered to 18 by the 61st Amendment Act, 1988, which became effective on March 28, 1989. That single amendment enfranchised millions of young Indians.
It basically said if you are old enough to be treated as an adult by the law, you are old enough to choose who makes the law.
A powerful statement.
And then there is Article 329, which seems to put a firewall around the election process.
It does. Article 329 places a bar on interference by courts in electoral matters, specifically regarding the delimitation of constituencies. Basically, once the boundaries are drawn and the process starts, you can't drag that issue to court to stall the election.
Why is that?
The logic is that elections are a sovereign function. They have to happen on time. You can't have them held hostage by endless litigation over boundary lines.
But what if I have a dispute about the election results? Say I'm a candidate, and I think the counting was rigged. There was some back and forth about tribunals in the history of this, wasn't there?
There was. Article 323B originally allowed for election tribunals, and the idea was to exclude the high courts from jurisdiction to speed things up. The government thought, let's keep the regular courts out of this.
But the Supreme Court stepped in.
Of course. In the famous Chandra Kumar case of 1997, the court ruled that excluding the high court's jurisdiction was unconstitutional.
Because judicial review is part of the basic structure of the Constitution.
Exactly. You hit the nail on the head. Judicial review is a basic feature. So today, if you have an election petition, a complaint about the result, it is heard by the High Court with an appeal lying to the Supreme Court. There are no secret tribunals.
So no special secret courts. It goes through the higher judiciary. Now, moving from the laws to how they've changed, the system isn't static, it evolves. Our sources highlight a significant period of reform from 1996 to 2013. Let's look at the 1996 reforms first. These were heavily influenced by the Dinesh Goswami Committee.
The Dinesh Goswami Committee in 1990 was a watershed moment. It recommended a whole slew of changes to clean up the process. By 1996, several of these became law. One of the most visible changes was how candidates are listed on the ballot paper. Before this, it could be a complete jumble.
I've seen this on the EVMs. It's very structured now, isn't it?
It is. The 1996 reforms classified candidates into three clear categories. First, you have the candidates from recognized political parties. The big national and state parties, they get top billing.
Okay.
Second, you have candidates from registered unrecognized parties. And third, you have independents. Within each of those categories, they are listed alphabetically. It brings order to the chaos, especially in constituencies with dozens of candidates.
Another 1996 reform dealt with national honor. What's that about?
Yes, this is under the Prevention of Insults to National Honor Act, 1971. The reform made it so that if you are convicted of insulting the national flag, the Constitution, or preventing the singing of the national anthem, you are disqualified from contesting elections for 6 years.
It signaled that if you want to represent the nation, you cannot disrespect its symbols.
A very clear signal.
Then there is the issue of proposers. I found this funny, but also really practical. To stop people from running just for fame, they made it harder for independents, right?
Precisely. It was to discourage non-serious candidates. You used to have people filing nominations just to see their name on a ballot. The reform changed the rules. If you are from a recognized party, you only need one proposer, one registered elector to sign your nomination.
Just one.
But if you are an independent or from an unrecognized party, you now need 10 proposers. It's a small hurdle, but it filters out those who can't even get 10 people in their entire constituency to back them.
And the dry day rule. Everyone knows this one. No alcohol for 48 hours.
The liquor ban. No sale or distribution of liquor for 48 hours before the close of polls. The idea is to prevent the intoxication of voters and ensure a calm atmosphere. Violation brings 6 months in prison or a fine.
It's about ensuring the voter is sober when making a decision.
At least in theory.
There was also a grim but necessary change regarding the death of a candidate. This sounds like a plot from a crime novel.
It really does, but it was a genuine problem. Previously, if any candidate died during the campaign, the election for that constituency was countermanded, basically canceled and restarted from scratch.
I can see the potential for foul play there. If you were losing and you could somehow arrange for a minor independent candidate to disappear, the election would be postponed, giving you more time.
Exactly. It was a massive loophole for sabotage. The reform changed this. Now, the election is not countermanded unless the deceased was a candidate of a recognized political party.
Oh, that's a key distinction.
A huge one. If an independent candidate passes away, the election goes on. It stops the democratic process from being held hostage by tragedy or, as you said, foul play.
That makes so much sense.
Yeah.
Now, let's jump forward to 2013. This was a year of judicial game changers. The Supreme Court really stepped in with some big rulings.
2013 was explosive for electoral law. The biggest ruling was on immediate disqualification. This is commonly known as the Lily Thomas case. Before this, if a sitting MP or MLA was convicted of a serious crime, something with 2 or more years imprisonment, they had a 3-month window to appeal, and during that appeal, they could keep their seat.
So you can have a convicted criminal sitting in Parliament making laws for the country just because they filed an appeal. That seems wrong.
The Supreme Court agreed. They struck that down. They said the law cannot differentiate between a sitting member and an ordinary candidate. Now, if you are convicted, you are immediately disqualified. No buffer, period. You lose your seat the moment the gavel drops.
That completely changed the landscape for politicians with criminal cases. But there was a nuanced ruling about people in jail and their rights. This one always trips me up.
This is a tricky one. The court clarified that a person in jail or police custody cannot vote. You lose your franchise while incarcerated.
Okay, that part is clear.
However, the ruling also clarified that being in jail does not disqualify you from contesting an election.
Wait. So I can run for office from a prison cell, but I can't cast a vote for myself.
That is the paradox. You can be a candidate, you can even win, but you are disenfranchised as a voter. It comes down to the legal distinction between the statutory right to vote and the statutory right to contest. They are governed by different sections of the law.
Talk about a legal quirk. And one final point on the 2013 reforms affidavits.
This is all about transparency. The court ruled that filing false information in your nomination affidavit is now an electoral offense. It's punishable by up to 6 months in prison.
So you can't lie about your assets or your education anymore.
Well, you can, but now there are real consequences if you're caught. Honesty in that affidavit is legally binding.
This brings us perfectly to the voter's experience. We've talked about the politicians, but what about you and me inside the booth? The 2013 reforms also gave us NOTA.
None of the above. This was the result of a petition by the PUCO, the People's Union for Civil Liberties. The Supreme Court directed the ECI to include a button for those who don't want to vote for any of the listed candidates.
But here is the thing that always confuses people. Is NOTA a right to reject? If NOTA wins, does the election get canceled?
Not exactly, and this is a really important distinction. The ECI had actually proposed something called neutral voting way back in 2001. NOTA, as it's implemented now, is a neutral vote. It records your dissatisfaction.
So it's a protest vote.
It's a protest vote.
Yeah.
But in general elections, it does not disqualify candidates. Even if NOTA gets the highest number of votes, the candidate with the most valid votes is still declared the winner.
So let me get this straight. If candidate A gets 30 votes, candidate B gets 20 votes, and NOTA gets 50 votes, candidate A wins.
Candidate A wins. It's a symbolic weapon, not a decisive one, at least not yet. It signals to political parties that, hey, a significant chunk of people hate all your choices. It shames them, but it doesn't stop them.
It's like screaming into the void, but at least the void is recording it. Speaking of recording, let's talk tech. VVPS, Voter Verifiable Paper Audit Trail.
This was introduced to quell doubts about electronic voting machines, the EVMs. There was a lot of noise about hacking or machines malfunctioning. The VVP is the answer to that. It's an independent printer attached to the EVM.
How does it work for me, the voter, when I'm in the booth?
When you press the button for, say, candidate A on the main unit, the VVPAT printer wakes up. A slip prints out behind a transparent window. It shows the serial number, name, and symbol of candidate A.
And I see it through a little window. For how long?
For exactly 7 seconds. You watch it, you verify it, and then it automatically cuts and falls into a sealed box below.
So I get to see physical proof.
You get to verify, yes, the machine recorded what I intended. And importantly, if a voter believes the EVM is wrong, say the light flashed for a different candidate, there is a test vote procedure they can use.
But there is a catch there, too, isn't there?
Yes. If you, the voter, demand a test vote and you're proven wrong, you can be penalized. It's to prevent people from slowing down the process with frivolous complaints. But the VVPAT creates a physical paper trail that can be audited later if there is a dispute. It's a huge step for trust in the system.
Security and trust are everything. Which brings me to the media. The election season is a media circus, but there are strict laws about when the circus has to stop, Section 126 and 126A.
These are crucial for maintaining the sanctity of the vote. Section 126 imposes the campaign silence. It bans public meetings, processions, and displaying election matter via TV or cinema for the 48 hours ending with the conclusion of the poll.
The idea is to give the voter a break, a quiet period to think, right?
Exactly. It's a silence period. The logic is that you, the voter, need a cooling-off period to think freely before casting your vote without the noise of loudspeakers and last-minute propaganda bombarding you.
And Section 126A, what does that do?
That deals with exit polls. You might notice you never see exit poll results on TV while voting is still happening in other parts of the country.
Right.
That is because of Section 126A. It bans conducting or disseminating exit polls from the start of the first phase of voting until half an hour after the end of the last phase of voting.
Because in a country as huge as India, elections happen in multiple phases over a month or more.
Precisely.
Yeah.
You don't want the voting patterns or predictions from Phase 1 to influence the voters in Phase 7. It keeps the playing field level until the very last vote is cast.
Okay, let's zoom out a bit. We voted, the results are in, and the government is formed. But the game isn't over. Political dynamics take over. And the biggest villain in the Indian political story has often been defection.
The infamous Aya Ram, Gaya Ram culture. That phrase actually comes from a real MLA named Gaya Lal in Haryana back in 1967 who changed parties 3 times in a single fortnight.
Wow.
To curb this instability, we have the anti-defection law contained in the 10th schedule of the Constitution, introduced by the 52nd Amendment Act in 1985.
The goal was to stop MPs and MLAs from hopping parties for power or money. But there was a massive loophole initially, wasn't there? Something called a split.
There was. It was a huge loophole. Originally, the law said that if you defect alone, you are disqualified. But if 1/3 of a party's legislators defected together, it was considered a legitimate split, and they were protected from disqualification.
So let me get this right. If I leave alone, I'm a traitor. But if I bring 1/3 of my friends with me, I'm a separate political entity. It basically legalized mass defection.
Exactly. It encouraged wholesale horse trading. But that changed with the 91st Amendment Act in 2003. This was a critical tightening of the screws. It removed the protection for a split entirely.
So that 1/3 rule is gone.
It's gone. Now, defectors are not protected even if they move in a group. The only exception remaining is a merger, which requires a much higher bar of 2/3 of the members to agree to merge with another party.
So the bar went from 33% to over 66%. That is a huge jump. But who decides if someone has defected?
The Speaker of the House, or the chairman in the Rajya Sabha, for a long time it was believed their decision was final and beyond the reach of the courts.
But knowing the Supreme Court, they probably had something to say about that.
They certainly did. In the Quixote-Holohan case of 1993, the Supreme Court ruled that the Speaker's decision is subject to judicial review. The Speaker acts as a tribunal in this capacity. If their decision is perverse, malified, or violates the Constitution, the courts can step in. The Speaker is not an absolute monarch.
Good to know. And looking at the broader political landscape, this anti-defection law is so relevant because we live in the era of coalition governments.
Yes. The term comes from the Latin coalition, meaning to grow together. Since 1989, starting with the National Front, Then the United Front, the NDA, and the UPA, coalition politics became the norm for decades.
Right.
No single party could secure a majority on its own, so different parties had to join hands based on a common minimum agenda.
And this fragility is why the anti-defection law is tested so often. Now, finally, let's get to the why. What drives these parties? Or rather, what drives the voters who pick them? This leads us to the sociology of elections. The source material lists some heavy determinants: religion, language, and caste.
This is where the machinery meets human behavior. Despite India being a secular state, religion is a major determinant. Political parties often, exploit religious sentiments. We see this in the mobilization of voters, the concept of vote banks, and the alignment of certain communities with specific parties. It's a reality of the political landscape.
And language. We often forget how central language is to our politics, especially if we live in the Hindi-speaking areas.
It is fundamental. Remember, the reorganization of states in India from 1956 and specifically 1965 onwards was largely on a linguistic basis. This gave rise to powerful regional parties like the TDP in Andhra Pradesh or the DMK in Tamil Nadu. Their core identity is linguistic pride.
The notes mention the Official Languages Act of 1963 and the resistance to Hindi.
Yes. The act made Hindi the official language, but due to intense anti-Hindi agitation in the South, specifically Tamil Nadu and West Bengal, it allowed English to continue as an associate official language. This compromise saved the Union in many ways.
This is why we have the three-language formula in education, right? Hindi, English, and a local language.
Theoretically, yes, but it is not implemented everywhere, particularly in places like Tamil Nadu, where the resistance to Hindi imposition is a key political stance. Language isn't just a way to talk. In India, it's a political identity.
And finally, caste. The politicization of caste is something every Indian observer knows all too well. But all these factors, religion, language, caste, they pose a challenge to national integration, don't they?
They do. This is the central tension of Indian democracy: unity and diversity. Communalism, or the prioritization of one's religious community over the nation, has roots going back to the British divide and rule policies, like the separate electorates in 1909 and 1919.
So how does modern India combat this?
By building specific institutions, for example, the National Integration Council, or the NIC.
What's that?
It was constituted in 1961 by Prime Minister Nehru. It was later reconstituted in 1990 by VP Singh with 101 members. It brings together the PM, ministers, chief ministers, and party leaders to discuss communal harmony and discrimination.
Do they actually meet?
They do, though perhaps not as often as some would like. They met in 2011 and 2013 to pass resolutions condemning violence and promoting brotherhood. It's a forum to air grievances before they turn into riots.
And there is also the National Foundation for Communal Harmony.
Set up in 1992 under the Ministry of Home Affairs. It's an autonomous body. What I like about this one is that it specifically supports children affected by communal violence. It shows that the state recognizes the fragility of social cohesion and tries to create mechanisms to repair it.
So what does this all mean? We've traveled a long, long way in this deep dive.
We really have. We started with the exam perspective of the machinery, the whole hierarchy of the ECI, the observers watching every move.
Right.
We navigated the legal jungle of the RP Acts of 1950 and 1951. We looked at the technological shifts like VVP and the legal reforms that criminalized false affidavits.
And we ended with the sociology, the human reasons why we pull that lever or press that button.
The aha moment for me, is realizing that this system is a living, breathing entity. It isn't some dusty book. It evolves. The 91st Amendment closed that defection loophole. The 2013 Supreme Court judgments cleaned up the candidate lists. The system reacts to its own failures and tries to improve itself.
That is a hopeful way to look at it. It's a machine that is constantly trying to upgrade its own software.
Exactly. It's messy, it's loud, but it is, at its core, self-correcting.
Before we sign off, I want to leave you, our listener, with a thought. We talked about NOTA, the none of the above option. We know that right now it's a neutral vote. It doesn't reject the winner. But imagine if it did. Imagine a future amendment where if NOTA gets the majority, the election is canceled, and all those candidates are disqualified from running again in the repoll.
That is a provocative question. Is NOTA a toothless tiger, or is it a sleeping giant just waiting for the right law to wake it up?
Something to mull over. Thank you for joining us on this deep dive into the massive machinery of India elections.
It was a pleasure. Keep questioning, keep learning.
See you next time. So we have a country that has successfully navigated the Cold War, developed a sophisticated nuclear doctrine, and is actively building trade corridors across Central and East Asia. The external face looks strong, It looks ambitious.
It does. It projects power and a sense of stability.
But now we have to turn the mirror around. Because while all this was happening, India decided to do something very brave
Yeah.
and, frankly, a bit risky. They decided to audit themselves.
They did. And moving ahead, let us understand this next important point. From an examination perspective, this point is significant.
I'll say. This is the National Commission to Review the Working of the Constitution, the NCRWC.
Exactly. Set up in the year 2000, and its chairperson was M.N. Venkatakalia, a former Chief Justice of India.
A pretty heavy hitter.
Oh, absolutely. And it's really important to clarify the mandate here. They were not asked to rewrite the Constitution.
So it wasn't a let's start over kind of thing.
No, not at all. It was more like a 50,000-mile checkup for a car,
Yeah.
you know? The mandate was to examine how the Constitution had worked for the last 50 years.
A health check for Indian democracy.
That's the perfect way to put it. A 50-year report card.
And the results? Well, they're a mixed bag, to put it mildly. Let's start with the good news. The successes column.
Well, there were some undeniable massive successes. I think the biggest one, the one you have to start with, is just democracy itself.
The fact that it survives.
The fact that it survived and thrived. I mean, look, you're in a region where coups, military dictatorships, and political instability were pretty common.
All around them, really.
All around. And yet, India maintained a parliamentary democracy. The transfer of power after elections was, by and large, peaceful. That is not a small achievement. It's foundational.
And the documents say they even deepened it over time, right, with the 73rd and 74th Amendments.
Oh, that was a huge step, a
Yeah.
really huge step. These amendments gave constitutional status to Panchayati Raj institutions.
So village councils, local government.
Exactly. Power was decentralized, pushed down to the grassroots level. It empowered, millions of local representatives, many for the very first time. It was a massive expansion of the democratic project.
Okay, so politically, the system held.
Yeah.
What about economically? Because in 1950, India was, well, incredibly poor.
It was. And the numbers in the report, when you compare them to the starting point, are just staggering. Let's just talk about food.
Right. The Green Revolution.
The Green Revolution figures are just mind-boggling. Wheat production. In 1960, it was around 11 million tons.
There.
By 2000, it was 75.6 million tons.
Wow. That's a seven-fold increase.
A massive jump. And rice went from 35 million tons to almost 90 million.
That's the difference between famine and food security for a billion people.
It is exactly that. And then
Right.
you look at the sort of the modern economy, the IT sector.
The thing India became famous for in the 90s.
Right. The report notes that IT revenue went from just $150 million in 1990 to $4 billion by 1999.
In less than a decade.
In less than a decade. That's the engine of that external face we were just talking about. That's the economic muscle starting to be built.
Okay, and then socially. The human development side of things. Life expectancy is usually a pretty good metric.
And it's probably the most dramatic statistic in the whole report. It literally doubled.
Doubled.
In 1950, the average Indian could expect to live to be about 32.
32.
It's hard to even imagine. But by 2000, that number was 63.
Incredible. And the report singles out one state in particular, doesn't it?
It does. It highlights Kerala. And it makes this stunning comparison. It notes that a baby born in Kerala at that time had a better chance of survival and a longer life expectancy than a baby born to certain demographics in Washington, D.C.
In the capital of the United States.
In the capital of the United States, it's a real mic drop statistic on the power of public health and education investment.
Okay, so democracy is strong. People are eating. They're living longer. A new economy is booming. It sounds pretty good.
It does.
But, and this is a huge but, isn't it? This is where the Jekyll and Hyde part comes in. The report didn't stop there. It laid out the failures. And that word, sobering, it doesn't even begin to cover.
No, it doesn't. They are more than sobering. They are deeply alarming. The commission identified something called political decay.
And the phrase that just jumps off the page is criminalization of politics. What exactly does that mean?
It means exactly what it sounds like. It refers to the growing influence of money power and, frankly, muscle power in the electoral process.
So candidates with criminal records?
Candidates with criminal records not only running, but being actively fielded by major political parties and winning. And then you had the instability problem.
Right, you mentioned this before. 6 elections in 10 years.
Between 1989 and 1999, India had 6 general elections. It's chaos, it's incredibly expensive, it's destabilizing.
And it prevents any kind of long-term planning.
How can you plan? The report contrasts this with the first 40 years of independence, where you had, I think, only 4 prime ministers. That stability allowed for vision. This later period, the report says, led to opportunistic politics and coalitions built on personal gain, not national development.
And speaking of national development, the economic disparity numbers are, well, they're hard to read.
This is that classic two Indias story, the India shining versus the India suffering. The report is blunt. It states that 85% of the national income was held by a tiny, wealthy elite.
85%.
Meanwhile, 260 million people were living below the poverty line.
A quarter of the population.
A quarter of the population in abject poverty, completely bypassed by that IT boom we just celebrated.
And that poverty has a very real physical cost. The thing that really caught me off guard in the report was the data on malnutrition.
It's the statistic that stops you in your tracks. 53% of all children under the age of 5 were malnourished.
Over half.
Over half. And the Commission goes out of its way to provide context. It explicitly notes that this rate was double the rate of sub-Saharan Africa at the time.
Double.
Yeah.
That really puts that whole global superpower ambition into perspective, doesn't it?
It absolutely does.
You can have nuclear submarines, you can have treaties, you can chair international committees, but if half your children are malnourished, what does that strength even mean?
That is precisely the question the Commission was forcing the nation to confront. And it wasn't just children. They also highlighted what they called the disappearance of women.
You're talking about the sex ratio.
The sex ratio.
Yeah.
At the time, it was 933 women for every 1,000 men.
Which is not natural.
It's biologically backwards. In most healthy societies, women actually outnumber men slightly. A ratio of 933 is a statistical scream. It points to systemic neglect, to female feticide, to poor healthcare access for women from birth to death.
And if you're a citizen, a man or a woman, and you want to fight for your rights or just get a dispute settled,
good luck with that.
The justice system.
Clogged. Completely and utterly clogged. The report found there were 30 million cases pending in Indian courts.
30 million.
30 million. The report's own words are damning. It calls the justice system slow, expensive, and inaccessible for the average citizen. Justice delayed is justice denied, and for millions, it was denied for decades.
Okay, so
yeah,
we had this very clear, very stark diagnosis. High blood pressure, blocked arteries, but maybe a strong heart still beating somewhere in there.
Oh.
What was the prescription? What did the NCRWC actually recommend?
They made 249 specific recommendations. So, we can't go through all of them, but we can hit the big ones. A huge focus was on strengthening fundamental rights.
Making them more robust.
Exactly. For instance, freedom of the press. It's currently implied in the right to free speech, but they said, no, let's make it explicit. Let's write freedom of the press directly into Article 19.
Leave no room for doubt.
None. They also proposed entirely new fundamental rights.
Like what?
The right to privacy, for one, which is, hugely relevant today.
Right.
Also, a right to rural employment.
Oh, that's interesting.
Yeah, they recommended guaranteeing at least 80 days of work for rural households.
That sounds like the direct intellectual precursor to the MG and RGA scheme, the big rural employment program that came a few years later.
It absolutely was. The seeds were planted right here in this report. They also pushed for a right to free and compulsory education up to age 14.
Which also became law later on.
It did. But the Commission wanted to go further. They suggested making it compulsory up to age 18 for girls and for children from marginalized communities, the scheduled castes and scheduled tribes.
So, using rights as a tool for equity.
Precisely. They also added a right to compensation if you're illegally detained by the state, a real check on state power.
Now, there was also a very specific and, I imagine, sensitive nuance regarding religion in the report.
Yes, this was really interesting. It has to do with Article 25, the freedom of religion. For certain legal purposes, the Constitution groups Sikhs, Jains, and Buddhists under the broader legal definition of Hindu.
Right, it's a sort of legal catch-all.
It is, and the Commission said, that doesn't fully respect the unique and distinct identities of these faiths. They recommended that for the purposes of that article, they should be treated as separate and distinct communities. It was about recognizing the pluralism of India, not just socially, but constitutionally.
That's a subtle but profound point.
Yeah.
Okay, what about the political side? How do you fix that decay, that criminalization they talked about.
Well, they had some pretty direct suggestions. First, they said anyone who is formally charged with a serious crime, we're talking heinous offenses, should be disqualified from contesting elections.
So not even convicted yet, just charged.
Just charged. The idea was to clean up the candidate pool from the very beginning. They also recommended automatic disqualification for defectors.
So politicians who get elected on one party's ticket and then switch to another, often for inducements.
Let's call it what it is, for cash or a ministerial post. The commission said if you do that, you lose your seat, period.
And there was a recommendation about the Rajya Sabha, the upper house, that caught my eye, about residency.
Yes, this was a big one. They recommended that a candidate for the Rajya Sabha, which is the Council of States, must actually be a resident of the state they are claiming to represent.
Seems like common sense, doesn't it?
You would think so, but it had become common for political parties to parachute in candidates who had no connection to a state just to get them into parliament. The commission argued that this practice completely undermines the federal character of the House. If you live in Mumbai, how can you truly represent the interests of the people of Assam?
Right. It erodes the whole purpose of a council of states.
Exactly.
And they also touched on duties, didn't they? We always talk about our rights, but duties are the other side of that citizenship coin.
They are. And the commission felt they were being neglected. They made a powerful suggestion. Make voting a fundamental duty.
A duty. That's a right.
A constitutional duty. And paying your taxes. The idea was to shift the psychology of citizenship from just what can the state do for me to what are my obligations to the republic.
That would be a radical shift. And then there was one more pretty controversial one under the directive principles.
Population control.
Population control.
Yes. They recommended adding a directive for the state to promote population control measures. They clearly saw the demographic explosion at the time as a fundamental hurdle to economic development and providing services.
So if we bring this all together now, we've got these two very different pictures of the same country at the same time. On one hand, you have the external face.
Yes. The Act East policy, the nuclear doctrine, the push for a seat at the UN high table.
Confident, ambitious.
And on the other, you have this internal reality, as diagnosed by the NCRWC.
A reality of judicial backlog, widespread malnutrition, social inequity, and a political system showing signs of serious decay.
What's the connection between the two? How do they affect each other? I think the connection is that the internal reality acts as a fundamental drag on the external ambition. It's like an anchor. You can't project yourself as a true pole in a multipolar world, a leader of the global south, if your own internal institutions are creaking and failing large segments of your population.
Your foreign policy is only as strong as your domestic foundation.
That's it. That's the whole point. The NCRWC report was essentially a warning flare sent up by the system itself. It was saying, fix the machine or this car won't win any race.
It's fascinating because when you and I or anyone listening reads about India rising in the news, we almost always see the foreign policy wins, the G20 summit, a new trade deal.
The shiny objects.
Exactly. But this internal audit is the bedrock. It's the part that determines if any of that other stuff is sustainable.
Precisely. That regulation of relations with the outside world we talked about at the start. It requires a regulation of rights and duties on the inside. You can't have one without the other. Not for long, anyway.
So, for you, the listener, trying to make sense of all this, what's the big takeaway?
I think it's that when you analyze any country, not just India, but any nation, you have to look at both the handshake and the heartbeat. The handshake at the diplomatic table might be firm and confident, but you have to ask, is the heart healthy? Are the internal organs functioning?
And here's the final thought to leave you with, to kind of chew on. This report, this incredibly detailed, honest, and sometimes brutal audit from the NCRWC, is over 2 decades old now.
It was released in 2002, a whole generation ago.
So the provocative question is this. If we ran the exact same audit today, if we took the same metrics and applied them to the India of the 2020s, would that success column be longer? Or, and this is the unsettling part, would we see the exact same bullet points under failures, the criminalization of politics, the judicial delays, the social inequities, just with more recent dates next to them?
That is the question, isn't it? Has the needle really moved, or have we just been watching the calendar pages turn?
Something to mull over. We'll be back with another deep dive soon. Keep learning.